There were a couple of questions that were raised yesterday that we said would come back to you. So if it's helpful, we'd start with that this morning, and then we'll move on to Mr. Fisher in terms of the legal submission. So the first question that was asked during my opening statement was the split of greenfield versus brownfield numbers expected. So in terms of the reasonably expected to be realised numbers from the development capacity assessment for brownfield, it's estimated at 19,000 dwellings. And then that leaves 11,000 dwellings to be delivered through greenfield development. That's, for example, projects such as Tauranga West and Keenan Road. The second question was from Commissioner Knott in terms of understanding what a typical cross-section of Cameron Road looks like. This is in relation to Mr. Musk's opening statement in terms of the noise provisions proposed. So we've tabled with you a map which provides an example. This is a pretty typical cross-section showing the shared paths, also cycle dedicated and the dedicated bus lanes proposed, and you would have seen under construction along Cameron Road corridor in terms of stage 1. There was also a follow-up question with Mr. Musk in terms of the difference between a designation and the property boundaries. So in terms of our look at that Kiwi Rail or railway designation, generally it does follow the property boundary, but there are locations where it doesn't. And also there are some locations where it may be the designation boundary may be with a road or, not necessarily a residential property boundary. And that's why if that alert layer is to be applied, our view is that it should be from the designation boundary rather than from property boundaries or measured from that designation boundary.
So there are instances where the designation boundary is within the property or overlaps the property boundary, just to be clear.
Yeah, there are examples where it overlaps property boundaries. In terms of the evidence presented by Mr. Appledorn for transportation, you requested table 7.4. That has been provided to you this morning with a cover memo from Mr. Appledorn explaining the numbers. If you'd like a complete report, I'm happy to send you the entire report, but probably best through email since it's quite a large document.
Yeah, and it's a classic example of be careful what you wish for. Yes, right, thank you.
And then the last question or item that we wanted to bring up and discuss with you this morning was in terms of the qualifying matters and the presentation and opening statement from Ms. Vaja in terms of the coastal environment protection area, plan area, and whether it would assist the panel just for us to run through that this morning to clarify when a consent is triggered and what that consent activity is. So if you're happy for us to do that this morning, we can run through that. So I'll just share my screen.
Do you want to do that now or do you want to wait after Mr. Fisher? I don't know what his time frame is.
I've checked with Mr. Fisher this morning and he is available and has been given leave to be a bit late to Environment Court this morning.
Okay, all right, thank you. And just because I spent the small hours reading the 142 pages last night, I have a question which you might want to think about as well, which is the extent to which applying the rules, whatever the rules are, the extent to which it's in scope, because as I read it, and correct me if I'm wrong, because it was quite late. It only applies to Pole 3 in effect, because as I understand it, it doesn't affect the MDRS. in which case it can only apply within walkable catchments from the various centres and zones and so on, which is what Pole 3 defines. And yet when you look at the maps, it seems absolutely extensive. And I'm just wondering about the locational extent of the rule. And we may need to get, in due course, an overlay of the walkable catchments on top of or underneath what is proposed, so we can actually demarcate the rules. Now, I might have that completely wrong, which is fine, but that's my understanding as I got to the end of the text. And just to confirm, I'm assuming that the line of coastal environment is the regional council's determined coastal environment line, is it? We're not talking about a different boundary.
Morena, I can answer that. Yep. So the coastal environment line that's been drawn has been, it's in the landscape assessment on the methodology that has been undertaken, but it is consistent with the regional policy statement and the coastal environment plan area.
Not quite the question I was asking. So, is it the same line or is it a different line?
It's the same line, more or less.
The same.
Yeah.
Okay.
So, just to give a little bit of context on this line, though, the SEPA has been proposed to give effect to the NZCPS. So, policy 13 of the NZCPS specifically says you must avoid, mitigate, remedy effects on the coastal environment, and then it talks about the natural character. So everything from this line that you can see out to the coast is the coastal environment as it's been identified in the RPS. So can we make this bigger? Sorry. So if we're just looking at the map and how these proposed heights are would work, is we've got the grey area, which is the 9 meters permitted height with the 2 meters permitted intrusions, and that's only up there. So if a development was to go above the 9 meters, then there would be a restricted discretionary space, but it's only relating to that height. Where you can see these sort of sorry.
Can we be clear? Because I want to understand whether it qualifies the MDRS or not. So if this is a residential zone, presumably that we're looking at here.
Yes.
So are you saying that in actual fact it does qualify the MDRS?
Yes. So these are so this has only been applied in the relevant residential zones. So what used to be our suburban residential zone and commercial, etc. So basically what's now our medium residential zone and our high density residential zones. So within the medium residential zone, and I can actually bring this down here because that's probably easier to see. You can see this sort of beige kind of color, and that's the MDRS. So that's the 11 meters height plus the 1 meter permitted intrusion. That's permitted there. Anything above that will kick a development into a restricted discretionary space, where they will have to consider the relevant matters of discretion. And then you've got the high density, which is the sort of orangey color. And this is where we were talking about potential transitional heights. So probably a good example is down here, where within the city centre, you can go up to 27 meters, but because it's within that coastal environment plan area, that will be, I think, 16 meters there. And anything above that 16 meters will require a restricted discretionary resource consent. So once you're in a resource consent space, a landscape assessment is required, and the matters of discretion consider the effects on the outstanding natural features, which is in the water, and the natural character as well of the coastal environment.
I'm not sure that I'm still 100% clear, sorry. Could we go back to that first plan where you had the 3 colours, you had all of the... So the grey area would otherwise be MDRS.
That's correct.
But it's been restricted in height as a result of this.
Yes, so only in height, not... So someone could propose to build 3 dwellings on there.
Yes.
It's only the height that's restricted, yeah.
Sorry, Janine, yeah.
Sorry, can I just, what we talked about yesterday, so the absolute, in terms of the architectural testing that we've undertaken, the absolute height of the MDRS versus our suburban residential rules are the same. The key difference is our permitted intrusions are, for that additional 2 metres, are more restrictive in that it is really providing for roof design and chimneys and things like that. So it's the bulk, while the absolute height is not what is different, it's the bulk of those, that extra 2 metres, that really limits it in comparison to what the medium density residential standards enable, if that makes sense. So we've always had that 9 metres plus the permitted intrusions, which is that same height, but the bulk of those additional 2 metres is reduced in those grey areas. So just to give you an example, and Mr. Budden can, on Thursday, if necessary, can go through in a little bit more detail, but the assessment has been based on each area, so each area has been assessed. So it's not a matter of, oh, the first row of houses has been restricted and then we'll have a stepped approach from there. Each area individually has been evaluated and assessed given its geographic location, and also the topography. You know, we've got some, especially along the city centre, where we've got quite significant escarpments and cliffs, and so those are obviously quite different to where we'll take you around the Beretta area, which is extremely low lying. So yeah, there's other areas such as the one you can see on the screen where you've got the conservation zone, which provides that quite significant setback. So in that location that you can see, the MDRS is enabled with no limitations. If you are to exceed that height, you're going to be in a consent process anyway because you've exceeded height. It's a restricted discretionary activity. We're recommending that it remains restricted discretionary. However, there are additional matters to be considered, which are set out in those matters of discretion in Chapter 6.
So that was going to be my next thing. I think you've clarified that. So if again, we go back to that first plan, that the outer strip is a QM, but the next strip is not a QM, but it does trigger further matters of discretion.
Correct.
Yeah. That's
correct. And then when you've got the high density in some limited locations, such as that along the Cameron Road corridor, city centre area, where you have policy 3 applying, that is also a qualifying matter where we have limited that additional height. Again, a restricted discretionary activity if you're to exceed the heights shown within Section 7 of the planning maps.
Sorry, just whilst he's typing there, just go back to the maths, because as I understood from what you were saying, the operative is 9 plus 2, but the MDRS is 11 plus 1, so those numbers are not the same.
we're more than happy to provide you the architectural testing that was undertaken to compare the heights between the two.
Yeah. And I guess the other thing that became very apparent as I was reading the text last night is that this is not about natural values at all. This isn't 6A. This is entirely 6B. It's entirely on the ONL and ONFs. Because I think I'm right in that, because the subclassifications for the 6A stuff are not affected by height and density, obviously. You know, water issues, land coverage, terrestrial biota systems, abiotic systems, and landform are not affected by a meter of height. So my read through that is that we're really talking about Section 6B issues with respect to the ONF and the ONLs.
I can ask Mr. Button to respond to this question. Would you prefer that in writing or verbally on Thursday?
Well, it doesn't really worry me how we get it back through. That, as I was saying, that's my take at the moment. I mean, if that take is wrong, that's fine. We'll
ask him to respond. Yep.
But certainly reading through, I mean, the majority values that seem to be at stake in terms of what we're talking about are arguably the aesthetic values. Question mark over legibility. I don't quite know about that. None of the other values seem to me to be in play in terms of simply a meter of height, if you like. And that's what I'm trying to focus on is the merit of putting a rule on 1 meter of height. It just seems to me it needs. Well, if we're going to do that, we need to be absolutely certain that it's necessary, because that's the requirement of legislation to the extent necessary. And I haven't seen yet that argued. So let me just alert you to that. But that's good. Anything else, Richard?
So on the next bit is when you just step in further and you hit those high densities, so it only becomes a QM in those areas where they're within walkable catchments. Yeah,
that's correct. Yes.
So eventually we'll need those defined, because in the text they're not narrowly circumscribed by, as far as I could see, the diagrams in the appendix A. They're much broader scale than the 800 metres that I think council is using as a walkable catchment option.
We can try and get you some numbers, if that helps, or maps.
Again, I mean, Mr. Button may simply be able to indicate through a couple of graphs that actually that isn't the case, and so that's fine.
Those are all the matters that we had to follow up with you this morning. So if you're comfortable, we'll move on to Mr. Fisher in terms of his legal submission.
Just to close off that last discussion, the reason for the coastal boundary itself, is that an RL that's been determined, a particular level or something, or is it a distance in, or how's that actually been determined?
So multiple landscape assessments have been undertaken over the years. Boffa did some for the regional council, and this new landscape assessment is consistent with that. But each area, like Ms. Beattie was saying, has specific values. So some areas have higher natural character, more important or more significant ONFLs. And based on that, the landscape assessments have identified where that boundary needs to be. But I can ask Mr. Button to
well, it's reason. I mean, if it's a regional council boundary, it would be good to get an understanding as to how that's been set. Just need to be absolutely clear that the boundary is the same as the regional council's boundary. That's all. If we're going to apply a rule to it, if in actual fact it's varying, then we might need to understand what the variance is and the reason for the variance.
As far as I'm aware, it is consistent, but regional council is speaking tomorrow on this, so we can ask them to
All
provide
right,
some
well,
information.
perhaps if you just alert that we want that answer, because they may not be
Yes.
the right people to answer that
Yeah,
question.
I will. Thank you.
Thank you very much. Right. And now for something completely different, Mr. Fisher.
Yes, thank you, sir. Good morning to the chair and the panel. And first of all, my apologies for not being there in person. As I think you've heard, I ended up being double booked in the Environment Court in Hamilton, so I've had to do this remotely, although it wouldn't have been my first choice. So thank you for accommodating that. Now, does the panel have a copy of the submissions that I've filed?
Yeah, you certainly do, and
Thank
they're
you.
open before us. Yeah.
Great, thank you. So I'll just work through those submissions in the normal way. If you want me to speed up or slow down or have any questions as I go through these, feel free to interject, and we can get it right. So in the introduction, I've just explained that the statutory overview was covered in the Session 1 submissions, and the scope issues were covered also in those submissions, along with some reply submissions that were filed after the conclusion of the Session 1 hearing. So I'm not intending to repeat any of those matters. I'm just relying on the previous submissions. These submissions really just address three fairly discrete issues that I've been asked to address by Ms. Speedy. I don't have full visibility over the detail of the entire plan change. Really, at this point, I'm just addressing these issues, and if any further issues arise throughout the hearing or the panel has any questions, I'm more than happy to address those issues and reply. The questions can be either fed to me through Ms. Speedy or a direction from the panel. Either way, I'm happy to produce further reply submissions to cover off any other legal issues that arise. So in paragraph 2 of my submissions, I've set out the three issues that I'm addressing. One of them is the Waikanai decision, which has, of course, been debated up and down the country. The next one is Plan Change 27 and the relevance of that. There are some submitters who have raised issues there, and this panel is, of course, very familiar with that plan change, having made the decision on it. And then finally, a smaller point about the meaning of adjacent in the context of Policy 3D. So I'll just work through those issues. First of all, starting with Waikanai. At paragraph 4, Waikanai is the first time the Amendment Act has been substantively considered by the courts. The decision of the Environment Court is subject to an appeal to the High Court. However, the appeal is not scheduled to be heard until 13 February 2024, with the High Court's decision likely to be reserved until sometime after that. So it's unclear whether we're going to have any further guidance on this issue from the High Court by the time you come to make your recommendations. At paragraph 5, the Council's overall approach to Waikanai is to abide by the Environment Court's decision unless or until it is overturned by the High Court. These submissions are therefore not intended to revisit the merits of the Environment Court's decision. Rather, they comment on the potential implications of applying the decision in the context of the Tauranga City Council and IPI. In paragraph 6 there, I set up some of the facts in Waikanai. It involved a decision of the Environment Court on a preliminary question of law relating to an application for direct referral. The Kapiti District Council proposed to include a new Waihi Tapu qualifying matter in its IPI. The consequences of this were that the new Waihi Tapu site would become subject to additional objectives, policies and rules over and above those normally applying in the underlying zone. In particular, some activities that were previously permitted became restricted, discretionary or non-complying. It was common ground that the effect of the new Waihi Tapu qualifying matter was that the NDRS would not apply to the scheduled area. So it's basically an overlay type approach, which you'll be familiar with. The issue for the court was whether the inclusion of the new Waihi Tapu qualifying matter in the IPI went beyond the council's powers. And I've set out in paragraph 7 there, the key paragraph in the court's decision. I won't read that out, but I will perhaps pause there for a minute. I suspect it's already been read more than a few times, but I will pause to let you read that through for a minute.
Thank you.
Yeah, it is sort of, in some ways it does refer to the facts of the particular decision, the reasoning there, but I'll get to that a bit later. But a broad interpretation might be that taking away development rights under the operative plan conflicts with the purpose of the Amendment Act, would be perhaps a broad way of paraphrasing that. The court found it to be ultra vires for the IPI to disenable or remove permitted activity rights under the operative plan. The court found this to be contrary to the statutory purpose of imposing on residential zone land more permissive standards as set out in the MDRS, and to go well beyond just making the MDRS and relevant building height or density requirements less enabling as contemplated by section 77I, which is of course the provision that enables qualifying matters. However, the broad application of Waikanae beyond its particular facts is not entirely clear. In particular, it's unclear whether the Waikanae decision supports the general principle that an IPI is constrained by and cannot be more stringent than the operative district plan. To put it another way, whether the decision means that an IPI may be less enabling of development than the MDRS and the relevant building height and density requirements, but not less enabling than the operative plan, which could be treated as a bottom line which cannot be taken away by an IPI. Have been tried to be
sorry, I just have a few questions around Waikanae. So in some of the submissions for other parties, they have said that obviously Waikanae does not bind us, but is or isn't persuasive. Do you agree with that position? That we're not bound to follow Waikanae?
Yeah, I mean, I was thinking a bit about that one last night again, and I know it's come up before. The idea that a decision is binding, as I understand it, comes from the doctrine of precedent, which says that basically that lower courts are bound by the decisions of higher courts. So looking at the Environment Court is bound by the High Court Court's bound by the Court of Appeal, and the Court of Appeal is bound by the Supreme Court. That's the doctrine of precedent. So strictly speaking, no, I don't think it's an Environment Court decision is binding in that sense on you, because you're not a court. Is probably the answer, but I think the very orthodox approach would be to treat an Environment Court decision as highly persuasive, and of providing a good level of guidance. So you might say you might be very slow to disagree with it, as one way of looking at it.
Thank you. And I mean, obviously you're aware that the panel in Kapiti Coast took a different view, based in part, I think, on some advice that your firm provided. And I just was wondering whether you've had a chance to read that Kapiti Coast decision, and whether or not you agree with the reasoning in that decision, and whether it's a decision that we should take notice of.
Yeah, I have briefly read it some time ago. I haven't, as I've said, this council's approach is to abide by the Environment Court's decision and respect it as far as it can. So it's not seeking to take a different approach. In terms of what the relevance of that decision is to you, again, it's not. It's not strictly applicable. You might take interest in it and consider the reasoning of it, but it doesn't have any status beyond that.
And another question, which I'm not sure is for you or it might be for one of the planners, is just in terms of when we're looking at that decision and considering whether or not we take notice of the way that they've applied things, is whether or not the provisions of the Kapiti Coast District Plan are similar to the Tauranga District Plan in terms of some of the relief sought. So, for example, Ryman and retirement villages have relied heavily on that decision because they have, according to their submissions, received favourable decision on this, the approach they're seeking. And so I guess there's been scope issues raised here in terms of some of the relief they're being sought. So I guess I'm wanting to understand if there is I guess, similar provisions, in which case we should give more weight to that KCDC provision or decision, or if they're different provisions, in which case that could be distinguishable just on the basis of those provisions. Don't expect you to answer that right now, but yeah, just I'm interested in that issue and whether that's a planning issue or whether it's a legal. Happy for someone to come back to me on that one.
Yeah, thank you. I couldn't answer that, so we'll have to leave that for the planners. Otherwise, look into it at a later date.
Thank you.
So I was at paragraph 9, and I did get to the end of that, and I have tried to put that issue quite fairly, because I am aware of these different interpretations up and down the country, and I'll get to where the council actually landed on it a bit later. So in paragraph 10, there are relatively few matters in PC 33 that this issue could potentially impact upon. We understand that one of the more contested situations relates to the activity status for buildings or structures in the high voltage transmission plan area, subzone A. The Section 32 evaluation report identifies the national grid as a proposed new qualifying matter under Section 77I, B and E. The notified version of PC 33 proposed to amend Table 10B.1 to make the activity status for the alteration, construction, erection, and or placement of any building or structure in the high voltage transmission plan area a non-complying activity. So it's going from RDA in the operative plan to non-complying. That's what was notified. Transpower supported the notified approach, and Tauranga order lodged submissions seeking to revert back to the operative restricted discretionary status. And just in terms of the sequence of this, the Waikanae decision was issued after notification of PC 33, but before completion of the Section 42A report for Session 2. The Section 42A report notes uncertainty about how the Waikanae decision applies. However, because the proposed activity status will be less enabling than the operative district plan, the reporting planner recommends to retain the operative restricted discretionary status in subzone A of the high voltage transmission plan area.
I just had a question in relation to that. So obviously your advice is that it's not clear whether or not Waikanae captures a change in activity status to make things more difficult. Is that fair? Or there's a room for arguing that point?
Yeah, that's right. I mean, the facts are different because in Waikanae it was taking away a permitted activity right, whereas in this case we're going from, you're considering going to a more restrictive activity status. So there is a factual distinction there. I see the way it was put in the Tauranga order submissions that this situation is a logical extension of Waikanae, and that might be a fair way of putting it. And I do get to that point a bit later on, where I'm a bit more provide more detail on the logic for that extension, if that's how we're going to look at this.
With that, and this again might be a question for the planners, I wasn't clear whether the restricted discretionary applied across all of the relevant, applied across in the operative district plan, applied across all zones, or whether it was just when PC 33 was notified, the non-complying just applied to the MDRS zones. And I was wondering if there's a difference there in terms of scope. So if there's a need to revert to a restricted discretionary, would it only be for the zones that are outside the scope of PC 33?
Yeah.
I can answer that.
Thank you.
It only relates to the relevant residential zones, so it's quite a defined area,
Right.
Which we can actually drive down on a site visit, so you can get to see the location of where that rule applies.
Thank you, that would be helpful.
Thank you for that. At paragraph 14, to be clear, the reporting planner agrees that the national grid is a qualifying matter and that the MDRS and the relevant building height or density requirements under policy 3 should be less enabling of development to accommodate that. The council notified non-compliant activity status, and the reporting planner has not resolved from the planning merits of that. Rather, the reporting planner's concerns are with the vires of the notified approach in light of the Waikanae decision. So really, the council is motivated here only to ensure that its ultimate decision is lawful. That's really what this is all about from the council's perspective. The reporting planner's approach is questioned in the evidence of Ms. Ainsley McLeod on behalf of Transpower. She proposes a refinement to the notified wording so that non-compliant activity status applies only to the medium density residential zone and the high density residential zone, as opposed to applying across the city, which is the point that Ms. Speedy just touched on. Ms. McLeod goes on to address the planning implications of the approach in the Section 42A report, while noting that the issue will be addressed further in Transpower's legal submissions. And of course, we now have those submissions, which I have read, and they raise similar distinguishing features to those raised by Ms. McLeod. And I've listed those points of distinction that are raised in paragraph 16 there. Perhaps I'll give the panel a minute just to read those points of distinction that have been raised.
Yep. All right. Thank you, Mr. Fisher.
So down at paragraph 17 is perhaps where it sort of gets to the nub of it. And those distinguishing factors that have been raised are acknowledged. There are distinguishing features here, but that's always the case. Of course, you never get two factual circumstances that are always exactly the same. However, it's not clear how material those distinctions are to the outcome that was reached by the Environment Court. An important aspect of the Waikanae decision is that it's premised on a comparison between the developer's rights under the operative plan and the IPI, rather than a comparison between the MDRS and the IPI. By adopting the operative plan as a point of comparison, Waikanae decision may suggest that an IPI cannot be less enabling than the operative plan, whether it proposes a removal of permitted activity rights or a more stringent activity status for consented activities, e.g. from restricted discretionary to non-compliant, which we're dealing with here. If the operative plan is treated as a bottom line, both approaches could be described as affecting rights under the operative district plan, and the difference between the two is mainly a matter of degree. So that's the logical extension how Kāinga Ora phrased it. So that's the approach that has been taken by council staff and consultants in preparing the Section 42A report. However, the council remains open to considering the legal submissions from other parties and any directions from the IHP on these matters.
Thank you. I just have a question, and again, I think it's to the planners rather than to you, Mr. Fisher. And just on a practical level, the matters that would be of interest to Transpower in any application, and this fairly well defined. And I'm just wondering why the matters of discretion can't be so constructed that in actual fact there's no effective difference in terms of the matters to be considered. So then this becomes an academic question.
It is to some extent, in that through the matters of discretion you need to get a written approval from Transpower. So it does question whether there's much of a difference between that non-complying and restricted discretionary when you need to get that written approval.
I mean, that's where I guess where I'm sitting at the moment as I'm listening to this. The matter can be easily covered off in terms of the matters of discretion, such that if there's an issue, it can be dealt with. So, but anyway, all right, back to you, Mr. Fisher. Thank you.
Thank you, sir. So that does take me to the end of the piece on Waikanae, and I'll move on to Plan Change 27 now. There are a number of submissions which address the proposed PC 33 approach of treating flooding from intense rainfall as a qualifying matter, with the provisions of PC 27 applying to make the NBRS and the relevant building height or density requirements under Policy 3 less enabling of development. The relevant submissions generally seek that the provisions of PC 27 do not apply as a qualifying matter, with less enabling provisions being confined to areas that are mapped in the operative city plan as subject to natural hazards. The stated reason, and I have footnoted there some of those relevant submissions for you if you want to go and read those for yourself. At paragraph 20, the stated reasons for seeking this relief include that it's inappropriate for non-statutory mapping which sits outside the district plan and is not subject to the RMA Schedule 1 process to be used for the purpose of determining a qualifying matter, and PC 27 is subject to appeals in the Environment Court and may be amended. And I suspect those the first of those arguments will sound fairly familiar to this panel, similar things having been raised through the hearing process for Plan Change 27. In this next section, I provide an update on the status of Plan Change 27. And some of this will be familiar to the panel and some of it will be new, I suspect. At paragraph 21, Plan Change 27 was publicly notified in November 2020. It was decided by an independent hearing panel in March 2022, as you're well aware, of course, and the council's decision was released in April 2022. 3 appeals were received from Aotearoa Park Developments Limited, Blue Haven Management Limited, and Urban Task Force for Tauranga Incorporated. A number of Section 274 notices were also received, both in support of and in opposition to the council's decision. Turning to PC 33, it was publicly notified on 20 August 2022, and the PC 27 appeal process has proceeded in parallel to PC 33. Court-assisted mediation on Plan Change 27 took place in Tauranga on 11-12 October 2022, which is of course a while ago now, and the parties agreed to a number of action points which have been completed insofar as they are the responsibility of the council. These matters include an expert modelling session and joint statement, and the premise of this was that there were questions about the accuracy of the maps and the modelling approach and so on, and the idea was to hold a session with experts for the appellants and the council's experts to provide as much information and give as much comfort as the council was able as to the accuracy of its maps and the robustness of its modelling processes. There was some subsequent sensitivity testing of modelling undertaken, a rainfall data update report, preparation of a practice note, and an updated schedule for modelling updates, which are now both on the council website, and discussions about specific properties and discussions about resource consent processes and the content of LIM reports for the Wairakei urban growth area. Excuse me. So those are all things that have been achieved through that process. And this next paragraph is the last touch point on the file. So on 11 September 2023, legal representatives for the council and the appellants attended a judicial teleconference with Chief Environment Judge Kirkpatrick, who directed that the appellants are to file and serve a memorandum by 31 October 2023, setting out the specific amendments they're seeking, which we have not seen yet, and the appellants and the respondents are to file a joint memorandum by 10 November 2023 that sets out a further proposal for how to progress the appeals. So we're getting to the pointy end here of defining outstanding issues and deciding whether we're going to proceed to an Environment Court hearing on those appeals.
Just a question on that. So in terms of your 23A, are the amendments that are sought, are they the agreed amendments? And then the B is talking about the things that are outstanding. Is that right?
No,
so there are some agreements.
There are no agreed amendments because the notices, the notices of the appeal didn't specify amendments in any detail. So and specific amendments have never been provided and didn't really feature in the mediations. So that's why we've had this extra step of the court directing that they are to be provided so that we can see exactly what outstanding issues remain.
Okay, so there haven't been any resolution of issues through the mediation process such that there's going to be consent orders or anything? The whole thing's basically still up for grabs and in terms of the appeals
Yes,
and
that's
likely
correct.
to proceed to hearing? Yeah.
That's correct.
Thank you.
From paragraph 24 onwards, I set out the plan change 27 approach. Perhaps in light of your background on it, I'll take that as read, or would you like me to go through it?
I'm quite happy for you to take that as read. Yes, thank you.
Okay. Perhaps I'll pick up at paragraph 26 then, which talks about the flood hazard mapping information. It's contained within the council's publicly searchable GIS system, MAPI. MAPI includes a flooding from rainfall layer, which maps the 1% AEP, the year 2130 climate, and RCP 8.5 median scenario, which corresponds with the parameters specified in the various definitions for flood hazard areas as I've set out previously. Because they sit outside the city plan, the GIS hazard maps do not directly trigger requirements for resource consent. Rather, requirements for resource consent are triggered by activities being proposed in areas which satisfy the parameters specified in the definitions. Although the GIS maps do not have legal force, they may be used by applicants and the council to inform an assessment against the definitions in the city plan. However, they are not necessarily determinative of consent requirements in any particular case, and applicants may undertake their own mapping using the parameters in the definitions. So that's one of the points of disagreement through the appeal process. And just to note, it's a similar approach to that adopted in the Unitary Plan, which Judge Kirkpatrick noted in the joint telephone conference. So turning now to the PC 33 approach. Under section 77G, specified territorial authorities have a duty to incorporate the MDRS and give effect to policy 3. Under subsection 6, a specified territorial authority may make the requirements set out in the MDRS or policy 3 less enabling of development than provided for in that schedule or by policy 3, if authorised to do so under section 77I. Qualifying matters are set out in section 77I and include matters of national importance under section 6, which in turn includes management of significant risks from natural hazards. Section 77J includes matters that must be addressed in the section 32 report in addition to the matters set out in section 32. In section 77K sets out an alternative process for existing qualifying matters. For the purposes of the PC 33 evaluation report, flooding from intense rainfall was evaluated under section 77J rather than as an existing qualifying matter under section 77K. And that's because flooding from intense rainfall is addressed in section 8D of the proposed plan change, which is not yet operative. So it didn't meet the definition for existing qualifying matter. Section 8D operates like an overlay to make the PC 33 provisions less enabling of development than required by the MDRS or policy 3. Section 8D would apply in a similar way to the city plan chapters for existing qualifying matters, e.g. Outstanding natural features and landscapes or areas of significant indigenous vegetation. I think paragraph 33 is being covered previously. In paragraph 34, in my submission, the approach in the IPI, which relies on plan change 27 to accommodate flood hazard as a qualifying matter, is consistent with the purposes of the Amendment Act. The limits plan change 27 would place on development have been properly evaluated in the context of the IPI as required by section 77J. And this next section gets to the nub of the issue that's been raised about using non-statutory mapping. And it's a similar type of issue to what was raised through the PC 27 hearing, but of course now we've got a different statutory framework, which we need to consider the issue in light of. The issue of whether PC 27 can define flood hazard areas using definitions specifying key parameters rather than maps is a subject of appeals to the Environment Court. These submissions are therefore confined to the issue of whether the Amendment Act requires flood hazard areas to be delineated on the planning maps. Section 77I allows application of qualifying matters to an area within a residential zone. Similarly, section 77J3A requires demonstration of why that area is subject to a qualifying matter. Subsection 5 provides that the requirements set out in subsection 3A apply only in the area for which the territorial authority is proposing to make an allowance for a qualifying matter. So there's a consistent reference there to the area. Although section 77K does not apply to Plan Change 27 because it is not yet operative, section 77K requires a specified territorial authority to identify by location, for example by mapping, where an existing qualifying matter applies. And then the subsequent paragraphs refer back to those areas again. And then finally, paragraph 38, the definition of qualifying matter area means an area in respect of which the specified territorial authority has proposed, in accordance with section 77I, that a qualifying matter apply. So the issue of whether qualifying matters need to be delineated on maps therefore turns on the meaning of the word area. The meaning of legislation must be ascertained from its text and in light of its purpose and context, and that of course is the Legislation Act 2019. Starting with the text, the Short Oxford Dictionary defines area to mean a particular extent of ground or another surface. Plain meaning of the word therefore does not necessarily require delineation using lines on a map. Turning to context, this meaning is supported by section 77K, subsection 1A, which uses mapping only as an example of how existing qualifying matters could be identified by location. While that section is not directly applicable, locations identified by mapping or implicitly by some other means are referred to as areas in the context of that provision. This provides helpful context which suggests that the word area is not intended to be confined to areas defined on planning maps in my submission. In terms of purpose, the qualifying matter regime is intended to recognise that the NDRS and Policy 3 development is not appropriate in some places and allow plan provisions which are less enabling of development than the NDRS and Policy 3 to the extent necessary to accommodate the qualifying matter. In my submission, this purpose is equally achievable whether qualifying matter areas are defined by lines on a planning map or by words and definitions.
Just have a question in relation to that. I guess what I understand you to be saying is that as long as it's clearly made clear where it applies, whether that's through words or through a line on a map or through noting various property boundaries, as long as it's clear, that's enough. Is that what your submission is? As long as the plan user can figure out whether or not the particular property or the particular area they're interested in falls within the qualifying matter area, then that's enough. It doesn't have to be a line on a plan.
Yeah, that's right. There's the normal principles of certainty, which are that rules must be objectively ascertainable to be lawful. So we've got that normal orthodox test, which we say can be met by specifying key parameters. And then we're saying there's nothing in the context of this new legislation, this Amendment Act, which overrides that or precludes that approach. That would be one way of looking at it.
And in your view, is it clear on its face, if we're applying these definitions, that the sort of the reasonable person on the street would know whether or not it applies, or would they need to get an expert assessment to see whether or not they come within the definition?
I mean, applying the parameters like a 1% flood event and RCP 8.5 scenario are quite technical things, and I imagine they would need expert assistance with that, but that doesn't necessarily make the rule uncertain or invalid, because it is still objectively ascertainable whether you're in the rule or not. You just need you might just need a expert assistance to determine that.
So by sort of using that method rather than mapping, it is imposing a cost potentially on someone who's wanting to find out whether or not they're within or without.
Potentially, they have the option of accepting the council's mapping, which would be the perhaps you know, for a lot of submitters the default position, and if in looking at that there's questions that arise and they want to do their own mapping, then yes, there would be a cost to that.
And just and again, this might not be a question for you, it might be for the planners, but are there any other qualifying matters that aren't mapped that use this approach of definitions, or is this the only one?
This is the only qualifying matter that is not mapped within the district plan. Yeah, and it's one of the only new matters in terms of, because it's still running through a appeal process. Just one other thing to note in terms of the reasonable expectation of a resident understanding whether they're affected or not, and the cost associated with that. So those maps are, we have 19 models, and then those are mapped and publicly available. In terms of if a resident does not agree with those, at council cost, we review that with an independent engineer. So we take on a significant amount, we take on that cost if a resident doesn't necessarily agree with the information in front of them, and that undertakes site visits. So it might be an example where a retaining wall has been built where a review is required, and that's the whole purpose of having those planning maps, well, those GIS maps outside the plan, so they can respond to very site-specific changes that may change the location, the depth, or the extent of that flooding.
Thank you, that's helpful.
Mr. Fisher, I mean, I guess I was listening for where you're making the connection with the non-statutory maps, because obviously the definitions and the non-statutory maps in actual fact do form a bundle. They may not be the complete bundle, but they do form a bundle. Or are you suggesting that in actual fact a rule devoid of any mapping whatsoever, statutory or non-statutory, would be sufficient? The definitions themselves would be sufficient as on their own?
Yes, yeah, they are sufficiently certain to be sufficient on their own, but implementation is assisted by the non-statutory maps.
Thank you.
Okay, and just to wrap that one up, for the reasons above, we submit that it is permissible under the Amendment Act to provide for flooding from intense rainfall as a qualifying matter with less enabling provisions without delineating the flood hazard areas on the planning maps. I now get to the third issue, which is a smaller issue, and I'll work through that. It's about the meaning of adjacent in the context of policy 3D. Mr. Sweet, in submission 217, opposes the establishment of a high density residential zone around Bayfair. He submits that Bayfair should not be he submits that Bayfair should be a neighbourhood centre zone, which might support high density residential zoning in accordance with policy 3D only within the centre and immediately adjacent to it. Policy 3D requires that district plans enable building heights and density of urban form commensurate with the level of commercial activities and community services within and adjacent to neighbourhood centre zones, local centre zones, and town centre zones or equivalent. And I've just looked into the meaning of the word adjacent because it is fairly crucial in the context of that policy. And I set out in paragraph 45 a case where the meaning of adjacent was considered, and I'll let you read through that. It starts off by saying what adjacent does not does not mean adjoining or contiguous. And then it says near to, in the vicinity of, or neighbourhood of. And then it says that its application can vary with the circumstances and the context. And that decision was cited in a more recent case, which again I've set out and says similar kinds of things. Perhaps importantly, the noting towards the end there that the degree of proximity required was held to be entirely a matter of circumstance. So it's not a word of precision. In paragraph 47, the word adjacent in policy 3D should not be read down to mean immediately adjacent, adjoining, abutting, contiguous or similar. Rather, it connotes proximity without being precise about the degree of proximity. In the context of policy 3D, the word adjacent leaves decision makers with latitude to decide the extent of areas around the identified centres which are suitable for increased building heights and density of urban form. This could vary from centre to centre. In some circumstances, the direct degree of proximity could be equivalent to the walkable catchment referred to in policy 3C. So those are the three issues I've been asked to address, and I'm happy to answer any further questions.
Thank you, Mr. Fisher. Here we go.
Yes, I just have a few more, and they don't relate to the three issues that you've covered. So if they are things that you need to come back on, that's fine, but I thought I'd just put them out there. One is the meaning of commensurate, and Kāinga Ora says that what is commensurate must include a forward-looking component. Do you agree with their interpretation? So what's commensurate isn't determined by what's on the ground now or what's zoned now or what's developed now, but that you must look out for the full sort of 30 years in terms of determining what is commensurate.
Yeah, I can't see any reason to disagree with that. I mean, it is a forward planning exercise that we're engaged with. We're engaged in, so that context would suggest that meaning. I don't take any issue with that.
Thank you. Kāinga Ora also makes some submissions about papakainga, and they set out a number of reasons why they say that papakainga should have been expressly provided for in this plan change. And it seems to me they're sort of getting to the point where they're saying actually those other requirements mean that there's a de facto obligation on the council to include provisions. Do you have a view on whether or not there is that sort of de facto obligation, that whether or not papakainga should have been considered and should have been included?
Yeah, so just going back belts and braces, so we've got to incorporate the NDRS and give effect to policy 3 with any related provisions support or are consequential on. Yeah, I'm not entirely clear how papakainga would fit into that. I can't.
So obviously there's a discretion, it's expressed in a discretionary way that it may include provisions in relation to papakainga in the legislation. But Kāinga Ora's argument is that if you look more broadly at the other RMA requirements, then you should have, or the council should have included papakainga within the plan change. So I guess I'm just interested, and if you need to refresh yourself on that and come back, that's fine in terms of those arguments.
Yeah, I'm not sure how they're getting from a discretionary power to a mandatory one. I don't quite understand the logic there. So perhaps I would have to look a bit closer at what exactly they've said in their submissions and consider it against the Act. But I can't immediately see.
Yeah, so they don't say it's mandatory, but they make the argument that all these other obligations really mean that it should have been included. And then the final question I had was in relation to the submissions from Mr. Barry Brown. And he's obviously seeking to separate out the Mount North and wanting the council to seek a further extension from the minister. And I guess my question really is, do we have an ability to, as a panel, to make a recommendation that Mount North should be treated differently, and we're not going to issue a decision on that, and that the council should seek an extension? And secondly, what are the grounds for seeking an extension? Obviously, that's something the council does, not us. So I think Mr. Brown talks about allowing time for the completion of the Mount Arataki spatial plan, but I'm not sure whether or not that would suffice as a ground. So I'm just interested in your view on that.
Yeah, I mean, whether or not there's an extension is a power wielded by the minister ultimately, and not something I would expect the panel to get involved in. Is my initial thinking. Sorry, what was the other part to the question?
Yeah, so if we were minded to accept Mr. Brown's argument that Mount North should be separated out and shouldn't progress until, say, the spatial plan had been completed, do we have the ability to issue our recommendations saying that we don't think that PC33 should progress for Mount North until the spatial plan has been completed, for example?
Yeah, I mean, just off the cuff, it seems like there's tension with the statutory imperatives to incorporate the MDRS and give effect to Policy 3, and that accepting that relief that he's requesting would be contrary to those imperatives.
Thank you. That's my questions.
Fraser? No. The only matter that's in my mind, Mr. Fisher, is the question of if the High Court does issue its decision on Waikanae, say between the period that we furnish our recommendation and before the council makes a decision, and that perhaps takes Waikanae in a different direction, if that's feasible or credible. Does it have any process implications for us? I mean, would we then be able to, or even required then, to readdress our recommendation in light of that decision? Or is your advice, as I read it from your submissions here, that really that's of very little bearing on what we're dealing with?
No, I think you should apply the law as it stands at the time you're making your recommendations. So if we do have a High Court decision which comes out in that period where you're working on your recommendations, we'll be looking to get a memo to you ASAP, bringing that to your attention so that it can be factored into your recommendation.
Yeah, no, I certainly would anticipate that. It was, the question was, if we in actual fact have made our recommendations and it still sits with council because it hasn't made its decision, is there then the opportunity for council then to say, panel, reconsider in light of, or are we functus officio effectively at that point?
Yeah, you will be functus officio, I think. But there may be an opportunity for the council to take it into account through its decision-making process.
Obviously, I'm thinking of that because there are some parties that want to broaden scope in terms of where council currently sits on the issue of scope. Yeah.
Okay.
All right. Well,
if that occurs and it results in the council effectively rejecting a recommendation of the panel because it's got this different legal ruling in front of it, then of course it's the minister who will make the final decision on that issue.
Sorry, just one more question. Do you know whether or not the KCDC IPI decision has been appealed?
No, I don't. There's no. No, I haven't heard. Sorry. No.
Okay, thank you.
All right, thank you, Mr. Fisher. You can go back and talk to the court.
Thank you very much, and have a great day, everybody. Goodbye.
We'll take somebody before we take a break. So, who do you want us to? We're going to do with Peters, or
So we'll be moving on to policy
I think so.
3. So we have a presentation to share, and I'll just invite our experts who may be assisting in terms of responding to questions through Ms. Peters' opening.
Kia ora koutou. I'm Ashley Peters. I'm planner for Tauranga City Council. If I could just invite my team of experts, Mr. Heath, Mr. Luca as well, if you'd like to join, and Mr. Kimmings. Yeah, just here as well. Is Mr. McKilder here? He can join us after morning tea anyway. So my role with Plan Change 33 has been addressing Council's approach to giving effect to Policy 3. I'm also a lead author for the bulk of the residential zone provisions, so I'll leave those for later. Towards the end of the day, I'll come back to the other part of my opening statement. So just in terms of the experts that I've got here with me, I've got Mr. Heath, who will be dealing with commercial centres, so economic expert. Next is Mr. Kimmings, so he's dealing with feasibility of development, and Mr. Luca in terms of urban design and spatial planning expertise. And if there's any questions around kind of population prediction modelling, I believe Mr. Mead can assist with some of those questions if we need be. So just in terms of what I'll step through this morning, I'll briefly touch on the MPSUD requirements for the context of Tauranga, some work we've done on centre classifications, adjacent and walkable catchments, how spatial planning has influenced our approach, and the use of height maps, which are introduced as Appendix 14Q. So firstly, just recapping that Council has a duty under Section 77G and 77N of the RMA to incorporate the MDRS and give effect to Policy 3 in the relevant residential zones and urban non-residential zones. So this requires significant change to the established conceptions of plan making. So it's a move away from that kind of locally led or community input into some of these planning decisions. And in my opinion, the introduction of the MDRS in itself sets some of the context for how we should implement Policy 3. So it's effectively establishing the new kind of acceptable development rights for the bulk of the urban area. So specifically in terms of Policy 3, so clauses, it's got 4 clauses. So Clause A, B and C, they're very prescriptive. So they're, I guess, easier to implement, and they're prescriptive because the supporting evidence for the MPSUD demonstrates kind of those areas have the greatest benefits of enabling significant change to their urban environment. And then moving on to Policy 3D, which is what I'll probably focus on a bit later. 3D is more descriptive, so it provides council with some discretion about how it implements those changes, but we need to be clear that council must implement those changes where commensurate height and density is required. So yeah, each council has kind of the ability to take a slightly different approach, but that change must be enabled. A key function of Clause D is supporting the centres-based approach of the MPSUD. And so that has required us to look closely at our commercial centres. And yeah, currently Tauranga, our commercial hierarchy or lack of a well-developed commercial hierarchy means we've had to do some specific work in that area. So in my opinion, the requirements of Policy 3 should not be seen as a maximum target, but nor should they enable development at all costs. So we've considered a balanced approach to how we enable opportunities for change in locations and at a scale that are necessary, but also appropriate to give effect to the broader MPSUD objectives and policies. So with that in mind, I think yesterday we touched on the fact that the IPI is giving effect to Policy 3, that when it is giving effect to Policy 3, it's considering those changes within the context of the broader policies. So in my mind, a key one is Policy 2 around providing, requiring council to provide at least sufficient development capacity into the long term. So that's looking at our housing shortfall out to 30 years and how the IPI can assist in addressing some of those issues. Obviously, again, it's important to recognise that this, for example, meeting Policy 2, it will require council to enable significant change to the urban environment, how it's currently established. And the MPSUD, again, as we've discussed, that it is a forward-focused policy statement, so it is looking ahead into the long term and beyond. So the changes we're making today, they're considering how future communities will be able to make use of some of those changes to the environment. Again, as Ms. Beattie discussed yesterday, Plan Change 33 is just one of many planning decisions, so it's not the be-all and end-all of meeting our development capacity requirements, but it will go a significant way to enabling and being responsive to some of those challenges that council faces. So in the next 15-20 minutes or so, I'll step through council's approach to how we've given effect to Policy 3. And I've got some slides and maps and stuff that will also assist. So just moving on to para 3.12 of my opening statement, in terms of looking at equivalent centres that are required by the National Policy Statement. So it talks about town centres, local centres, neighbourhood centres. The city plan doesn't have those zones as required by the National Planning Standard, so we haven't given effect to that yet, and we're not required to at this time. And so we proposed a planning methodology to kind of consider what was going on in those centres, what was established, what was the context around those centres, and how they best fitted within the equivalent zoning and the National Planning Standards. So that was set out in the Section 32 evaluation. And just to be clear, with Plan Change 33, we've never proposed to rezone any of those commercial centres. Some of that is to do with the constraints of the IPI around whether we can actually construct a comprehensive commercial and land use framework, commercial and industrial land use framework to really address that kind of hierarchy issue. And so we've been quite clear, and it's recorded in the joint witness statement for the approach to Policy 3, that we don't propose to undertake any rezoning through this process. So moving on in response to submissions about the centre classifications. So we received a range of submissions that were opposing either the centre classifications or the level of height enabled around some of those centres, and whether or not that was actually appropriate for the range of activities in those centres. Particular opposition was received from the Otumotai and Mount Maunganui areas. And so to look closer at some of the issues that were raised, Council engaged Mr. Tim Heath, and he'll provide a presentation following this to assess those centres in greater detail. So he undertook this in 2 stages, first looking at what was currently happening within those centres, and then stage 2 looking at kind of future forecasts for change, and that's responding to the NPSUD's direction of being forward-looking and considering how those centres may change or develop over time. And Mr. Heath also considered kind of the extent of some of those centres, because the current commercial zoning can be quite broad, and it can incorporate, say, some areas that have more of a light industry kind of function, but still within the broader commercial zone at the moment. So that also influenced the later stage, where we looked at how we should measure walkable catchments from some of those centres. So in terms of the outcomes of Mr. Heath's work and what that means for the IPI, there were 2 centres in particular that were notified with additional height and density within and around those centres, so that being Excelsior and Golden Sands and Pies Park. So they were notified as local centres and provided additional height and density up to 16 metres. And so Mr. Heath has looked closer at those centres, and he's considered they don't meet the appropriate kind of scale, or they don't have forecast change that would warrant them being considered local centres. And on that regard, I've then recommended they are removed from the opportunities to have additional height and density at this stage. And so that will address a number of submitters' concerns, but still open for discussion with other experts as well. And the other key issue is Mount Maunganui Centre, which again we'll address in greater detail on Thursday. So Mr. Heath will also be available on Thursday to discuss questions on the Mount Maunganui Centre, but effectively Mr. Heath considered or confirmed that Mount Maunganui Centre is a town centre, and as it would have a suitable range of services going into the future to support residential intensification in that area. So in that regard, I've recommended some additional upzoning within and around that centre, but also important to note, to accompany that change, a range of qualifying matters have been considered and implemented, which may constrain some of that development opportunity there. In terms of the commercial centres assessment, we undertook expert conferencing twice, 2 different stages. So there remains some disagreement with experts on the zone classifications for the Sands out in Wairaki, Tauranga Crossing, Gate Pa, Excelsior, as I mentioned, and Mount Maunganui Centre. Although a lot of the disagreement doesn't actually revolve around the height or the extent of, say, the high density around some of those centres. And that's obviously reflected in the JWS, if you'd like to canvass that a bit further. So moving on to walkable catchments, I've just provided a map there that kind of shows a broad spatial application of how the walkable catchments sit across the city. So the high density zone in Plan Change 33 is based on accessibility or proximity to centres by using walkable catchments. And it also brings in proximity to the planned high frequency transit along the Cameron Road corridor, which I see you've got some additional kind of cross sections to give you some context there. So in determining the catchments, we've relied on Council's network of footpaths, and then we've adjusted the boundaries of the high density zone by making a few judgment calls around, well, either is there some topography, or do people need to access through industrial areas, or are they having to cross a state highway, and that doesn't actually support good accessibility, but also it may kind of lead to some poor urban form outcomes if it's quite disjointed in that regard. So in terms of policy 3D, and I think Mr. Fisher touched on this a little bit earlier, it doesn't prescribe specific methods or metrics to determine extent of intensification for those lower order centres. So again, council has discretion to how it determines that. And again, I'd like to highlight that nothing in the Amendment Act limits council to that narrower interpretation of adjacent. And I would argue that taking a narrow kind of view of that would limit our ability to meet the broader objectives of the MPSUD, particularly that sufficient development capacity requirement. I also understand that walkable catchments are generally well accepted in other IPIs and by experts around, planning experts around the country, and generally consistent with the method that's set out within the MFE guidance. I'm reasonably confident that the walkable catchments are the correct way to determine where intensification should be progressed. So in terms of notification, Plan Change 33 proposed a 1,500 metre walkable catchment from the city centre zone. So relatively large, but it also considers the topography constraints of our city centre. Obviously, you're aware it's on a peninsula, so the catchment itself in terms of area is relatively small. And then we move down to town centre zones. We considered 800 metre catchment, local centre zones 400 metre catchment, and neighbourhood centre zones were not provided with additional high density areas. We also included an additional kind of strategic step, and the Amendment Act allows council to enable development kind of over and above those general walking catchments, and this applied in locations where we had a relevant spatial plan. So I'll discuss those a bit later on. So in response to submissions, we received a number that were concerned with, say, the extent of the high density, the reliability of using walkable catchments. And to respond to that, we produced some GIS modelling. So it's relatively straightforward. It relies on council's GIS data set. And we've had to make some kind of judgment calls about how that is measured by GIS. So we've taken either the furthest kind of extremity of those commercial centres, or where there's a very logical kind of restricted way to access that centre. So the kind of the southeastern corner, there's a on Girvan Road, there's a traffic lights where, you know, if you're a pedestrian crossing that road, you'd have to cross from there. So that's why that's measured from that point. And also this is obviously, excuse me, this is a raw data set. So this doesn't reflect how the zoning is then spatially applied. This is kind of what's informing where we put those boundaries. So for example, Bayfair is bordered by State Highway, Monganui Road. So to the southwest, we've excluded that from the high density zone, just in response to saying, well, it doesn't really provide good accessibility for people. They have to navigate a number of crossings to access that centre. And then also kind of at the fringes of the catchment, as notified, we were quite liberal in how we applied the high density zoning, and we kind of pushed out to physical barriers, roads, parks, wherever possible. And in response to kind of the matters raised by submissions, we refined that and took the more conservative route of actually pulling it in some places to support kind of a more coherent built form, but again kind of retaining.
Does it follow property boundaries?
So the GIS data set doesn't. So that's kind of it's kind of like a buffer area, but as we apply it to the zoning, it follows the property boundaries or road boundary. So that's kind of helping people understand the accessibility and the spatial application of those zones.
Just in terms of helping to assist how that's been done, just explain the carve-outs on the coast there that would seem to be evidently within 800, but are specifically carved out.
In terms of, in this data set, the little pockets. So that data set is picking up some kind of private right-of-ways probably in that instance, or like there's a beach access that's going out, and so the data set is picking up that kind of beach access down to the beach, but it's not really accessibility of kind of the zone overall. So we've tried to even out how we've applied that zoning to kind of follow road boundaries wherever possible. But
walking distance along streets and footpaths, so which is why you've got indents where actually the 800 meters stops just before the centre of that block, for instance, along.
So there's obviously overs and unders, and we don't want to create awkward lower points within that high density zoning. So it's obviously a judgment call to how that zoning works out in practice.
But the actual zoning map refines that further.
Yes. Yeah. So this is kind of the data set in behind. And so each of the centres has one of these, so you can look at that as well. So I'll just move on to how spatial planning is.
But just to be clear, these will be, if this moves forward, basically this is it. I mean, subject to any small amendments we might make, this is what's going to determine the heights and densities and so on and so forth.
Yeah, and in my opinion, we should rely on the catchments. Yeah. And in terms of the city plan?
Well, that's what I'm wondering. Yeah, I mean, just apropos of our discussion we've just been having on such matters. Are these inside or are they outside?
No, we haven't proposed to put them within the plan.
So, all right. I've got some questions.
But there's a zoning plan that will be in the plan, which springs from these.
Yeah.
It'd be really good to see these walking lines over the zoning plans to see how you've refined it. You know, just on one sort of a dotted line showing the walkable catchments.
Yep,
over the zoning would be really good, just to see how you've manipulated it to make it work.
Yep, I can get our GIS team to work on that. Yep, so
I did have another question in relation to the 1,500 metres for the city centre zone. I recall reading some reasoning for and you mentioned about topography constraints and being on a narrow peninsula. How does that impact on whether it's a walkable distance? I mean, if it's a narrow constraint, it's a narrow constraint.
Yeah, so the walkable catchment for the city centre zone was also influenced by spatial planning outcomes, so the Te Papa spatial plan and UFTI. And so that's where that directive came from in terms of improving accessibility within that catchment. And so they really wanted to support that 1,500 metre catchment as an accessible space. So it is greater than that kind of standard approach, but it's supported by a range of kind of spatial planning investments and actions.
So, I mean, I haven't read those documents, but what is it that's special about the city zone that means that people for walkability are walking twice the distance, say, for a town centre zone?
Yeah, so the city centre obviously is, and Mr. Heath can probably touch on this as well, has the most significant kind of employment, civic functions, and obviously people are more willing to commute further to those kind of key areas, and that's what's set out in some of the MFE guidance as well. So we've taken that on board and said, well, the city centre should be our kind of premier centre that people are willing to make an effort, whether that's walking or cycling, or you could use an e-scooter or what have you. And that spatial extent was appropriate to reinforce that kind of that premier position as a commercial centre for the city.
So it's not necessarily the topography that was, because it was narrow, you made it longer, it was other reasons.
Yeah, more so in regards to, because when I talk of a catchment, you kind of think, a circular catchment, but the spatial area of that isn't actually very large compared to if it was a 1,500 metre and like a radius, it would be, exceptionally large.
You haven't got the Cameron Road plot that you could put up. Demonstration of City Centre one.
I can grab it.
So we'll do that over morning tea.
Yeah, because as I understand it, what you're saying is you've determined 1,500 as appropriate for the city centre, but actually in effect, because of the shape and that it's peninsula, you don't actually get the real benefit of that. You only get it in one direction.
Yes,
is what you're saying. So
yeah.
the starting point is 1,500, and then you overlay that and see what it gives you. Yeah.
I can bring that up in the break. Sorry, so I'll move on to how spatial planning has also influenced council's approach to policy 3. So as notified, Plan Change 33 incorporated the endorsed Te Papa spatial plan, which, if I recall, was from about 2020, and also the draft Otamotai spatial plan. So that was in progress when we were working on Plan Change 33, and we notified Plan Change 33. So I just draw attention to Objective 6 of the NPSUD, and I've set that out in my opening statement. And in my opinion, it's really important that we take this opportunity to implement the direction of some of our spatial plans, because the NPSUD is seeking that council is more integrated, strategic and responsive in some of its decision making. And I would argue that the spatial plans that is their purpose, is to integrate kind of infrastructure, transport, public investment, and look at how that can support the community in well-functioning urban environments into that kind of 30, 50-year time period. So the Te Papa and the Otamotai spatial plan are implementing the broader sub-regional direction of the Urban Form and Transport Initiative. So I've included a little snip of that just in that slide there, so you can see the greyed out areas which were identified for kind of key intensification parts of the city. And you may also hear AFD kind of referred to as a connected centres program, so really focusing in on the transport and the accessibility between some of these key areas. And obviously Mr. Luca will kind of discuss the value of spatial planning for council and the community as well. So
the question there, in 336, you referred to the Otamotai plan being draft when the PC 33 was notified. And given the question we've had earlier on about the Mount North area, was there anything between the draft Otamotai spatial plan and the final document that would have changed any of the anything that's actually been incorporated into PC 33?
Yeah, that's a great question, and I'll step into that now. So in terms of response to submissions, so for Otamotai, we had a number of submitters who I understand were also participating within the consultation of the Otamotai spatial plan. And so we obviously took on board their concerns, and we've adjusted Plan Change 33, so in terms of the high density zones and the heights, to reflect the outcomes of what is now endorsed in the Otamotai spatial plan. So I've got a slide here that shows an example for Cherrywood. So we had a number of submissions relating to Cherrywood and the kind of broader Otamotai area. You can see on the left, that's the endorsed outcomes of the spatial plan. And you can see, for the example on the right, the red outlined areas are where we have removed the high density that was notified, and now we're recommending that we only retain the high density that was endorsed in the spatial plan.
When was the Otumoetai spatial plan finalised? Was that relatively recently?
Yes, I believe it's May of this year. Yeah. So while we were addressing submissions. Yeah.
All of that, those red blocks, they revert to
Medium
NDRS.
medium density. Yes. Yeah, that's correct. So obviously that's the same for the other centres there. And obviously in terms of the further submission process, you'll be aware a significant number of
So the reason that those blocks that are now being removed were actually included in the first instance, what's the difference between the rationale for that and where the spatial plan got to?
yeah, so in terms of
Is that doesn't look to me as though that's necessarily walkable catchment defined, but it might.
yeah, the scale is a little bit misleading, but it does reflect a 400 metre walkable catchment for the Cherrywood Centre. So in terms of the spatial plan, in terms of its draft form, it kind of went a bit further than your standard walkable catchment. So it kind of considered more, say, accessible streets, transport corridors, say down the Otumoetai Road corridor. And then in terms of how that process followed, and Mr. Luca can discuss that, it was considered that retaining just the walkable catchment was more appropriate for that centre, and the change projected or forecast for what's going on in that centre over the next 10, 20 years.
So I'm still slightly confused. So the red areas that have been removed were in there because they were previously considered to be walkable catchment?
No, so the
No.
spatial plan kind of it goes a bit further than just your standard walkable catchment. So they're considering things that are more broader. So they're saying, well, you know, you've got potentially accessible streets or more upgrades to bus infrastructure, and in that regard, it was considered suitable to kind of expand the high density around some of those centres. And again, so we've refined that through submissions, through considering submissions. We've said, actually, we're just going to stick with the 400 metre walkable catchment for that centre.
So, okay, so what the bit that isn't red now, the darker, higher density bit in the middle, that is all, that covers the whole of the walkable catchment. So you're not restricting it to being less than the walkable catchment now.
Yes, that's correct. It's consistent with.
But it was previously intention to go well beyond the walkable catchment,
further.
and that's shrunk back.
Yeah.
Okay.
Yeah. So the kind of broad premise of the spatial plans is to look at more opportunities for intensification. And yeah, the IPI is kind of considering, well, what is policy 3 asking us? Whereas the spatial plans are saying, well, what is policy 3 asking us, and also how can we achieve, you know, those more broader, well-functioning urban environment directives.
So was the red from an earlier version of the spatial plan? So okay. So there's an earlier version of the draft spatial plan which expanded, and then through consultation and whatever, it shrunk back to the walkable catchment.
Is it appropriate for me to chip in here? Ko Carl Luca ho. Yeah, look, I mean, I think what we're stepping through here is, I guess there's been an evolution and a working through the spatial plan process. So when Plan Change 33 began, and as they were working through their process and notified and receiving submissions, we were in a draft spatial plan period. We had also received feedback at that point in time. So we had, as a first draft from the spatial plan, had put out a broader walking catchment based both on, I guess, feedback from through, you know, that was coming through the Plan Change 33 process, but also the feedback we were receiving through the spatial plan process, and then working with our decision makers, we agreed to reduce that walking catchment, and that was appropriate. We also had the benefit of Mr. Tim Heath's analysis coming through at the same time in terms of the growth of that Cherrywood Centre and having a better understanding of the type of amenity and commercial amenity that provide in the future. So yeah, hence there was agreement and I guess a comfort level of reducing that walkable catchment down to match in with that centre and the provision in that area.
The actual zone, the neighbourhood centre, is it? What's the zone? I'm going to show you.
So it's commercial zone, but its classification would
But
be.
I mean, in terms of its translation, it's
Yeah,
translated.
a local.
So that is exactly where on this chart, is it?
If I use my. Can I use my cursor? Yeah, so it's right in on that corner intersection. Yeah, and again, there's that GIS catchment. So when I get the GIS team to kind of overlay them, that will probably be more helpful to understand for you. Yeah.
All right, good.
Just one more question. In terms of this, the 400 metres was the distance that was in the notified PC 33 in terms of local centre. That's what you got that correct? So why does this one? So what you notified, which is essentially what we've got on the right in terms of the outline.
In terms of the red outline is
Yes.
what we notified. Yes.
Was that within the 400 metres?
That was greater. So that was considering more opportunities. So in terms of broader accessibility, say via cycling or bus connectivity, but my preference is to revert back to just relying on that
400 metres.
400 metres and primarily the outcome of what the endorsed spatial plan was for that community.
So were there any other, for example, local centres where what was notified and what you're still proposing is greater than 400 metres? Or is this the only example?
A good example is Brookfield, which is to the south of Cherrywood. So that is classified as a local centre, but in terms of the Uramoto spatial plan outcomes and supporting kind of regeneration for that area and accessible streets program. And Mr. Luca can talk to this, but great opportunities for high density over and above a typical walkable catchment.
So the 400 metres was sort of given as a sort of an indicative distance. It wasn't necessarily the only thing that was taken into account in terms of defining these areas.
Yeah, so the spatial plan outcomes kind of function as more of a strategic lens. So we've kind of got the walkable catchment as a almost like a base case, but where we've got the greater benefit of a spatial plan, and my preference is to rely on those outcomes and those mapped or those assessed areas to support opportunities for greater height and density.
And can you just confirm the spatial plan is a 30-year plan?
Yes. So that's a Uramoto example. We also have an example from Te Papa, which is the other endorsed spatial plan. So again, you'll see here in terms of the notified version on the left was notified with the inclusion of the red outlined areas. But my preference is that we, in response to submissions, we amend the extent of that high density zone to align closer to the outcomes of the Te Papa spatial plan, and that's recognising it's a much more kind of in-depth consideration of those communities and what's going on in those areas. But Mr. Luca can obviously discuss further in his presentation of his evidence.
But am I correct in saying that when the plan was notified, the Cameron Road or the Cameron Road, for want of a better word, spatial plan was available? So why have you made the changes subsequent to notification?
Yes, that's a good question. So again, as I mentioned earlier, we kind of had, we notified, we kind of took walkable catchments as a base case, and then we kind of applied that strategic lens over top. So in some areas, you kind of had this compounding effect of having a walkable catchment and say the spatial plan, or you had the walkable catchment approach going further than some of those spatial planned areas. And in considering the outcomes of all of our development capacity work and submissions, my position is that the extent of the high density should rely, or the spatial plan should have greater weight in terms of the boundaries of those high density areas. And that's recognising the level of detail and assessment that's gone into those processes, and the partnership with a lot of other government agencies or community stakeholders.
Any cases of the updates taking it to less than 400 metres or whatever you would expect for that classification of centre?
Potentially. So an example in this instance would be, can you see my cursor on the screen? It's probably a little bit delayed, but right here in this intersection is the Greaton Town Centre. So it's quite an elongated centre, kind of comes right down throughout here. And if you were to take the walkable catchment from the extremities of that centre, again, when you see the GIS, it'll be a bit clearer. It does come right out to this kind of these red margins out here. So in that instance, refining the catchments to align closer to the spatial plans would technically remove some of those walkable areas. Again, in my opinion, I think the better outcome is really trying to focus some of those high density opportunities where they're aligning with the actions and the investment proposed within those spatial plans.
I can't actually remember where it says the walkable in the guidance where it says the walkable catchments have to be measured from. Doesn't it vary in different types of centre where you measure it from?
There's no directive. Obviously, if you measure it from the kind of fringe of those centres, it provides flexibility over time. Obviously, businesses and activities will move around, and for that centre to expand. But in terms of the Te Papa corridor and the fact that the Cameron Road is going to be, was planned for high frequency transit, I think concentrating the activity as near as possible kind of to that infrastructure is the better outcome. And that's why I think putting more weight on those spatial plan outcomes is important. So I'll just move on to height maps. So unless you wish to take a break or...
All right, let's come back at 15:15, shall we? I think we may have some things to talk about. Yeah. Ms. Peters, let's resume. Thank you. Just one thing, by the way, just before we do resume, I omitted yesterday when talking about the site visits that we're doing to mention that Ms. Speedy is going to act as our driver guide around the area. And let me just indicate that if anybody has any difficulties with that, if they could maybe contact through Sarah. Yeah, through the committee advisor to that if there's an issue with that. We'll be heading out probably about 3:30 this afternoon. So thank you. Peters.
And just before you move on to your next topic, just over the break, we were talking about the spatial plans. And while I know Mount is coming up separately, I just had two questions in relation to the Mount Arataki spatial plan. The first is whether or not the PC33 incorporated the material within the draft spatial plan, or whether that wasn't available at the time it was notified. And the second question is just looking at the Tauranga City website, that it says that the spatial plan will be released late this year. Is that still on track? And if so, how's that going to affect this process for us?
Yes, thank you. I can speak to the first question in terms of when we notified there was no draft Mount Arataki spatial plan. So it was starting to become it was being prepared. And in terms of the second question, Mr. Luca can speak to the timing of the Mount Arataki spatial plan.
Yes, so we're aiming for late this year, early next year. So February, March at the latest for endorsement of the spatial plan. I guess in terms of what that means, when I work through talking about the spatial planning, I'll give a broader overview of, the relationship between the two teams and how we've been working. I think hopefully that'll answer that question.
So now that there is a draft of the Mount Arataki spatial plan, have the PC33 provisions been aligned with that draft spatial plan outcomes?
In terms of the land use layer, we're very much, worked with and aligned with the Plan Change 33 team in terms of that layer of the spatial plan.
And that's the current position of council with respect to heights and so on and so forth, or the notified?
It's the current position.
And has it been out for consultation and submission, or has that not taken place yet?
The process, so we have undertaken 2 periods of engagement with the community and stakeholders. The first is a values engagement, so very much asking the community around those values they wish to protect and enhance within their community as growth occurs. And the second round of engagement is currently underway, beginning of September and ends on Sunday. The focus of that engagement again is very much focused around the actions that have been proposed to support the community now and support that envisaged growth. So really we take the land use layer as a given. What we are seeking feedback on is the actions that will support that growth over that 30+ year period.
And is there any more engagement anticipated, or is after Sunday it's heads down and writing of the draft?
Sunday will see the end of the engagement. In saying that, there will be some ongoing engagement with, say, key stakeholders, mana whenua and so forth.
Well, we would encourage you to actually get that complete before February, March, which is the deadline that we're looking for our decision or our recommendation to go forward. So, if there's to be decent cross-fertilisation, obviously we would encourage that to be earlier rather than later.
I think we can certainly look to work with our decision makers to ensure that the position is really clear in terms of what's being endorsed through that spatial plan within those timeframes.
And are there any others out there that we're not aware of?
No, not that I'm aware of either. And just in terms of question before the break around the catchment for the city centre, so I've just brought up, I'll try and bring up the map just so you can get some context, hopefully doing this right. So unfortunately the colours aren't super clear when you look at it in this kind of setting, but you'll see that the pink red dot here in the centre and this one up here, it's kind of the northern and the southern extent of the city centre zone, and then how that catchment it extends primarily to the south, and then it actually blends in with another centre and its catchment as well. So you can kind of see the compounding effect of the Te Papa Peninsula, and hence that's reflected in the spatial plan outcomes as well. So I'll just try and jump back into my presentation, if you bear with me. Okay, yeah, so this is where we left off. And so so the next part of my opening statement talks about height maps. So these were introduced to respond to the flat hierarchy or lack of hierarchy that Tauranga has. So the height map, it effectively excludes parts of the commercial zone that we deemed weren't relevant centres in the MPSUD. So there's an example in this slide, if I hopefully use my cursor again. This is near the commercials, the city centre zone. It is a commercial zone, but it is, you know, tyre shops, manufacturing. It's very light industry focused, and so in those instances where we've got commercial land that we don't think would be appropriate to support kind of residential intensification, and isn't in terms of making that assessment against the national planning standards, we don't think those areas should be included for greater height and density opportunities. That's also recognising that currently in the commercial zones, residential activities are permitted, so we kind of needed to balance that risk as well. And so the height maps themselves apply across the identified centres, so your town centres, local centres, and also their relevant catchments, including the broader kind of spatial plan catchments where they've been applied as well. So within the high density zone, we considered commensurate heights between 4 and 8 stories. So obviously that's we've taken a kind of a relative approach, recognising that the MDRS is kind of setting that acceptable baseline at 3 stories. So responding to the MPSU directive kind of requires us to do 4 or more stories in any of those other centres. So our position is that for neighbourhood centres, which are kind of those convenience centres, they shouldn't be afforded any greater permitted development rights. And for local centres, we're proposing 4 stories, so up to 16 metres, recognising there's a more of a moderate increase in those range of centres. And then for town centres, looking at up to 6 stories as your kind of permitted development rights. That's responding to the higher levels of activities and services, and also those town centres playing a supporting function in terms of transport hubs and the connected centres program of UFTI. And 8 stories was proposed for the local catchment of the city centre, and also the adjacent, the Cameron Road corridor, which again is responding to the planned high frequency transit along there. And we also need to be mindful, so in terms of the MPSUD and its approach to the city centre zone, it's seeking an unlimited height, and my colleague Ms. Rat will talk to that later today. But the height of the city centre is actually quite constrained in terms of how qualifying matters affect that city centre. So what you can kind of expect to establish is only around 12 to 14 stories because of the airport constraints. So we kind of need to be mindful that where we're considering greater height for those other centres, we don't want to then push out that the city centre in terms of losing its kind of competitive or its kind of premier position in that hierarchy. So that's something that I think is important to be mindful of.
For you, in terms of the table there, the difference between town and the transit/Cameron allows for 2 more stories with another 5 metres of height. Some of the diagrams I saw you on were indicating floor heights of around 3.5 metres. How is it that the extra 2 stories can be gained in 5 metres?
So we did some architectural testing, and that's kind of how we landed on those heights. My understanding is they kind of provide for flexibility in terms of some developers may want to, say, provide larger floor to ceiling heights for a more premier product, or they may need to address, say, flooding issues, raising their floor levels. So it's just kind of providing that flexibility. So it's not it's not kind of the minimum standard that you'd need to achieve.
No, but my question is, could you achieve 2 more stories with the 5 metre increase in height?
Mr. Heath is going to assist with that question.
Sorry, you're right in the question, but the additional stories are amortised out over the whole 27 metres. It's not just built to 20 and try and get squeeze 2 in.
Yeah. I guess my question is that the 27 metre height will accommodate 8 stories.
Yes. At a slightly reduced stud height relative to perhaps a 6-story 22 metre.
So instead of being 2.7 or 3, that it would come down.
That's correct. Yeah.
Okay. Thank you.
I think that's what the flexibility point was about.
And so in response to submissions on what we notified for Appendix 14Q, we had a range of positions put forward concerned with the scale of change across the city, seeking council taking more of a gradual approach to addressing kind of capacity issues, concerns with that built form being inappropriate in some parts of the city, or that intensification being inappropriate in itself. But also some concerns that if we take such a broad approach to, say, applying or enabling 6 to 8 stories, we actually lose some of the benefits of intensifying around either those key kind of transit corridors or the centres. And also potentially you end up with an urban form that just doesn't quite sit right into the long term. And Mr. Luca is going to talk about, I guess, the reasons for potentially having some more ability to manage how that urban form establishes over time. So a key submission in terms of building heights was from Tauranga Ora, and my understanding of their submission was that they sought that council enable, clarify, when we notified 6 stories, we used a metric of 21 metres, and Tauranga Ora sought that we use a metric of 22 metres, and I support that. I think it provides better opportunities to build a 6-story building. But their submission, my reading of it was that this approach should only apply to the areas we had identified being appropriate for 6 stories. So we didn't go any further than that at this time. My understanding now is they've actually, in the evidence that they've prepared, they're now seeking that we apply 6 stories for the entirety of the high density zone that's being proposed. And so I'm interested to kind of consider further the potential effects or the potential outcomes of that approach. But at this time, I haven't recommended any changes prior to the hearing. And again, in terms of the broader kind of submissions that we received, we kind of acknowledged that our development capacity forecasts were telling us that there's quite a small market demand for, say, 6 to 8-story buildings. And in my opinion, I think we need to be a bit more careful around where we permit that development to occur. And so in response to that, but while still balancing the need to provide sufficient feasible land to support meeting our development capacities, we've proposed taking a transitional approach in those larger catchments, so specifically the town centre catchments and the Te Papa catchment. So I can show an example of that here. Bayfair on the left, so town centre, and then part of the Te Papa peninsula on the right. So with Bayfair, and again earlier I had that GIS map. So the inner 400 metre of that catchment permitting 6 stories, and the outer 400 metres permitting 4 stories. So it's still zoned within that high density zone. So there's still the policy framework still supports greater intensification in height. But my intention is that it provides some control over kind of the compatibility of that built form design outcomes, and managing the risk of kind of isolated 6 or more story buildings at the kind of fringe of those catchments into the long term. And again, with Te Papa, really concentrating those 8 stories in the best locations near those transit corridors, stepping down towards the fringe of the high density to the east. So again, I recognise there's kind of a range of opinions on this approach. So I'm really keen to kind of hear from other experts and submitters throughout the hearing, and happy to kind of reconsider that if need be. Primarily interested in either urban form kind of outcomes and also potential kind of economic outcomes, which I think Mr. McIlrath has a few thoughts on as well.
Am I right that Kāinga Ora is now seeking 24.5 metres rather than just the 22 they originally sought in their submission? Is that right?
Yeah, so my understanding is they are now seeking within the centres themselves, and this appears to be regardless of the type of centre, so whether it's a smaller local centre or a town centre, they're now seeking 24.5 metres, whereas we had proposed, and at this stage we're still recommending that within the centre and its catchment would have the same height. But yeah, that's quite new information that we haven't kind of delved into at this stage. So happy to take any specific questions. Otherwise, we can move on to the experts and their evidence.
Question on the presumably, and I can't recall what the rule framework is, but if you wanted to increase your height in the outer 400 metres, it's just an RDA.
Yes, it remains restricted discretionary. Yes. Okay. Well, I'll pass on to Mr. Heath to work through his evidence on commercial centres.
Much point looking at your watch. It's 10:30 according to the program.
That's right. Thank you. To be honest, I don't have a summary to present or anything like that. My evidence is fairly straightforward, and that is from an economic perspective, density and intensification in and around centres is a positive thing, from creates economic benefits, etc. Outlined in my evidence. And the second component of it was really the classification of the centres and putting them into the NPS framework. And that's outlined in my evidence how I've done that and the justification for it. And I've got happy to undertake any questions really on that, because there's nothing too tricky in it.
Well, that's easy for you to say, obviously, but some of your submitters disagree with you on that. Do you want to rehearse your counter arguments for some of those ones?
Yeah, I'm happy just to skip through my rebuttal, which sort of outlines some of the key touchstones of the evidence that I've been asked to address. So in terms of Mr. Crossan, and he lays out that additional employment opportunities in the supermarket would be needed to meet the future density in the Mount Maunganui North area, but he's against an increase in height, which is required to really achieve the delivery of some of that density in commercial and supermarket, etc. So there's a bit of a push-me-pull-me approach there. But I do concur with him in relation to that the Mount Maunganui North Centre is a bit unique in that it has a very high tourist inflow and an entertainment destination as a centre. So it plays a broader and quite a different role and function relative to other centres in the network. So it does have a more specific focus on that, as a broader focus than just meeting the local market. And the fact is, and this traverses a few submitters, is that the Mount Maunganui, the MMN, let's call it, Mount Maunganui North Centre, is not a centre in isolation that has to meet all the demand of that future catchment. It works in combination with Bayfair, it works in combination with Teed Street and Owens Place, and they work almost as a unit to deliver goods and services and meet the retail requirement of that area and of the inflow. So it's not, I think Mr. Thompson makes reference to this in terms of the future requirement of the Mount Maunganui North Centre, and that is while the generation of that area is quite significant in hectares, one, there's going to be a bit of vertical delivery required to meet that, just from a physical point of view. And secondly, it's not Mount Maunganui North Centre by itself to meet that demand in the future. It's a broad range of centres. And this is in the context of a CBD that needs to recover. It's you can go out there now and have a look at it in terms of the vacancy stores. But what is pleasing to see is that there's cranes on the CBD, so some of the recovery is starting to occur. But it really does need help. It's got policy grunt behind it. They want to maintain it as the preeminent centre. So I think that context is really important to understanding the delivery of density across the centres and the role and function of each of those centres.
Just a question on that. You just mentioned before about how they work in concert with the Bayfair and Tweed Street, the supermarkets down there. What's the sort of distance from the Mount Maunganui North to those areas? Is it kilometres?
Yeah, it'll be probably a couple of kilometres without having an exact distance, but a couple of minutes drive.
Yeah.
So, been doing decades of assessment of supermarkets over the years, that the Mount Maunganui North whole area would form part of the catchments of those supermarkets, so of the New World and the Bayfair.
And you mentioned in 2.3 of your rebuttal that there's a new Foursquare store being consented. I just wondered, is it one of the bigger ones, or do we know what sort of, was it sort of more the full service Foursquare, or is it a little small Foursquare? Don't know.
Ashley can probably give you the exact extent. I understand it's slightly bigger than a stock standard one.
Thank you.
In terms of a full service supermarket there, in terms of the physical impacts of that, would that bring any sort of disadvantage in terms of, we know how big they get in the service yards and all those things that are associated with it and the amount of land they need? Would that actually potentially have a physical negative impact on that scale of centre in terms of the sort of fine grain that you're looking to achieve?
In Mount Maunganui?
Yeah.
Yeah, if it was located on the main street, yes, it would change the character, the urban form of the centre. The propensity for that to be delivered on the main street is very, very low. It would have to be on a site or grouping of sites, probably back behind the main street. But again, the chances of that occurring in reality are very, very low unless it's a vertical development. And we've seen that with Tweed Street. They require circa 1.5 hectares chunk of land to deliver a supermarket. So that's going to be very difficult to either find or pull together, given the costs of it.
At a more sort of strategic level, I mean, your evidence is squarely on the connected centres hierarchy model.
That's correct.
And a number of the other submitters, obviously, who have aspirations to be metropolitan centres or whatever they happen to be. Your general response on that is, I mean, in terms of the drivers, I guess the question is, should the plan drive the hierarchy, or the classification of the hierarchy, or should the economic aspirations of the particular developers drive that, and the classification then come in line behind what is seen to be a realistic future?
I suppose the point of this plan change is to deliver the implementation of the MDRS. It's not to rezone centres for based on their future aspirations or requirement. That's the next plan change. So sort of I've been bound within that thinking, and those future aspirations and classifications will play out in the next plan change. I've just tried to reflect their current position in the network to help define an appropriate walkable catchment and the delivery of some of that residential density in and around the centres.
Is there a further plan change planned to pick up those aspects? Sorry, that might be a question for Ms. Peters.
Yes, it's in our work program, and we have we're planning to take that to council kind of towards the end of the year to kind of start the next plan change.
I have identified some centres where I think a future upscaling of classification would be required, and Cherrywood's one, where it's there's a need for an additional supermarket investment in that broader Otamoto area. There's one in Beretta, one in Brookfield, and Cherrywood supermarket in the future would provide a more even distribution of that particular store type, and it's an appropriate location for density. So over time, if it got that supermarket provision, I think it's got the 4 square at the moment, I think that could be elevated to a local centre given the growth projections for those areas.
I guess I'm just toying with the 30-year time frame that we're having, and I accept the argument that council is not proposing to rezone or reclassify. But we obviously submitters will be coming before us over the next week who are saying you should do that because it's within your remit to do that. But are you quite comfortable with it not being done through this process, or you simply think that, well, you've been given a particular task to do and that's the task?
Based on my analysis and forward-looking growth projections for each of the areas, I've got a level of comfort around the status of the hierarchy as outlined at the moment. And I do take a projections approach. They're still to be realised. And what I do know about projections after 25 years of working with them is that they're guaranteed to be wrong. And they will change over time for 100 reasons. So we've got to be
but
careful.
You still make them.
It's still we've still got to rely on them as a direction or a way of looking forward. But in reality, they change. And new subdivision opens up and growth changes direction. So I just need to be careful with it, I think, more than anything.
Just following on from that question, we heard from, I think, Mr. Fisher this morning talking about a forward-looking approach in terms of when we talked about commensurate. I've picked up from some of the submitters, they are feeling that in some cases there is a forward-looking approach, in other cases, perhaps along the argument you've just put forward, Mr. Heath, that maybe there's not enough information, or you're not able to be predict with accuracy what that forward position might look like. I'm interested in particularly your comments in terms of the sands, and I think that was probably the one that you felt that you, from what I'm reading through, maybe the least reliable. Is that a correct statement?
It's a centre in its infancy in terms of its scale that can be developed, but it's still to be realised, and the timing of that centre as it rolls out will depend on the growth around its core catchment. So I just think we need to be a little bit careful because it's such a significant centre in terms of scale that's been proposed and partly consented. I don't think we have to give it that status at this point in time, but we have to recognise what's been consented there and the direction it's going in. But it still has to be realised, and it needs to be a bit careful.
So what would be the characteristics of a centre that you, in terms of a forward-looking approach, that you would take into consideration how you would classify a centre?
Oh, that's employment metric, scale, size, breadth of offer, mix of activity, not just retail, commercial, residential, community services.
But they're all existing characteristics.
They are at the moment all proposed.
Right.
And in the case of the sands in particular, the consented activity that's been promoted, but still to be realised.
And is it your view that future rezonings or changes to the plan that was referred to a minute ago may be the opportunity to reassess those?
Correct. My understanding of this process is about actually delivering residential intensification in and around centres, and that's what I focused on.
So and I think we heard that the council hadn't completed hadn't done a complete exercise in applying the definitions out of the national planning standards. When are they planning to do that?
Yeah, more of a planning question. So my understanding is that we have until sort of April, May 2024. But notwithstanding, we've got a number of work programs that we need to kind of work through comprehensively to address that, rather than doing it kind of piecemeal through the IPI.
So so it follows from that you've had to do it in a somewhat piecemeal through the IPI timeframes, and I'm just looking at, in terms of the process you talked about mid next year that's making it notifying that, I'm assuming, or is that completed?
I'd have to come back to you on that, unless someone can help me out.
Pick that up if you like. Yeah, so we're in the process of putting together our forward work program for the City Planning and Growth team. I'm Andrew Mead, the manager, just for the record. That will be going up to our commissioners later this year, and for consideration, decision making, and endorsement on a way forward. We've already recognised that we won't be able to give effect to the national planning standards by the April 2024 date. That's something we've communicated with the Minister of Environment a couple of years ago, when we put our full district plan review on hold. But nonetheless, giving effect to the industrial and commercial hierarchy in the national planning standards is a key focus for both our team and our current governance, our commissioners. It's likely to be a priority plan change that we will develop over the next calendar year, and probably move that towards notification, maybe towards the end of the year or into the following calendar year. And that will certainly be picking up on, the variety of centres where they should be in that hierarchy, both now and with that forward-looking lens. There are a range of pretty complex issues, particularly when you start thinking about metropolitan centres and whether, you know, that's actually applicable in a Tauranga context or it's more applicable in a larger city such as Auckland. And so that's all to be debated. And as Mr. Heath has just outlined, there are some significant uncertainties around some of those future centres. So just not to take up too much time, but with the Sandstown Centre, that's located right next door to the Tutumu urban growth area. That's an urban growth area of around 15,000 people that would provide and that is the key centre to support that growth. But the timing of Tutumu has continually been pushed out to a point now where we don't envisage that Tutumu would start before 2040. So not for 15 to 20 years time. And there are some significant planning and Maori land issues to work through in terms of whether that can proceed and in what time frame. So I'll just leave it there.
So I guess what I'm hearing is that, you know, and with combining those three pieces of information, there is uncertainty. But what I'm also hearing is that there is a process that you're working through in the next 2 or 3 years. So perhaps if I use it by way of example, the Sands development is not necessarily going to be prejudiced by any decision we might make now, but a future decisions could necessarily deal with those when maybe there's some more certainty about those developments as well. Is that a reasonable statement?
Yes, that would be correct. And I'd also just like to add that the NPSUD is enduring, so we must continue to give effect to the NPSUD and all of those further plan changes.
Before we move off the topic of the sands, I just had a question in relation to the consent and whether the consent itself requires any sort of formal staging over a set period, and whether that's tied, you know, like what is the sort of the time frame that development is to be built within.
Mr. Mee, can you assist with that?
Of course, yeah. The Sandstown Centre is a very significant development, like over a couple of 100,000 square metres of gross floor area. And the consent does require staging. That staging is more not something has to happen within a specific point in time, but it's based around the delivery of infrastructure, that certain roads and services need to be in place before particular parts of that town centre can be developed. So it could be fully developed ahead of the opening up the Tutumu urban growth area, but I guess the question is whether there's the demand to support a centre of such a scale at this point in time, right at the fringe of the city.
Can I just come back to the classification question? So, Ms. Heath, the way in which you have applied the hierarchy, the classification of centres, can I just check, has that been discussed in council? So that's council's approach from here on out, subject obviously to fine tweaking, but in terms of the way in which those things have been shoehorned into the different categories, is that a sort of a council position, or is that just Mr. Heath's position? I don't know who answers that.
That's just Mr. Heath's position for now. So
right,
yeah,
okay.
We would anticipate.
Okay, so that could well change.
Yes, we would anticipate further work and also more engagement with relevant parties as well.
Yes. And to that, I think we've made it pretty clear through the expert conferencing on this matter that this is still up for grabs. It's a point in time to support the intensification around centres, but we recognise the difference of views that some parties have about where we've got to, and we've directed them to that future plan change process as a place where we will be happy to have that discussion, continue on that debate.
And if I was going to consider changing the status or rezoning centres, I'd need and would require a lot more information than what I just outlined in my evidence. There's spending data and all sorts of things that would need to consider to appropriately assess the status of the centre on its merits rather than just, you know.
The purport of the question was simply in terms of how we write this up, acknowledging that this is transitional stuff, basically. That's what it is. Yeah. Okay.
So next we'll move on to Mr. Luca. So he will talk specifically to his spatial planning evidence. And I'll just bring up your slides that you've got there as well, Carl.
Thanks for that. I'm just going to run through 5-6 slides. Within that, I'll try to pick up on some of the corridor questions to date. Just by way of background, which is covered in my evidence, I've spent the last 5 years leading the spatial planning for Tauranga City Council and these 3 spatial plans, and also been involved, I guess, extensively in spatial planning prior to that as well. So for Tauranga City Council, integrated planning for growth within our existing urban areas through spatial planning provides us the opportunity to work in partnership to plan for and prioritise investment over the short, medium and long term to support anticipated growth. And that is very much about us taking that look over the next 10 and 30 plus years to be able to put in place the investment that is necessary to support growth in those areas through our long-term plan, but also working in partnership with the likes of Wakakatahi, Regional Council and others to make sure that that investment can and I guess the changes in infrastructure and so forth required to support that growth can be achieved. As you're well aware, we've got 2 spatial plans that have been completed, so for Te Papa and Otamaitai, and the 3rd is underway, looking to complete late this year, early next year. And also the spatial plans, as well as looking to support our long-term plan process, do support our policy processes as well. So we would see them as playing a part in terms of informing future planning around commercial and industrial land uses and so forth as that moves forward. Just on to the next slide. So Ms. Peters has provided some context in terms of the Urban Form and Transport Initiative. I guess importantly, that strategy was completed before the MPS urban development and set a strong direction in terms of focusing growth around centres and a number of intensification areas. It is very much centred around a 15-minute neighbourhood where people have access, as shown onto the diagram, to local amenities, the environment and so forth. Picking a couple of examples, city centre, for example, is where we are investing a significant amount in terms of those type of amenities, library, civic centre, as well as having employment and so forth. But then on top of that, you have access to the harbour, the moana, as well as a range of other, passive and active recreation activities and so forth. I think the Mount North is another area where we certainly see some of those aspects of those playing out. The local shops, the type of activities, whether it be fast food, takeaways, hairdressing, doctors and so forth, all being provided in that area. And specifically in that area, access to really high quality amenity, open space, natural environment and so forth. And probably just picking up on the recent discussion as well, obviously with the Four Square opening, but with New World actually in close proximity as well, just down the road. So very well provided for in terms of those amenities. After he's taken that approach, it's looked at it from a strategic context and said these are the right places to be intensifying. And that's where our spatial plan has then gone to the next level of detail. Just flicking on to the next slide. To actually look at how we support growth in those areas and how that growth is undertaken. And actually you've seen this slide, so I can flip to the next one. So just talking about the process a little bit. So all of our spatial plans have run through a very, very similar process. They have been multidisciplinary and collaborative. So multidisciplinary in terms of land use, transport, open space, cultural experts and so forth, and collaborative in terms of working with our partners, Mana Whenua, Regional Council, Wakakatahi, other key stakeholders to ensure that we develop an implementable plan going forward. Each spatial plan starts with thorough analysis, a SWOT analysis, strengths, weaknesses, opportunities, threats, across all of those layers. And also, for each, and probably just picking up on Ms. Peters' earlier material, undertaking that GIS analysis to understand, the centres, their walking catchments and so forth. So I think in particular, probably here, just pointing out, with the Te Papa spatial plan, we were, it was prior to the Plan Change 33 process, but based on best practice, what we'd learned out of other cities and experiences, we were very much undertaking that GIS analysis approach to look at those walkable catchments. We're probably adding in other layers, access to transport, access to open space and so forth, but a very, very similar approach. And then just stepping through that process, as I mentioned earlier, values engagement with the community, focusing on the values we need to protect and enhance as growth occurs. So I think this goes back to growth in these areas, these spatial plan areas, is anticipated through UFD and now under the MPS as well. So the conversation with our community and key stakeholders is very much around how do we support growth as that occurs. We look to establish a strong partnership with Mana Whenua through these processes and have a specific work stream for working alongside Mana Whenua to understand the values and also the opportunities that they would like us to progress. The collaborative option development. For each process, we've run a series of workshops, generally with 30 plus subject matter experts and professionals in the room to effectively come up with a long list and test the process. So this is including testing the approach to the land use, looking at how that is best supported through an integrated land use transport approach, and then in terms of that social and broader infrastructure that's needed to support that growth. And that effectively establishes our long list, and then we narrow that down moving forward to, I guess, what we say the short list or the priority list of interventions to support that growth. And that's where we're currently at with the Mount Spatial Plan. And we're now out engaging on a number of those key actions with the community to seek their feedback. Probably at the moment I could say that most of the interventions we're putting out there around movement, open space are supported, and what we see is some are coming through stronger than others. For example, coastal pathway, people do want to see their air quality improved and so forth. So that's sort of where we're at on that process at the moment. And
just before you go on,
sure.
Just in terms of your evidence, you've in 5.7, you've mentioned the various people that have been involved in your, I think you referred to as design sprints, and representatives of council and a range of other mainly government departments and other agencies. Where's the involvement in terms of the development community in that process?
Yes, so we have those design sprints, and we do generally include a number of subject matter experts who can represent the development community. So for Te Papa Spatial Plan, we had representatives of Veros, for example, within our design sprint. For the more recent ones, I'd have to dig out the names, but we did have experts.
So in terms of, say, the work you're doing at the moment with the Tauranga and Rataki, who have you got involved in that development community on the current one you're working on?
So there's a number of touch points. We have key stakeholder workshops that we run through in the process, and through that we have invited representatives of the development community. That's included it's included representatives of the Urban Task Force, and it's also included a number of local developers within that Mount Tuarataki area. And then within our design sprint process, we have looked to include planners and professionals who have sound understanding of that development economics and so forth.
Could be argued that they would be representative, or they would have those insights being clients to some of those organisations.
Yes,
Sorry, being specialists advising those clients.
Yes, that's correct. Just on to the next slide. So I really wanted to emphasise, I guess, the consistent approach throughout the spatial planning process, and to, I guess, in terms of looking at that land use between the plan change team and the spatial planning team. Our teams work very closely. We sit alongside each other. We all sit within Mr. Mead's team, and we take a collaborative approach across that. We include one another in our mahi across the board, such as design sprints and so forth. So all three spatial plans are premised on supporting growth, as given the direction of UFTI and the MPS. While they were undertaken prior to Plan Change 33, Te Papa and Otamaitai spatial plans use the same centres-based framework, so that GIS mapping approach, to look at the appropriate growth areas around those centres. And that was very much, I guess, based on what we saw as best practice that had evolved out of the unitary plan process, and that we were seeing evolve with MFE subsequently. The same principles for identifying areas for intensification have been used by Plan Change 33, and I guess just really emphasising the rigour that they have put around those qualifying matters. So through the spatial plan process, when we were working through that, we were always conscious of hazards, conscious of the landscape, conscious of, I guess, topography and those sort of things, and we see that rigour coming through the plan change process. And I guess where it lands us is that we're very comfortable that the processes between the two teams have been consistent and can be relied on in the same manner for our current Mount Spatial Plan mahi. I think just probably picking up on some of the comments that have come through from submitters that the spatial plan should take place before the plan change process is closed out. I understand where those comments are coming from, but I guess, again, really emphasising that the spatial plans have been about supporting that growth. They do put in that framework, and then the engagement that we're undertaking with the community is really how do we support that growth going forward. I think also you do see other examples, such as in Auckland, where the unitary plan was established, and Auckland Council's local area plan has taken the same approach to get into the detail as how do we support that growth that has now been enabled. Just on the last slide, please. Last but not least, really just want to emphasise the investment that evolves out of the spatial planning processes. So this is just a snapshot which shows how we develop a program. This one for Te Papa, this was actually through a business case process in partnership with Waka Kotahi and Regional Council. What it resulted in is our current LTP has approximately 450 million of investment in it to support that Te Papa area, to support the growth that is envisaged within that. A big chunk of that is the Cameron Road investment, but it's also in walking, cycling, community amenities, the civic centre, for example, and so forth. So this program runs 2 or 3 pages. It is well underway, and we're tracking well against it in terms of our delivery. So for Otamaitai, a similar program has been developed, which sits in that spatial plan, and we're currently developing the program for the Mount to Arataki spatial plan area in a very similar vein to this, and currently looking at our draft LTP with significant investment being proposed in that area as well to support growth. I could probably leave it there. Happy to take questions.
Thank
Thank you. So in terms of that sort of point that you made on the previous slide, that sort of saying that it's legitimate that spatial plans can come after the plan change effectively. Notwithstanding that, do you think there's benefits in those instances where the spatial plan has come first and fully informed the plan change and then continues after supporting growth?
The process that we have taken in developing the land use layer in particular has been consistent in both processes. The plan change 33 process has provided a engagement process or consultation process through the submissions and further submissions, which has led to the ongoing refinement within the spatial plan processes particularly for Te Papa. Our engagement allowed for that opportunity for the community to provide feedback, leading to some refinement as well. But I'm comfortable that the processes are consistent and the community is getting the same opportunity to provide input into the process.
Okay, thank you. And then just turning, and this is a question that I sort of picked up earlier, turning to 9.3 of your evidence, and this is where you're talking about in terms of the walkable catchments, and I'm particularly interested in E, when you've got that before you. And so I think we saw we did see an example earlier where the catchment had effectively shrunk to meet the spatial plan. So are there other instances where you're not ticking off? I mean, my understanding was that catchment shrunk, but you were still ticking off. I think it was probably C. So it was still 400 metres, even though it was smaller than previously proposed. So you don't know of any instances where, because of the spatial plan, the catchment has got smaller than you would otherwise expect it to be in terms of A, B, C, or D.
So overall, for our spatial plans, our approach is largely consistent with A, B, C, and D. The only one exception that I can think of is the Brookfield area, where essentially it's, Mr. Tim Heath will correct me if I'm wrong, but his work has classified that as a local centre. We see opportunity for that to grow to a town centre, and acknowledging its general location, and also the investment that we are proposing for that area. And within that area, I think we've found a middle ground, or working with the planning team, that effectively provides for a catchment of around 600 metres.
Thank you.
Yeah, question in your rebuttal evidence, 2.1a, in referring to Kaingaroa's request for a 22 metre minimum permitted height. And as we heard earlier on, that height has been, the requested height has been increased. Is your response similar to what you've outlined in 2.1?
Sorry, I might just need a little bit of clarification. So
in 2.1, you've noted that Susanna Tate states that a minimum permitted height in the HOZ should be 22 metres. And I think we heard this morning that their latest approach is higher. They're seeking a higher height. Is your response to the 22 to this requested higher level similar to the 22? Have other comments you'd like to add?
So I think there's two parts to this question. One is, I guess my rebuttal is specifically around whether that 22 metres should be provided consistently across local neighbourhood and town centres. My position is that no, it shouldn't. That transition approach is appropriate, particularly for the smaller centres, the local and the local centres. For the town centres, providing that transition, stepping down to a lower height and having a lower height of 16 metres for the smaller centres. In terms of the difference between 22 metres and 24.5 metres, I haven't taken a position on that specifically. Wasn't asked to comment on by the planners. I mean, subject to looking at it further, I don't think it's a substantial increase within those areas, well, within the 400 metres of the town centre to provide for the outcomes sought around those areas.
So your response, am I correct in saying your response would be similar? I consider the approach proposed by Kaingora as being inappropriate. Would you maintain that evidence?
Yes.
Just picking up your not quite throwaway comment on Brookfield potentially becoming a town centre. Should we be bearing that in mind in terms of the heights that are being allocated through this process? Because if this process allocates a lower height to the centre as a local centre, then arguably it's going to be a little bit difficult to change that subsequently. So when you're forecasting the prospect that it might grow into a town centre, what's your sort of time horizon for thinking that? And I recognise that there's another process going on in terms of the centres themselves, but just giving me pause for thought.
So in terms of Brookfield and in the context of the Otamaitai spatial plan generally, we see that as the priority area for investment, with investment, and particularly in infrastructure, movement, walking, cycling, improving the overall amenity of that area. Starting within the next 10 years, it would sit more in the second half of our LTP cycle, that investment, given other priorities. And within that, we have indicated a need to work with those landowners to look at the opportunities to support development generally. So it's a smaller number of landowners over that particular centre, and that's where we saw another advantage to supporting growth. More broadly, the area sits with a potential for greater public transport support, infrastructure support through that area, connecting it with the city centre and other centres. So really into that second half of our long-term plan period and moving forward from there.
I think that answer tells me what I need to know, which is there's no point doing anything now. It's not imminent in terms of that growth, and any plan change that comes through dealing with the commercial centres can actually amend that in due course. All right, that's helpful. The other question I had is I assume you've lifted your eyes at some point to the new Spatial Planning Act, and without being obviously we haven't a clue what the hell happening with that, but just in terms of the way the spatial plan is being developed, it sounds to me like there's and this is conjectural, I know, but there's sufficient communication going on at the regional level and sub-regional level that it's unlikely to be overturned in some material way in the short term, notwithstanding the fact we haven't a clue how that process is going to develop. So you got a thought about that?
Yes. We've taken a very proactive approach to engage with our partners on all three spatial plans. I mean, it's a cornerstone of our plan or of our spatial plans. So particularly Regional Council, Waka Kotahi, They are very supportive of the approaches being taken, and over and above that, or moreover, the outcomes are nested within the direction of the Urban Form and Transport Initiative, and also within the current draft of the Smart Growth Strategy 2023. Also, our team members also have direct input into that, I guess, into those other processes. So I've been involved within the Urban Form and Transport initiatives and also within the Smart Growth Strategy itself. So always looking to collaborate and make sure that we have consistency and direction.
Thank you for the moment, Ms. Luke. I don't know whether are you spilling over now to design, or is that later?
We propose to address that later when we're talking about kind of the residential provisions and the like. So for the next expert, which I think should be relatively short, we had Mr. Concise. We had Mr. Greenway, but unfortunately he was unavailable to attend.
That's very short.
Yeah. So this is in terms of the evidence on like population predictions. So if there was anything in particular there, Mr. Mead is available in the meantime.
I had a general question in terms of the population projections, which I read over the last few weeks in terms of what the reports and evidence, but there was a more recent one that talked about a slowing of the rate of growth. Now, I can't immediately recall where I read that. Is that has that been applied across all your planning? It seemed to reflect an aging population that wasn't renewing itself, if I can put it somewhat impolitely.
So I think that was addressed in Abe's rebuttal evidence. So historically, population growth in Tauranga and the sub-region has been a mix of net inward migration and natural increase as births have exceeded deaths. I think migration has been the dominant factor for quite a period of time, but the natural increase has been quite substantial. But with New Zealand, not just the district, but our New Zealand's whole demographic structure ageing, Stats New Zealand are projecting into the future and potentially not that far into the future that deaths will start to exceed births. So natural increase will be negative, and therefore our population growth will become entirely reliant on net inward migration to Tauranga. And as a result, New Zealand's population growth and Tauranga's population growth is projected to decline out on the kind of 30-year time period that Stats New Zealand looks at. And it's still suspected to remain or projected to remain substantial, but is quite materially less than what it has been in the past.
So the rate of growth that you've traditionally had has been 4 or 5%, 6%?
No, it would be probably less than 2% per annum, the rate of growth. Yeah, so averaging around about 1,000 dwellings per annum, which is around about probably say 2,500 people per annum. Obviously, depending on the property and economic cycles, we've had growth. Down Tony's sort of 500 dwellings a year, so it's probably around about 1,000 people, all the way up to over 1,500 new dwellings per annum. So it's quite cyclical.
But I guess the nub of my question is that this information that's come out from that was produced in one of these expert evidence, that's not new information. That's information that's been handed some significant period of time, and that's been incorporated in all the analysis.
That is correct. That's incorporated in our current population projections for the next 30 years and our current dwelling projections for the next 30 years.
I think that's fine on that one. I mean, it hasn't really been taken to task by any of the submitters other than our favourite Mr. Adam Thompson. And he'll come and tell us what he thinks later on. So, yeah.
I think it's important to recognise that this plan change is about putting the scaffolding around where we want density to occur, and that framework will enable movements and projections up and down. It can accommodate that, and I think that's the overall takeaway. Whether the growth occurs at a faster rate or a slower rate, it's not undermining the framework and where that intensification is sought in the plan change.
So if we move on to our next expert, Mr. McIlrath. So he's our economic expert, and we'll also talk about plan-enabled capacity modelling and the like.
Good afternoon.
Welcome again, Mr. McIlrath. Yes.
Thank you very much. Lawrence McIlrath, Market Economics. I prepared some speaking notes. I'll try to keep it short and to the point. So I lead the team from Market Economics that assisted Council with Plan Change 33, and our focus was really on estimating the plan-enabled capacity. In terms of the summary that I'll give, I'll just touch on sort of 2 or 3 sort of main points. That's really just the overview of the approach, just summarising sort of the key results and those findings, and then just outlining some of the key costs and benefits and some comments around that. In terms of the approach, I think it's important to just bear in mind that the part of the purpose of Plan Change 33 is to give effect to Policy 3 of the NPS-UD, and that's really about increased residential development capacity, but it's also about implementing the MDRS and the relevant changes in the residential zones. So in terms of the process, it's conceptually quite a straightforward process. Of course, multiple steps, but the first part of the process was really about setting up a property platform that's extracting information from the rating database using GIS layers and so, those sort of tools, spatial analysis tools, to get a sense of where the development capacity, where the planning structures enable a change in development. So went through a process, looked at setbacks, recession plans, height limits, the view shafts, as well as other sort of guidance information from council, like architectural testing, not agricultural. Went through that process to get a sense of, how much development capacity is enabled. So we looked through that at different typologies. We looked at standalone dwellings or detached dwellings. We had looked at horizontally attached dwellings, which are really duplexes or terraced homes, and then also looked at vertically attached, which is really apartments, and that's up to the maximum heights. So following that process, we then compared the current city, the operative plan with Plan Change 33 to look at what are the potential differences. So that's spatially what are the differences in terms of where development is enabled, looking at the quantums at a total level, but also looked at the different typologies. I think it's important just to realize that the plan-enabled capacity is this theoretical maximums. So that's really the top end of the market, in terms of what's enabled. So in terms of the key findings, I think nobody's really surprised or shouldn't be surprised that if we look at the Plan Change 33, it really enables a substantial lift in plan-enabled capacity compared to the operative city plan. And that is, of course, consistent with the requirements and as expected with the NPS, UD and the MDRS. So Plan Change 33 really increases the density of residential development, and it's really around the centres and in those key locations. So if we just look at the sort of headline numbers in terms of what's enabled in terms of the change in the quantums, for standalone dwellings, plan-enabled capacity increases from around $30,000 dwellings under the operative city plan to approaching 92,000 additional. So that's a shift of 62,340 dwellings. Horizontally attached dwellings increased from around 8,160 dwellings. So a big increase there to around 140,000 additional dwellings. And vertically attached dwellings, you see an upward shift from around 52,000 to 356,000 dwellings. So you can really see the change in quantum, but also the change in the typology. So if we look at the potential step changes, standalone dwellings, threefold increase horizontally attached dwellings, 17-fold increase, and vertically attached dwellings, it's a 7-fold increase. So of course, it's not just the quantum or the type of dwellings that's important in terms of what's enabled, it's also the spatial distribution of what is actually anticipated where. So we grouped the city into sort of 7 or 8 broad reporting areas, and that's just to make it a bit more easily digestible, and went through that. And I guess that from our perspective, the key findings of that is that the plan enabled, while it is across the city and you see these big lifts across all locations, it is actually reasonably uneven. It's really concentrated around some of the key centers around the city. So I explained some of those in the evidence and just highlight that if we look at the vertically attached dwellings, around 80% of the plan enabled capacity that's enabled, that's around Tauranga Central, Tauranga North, Bethlehem, the coastal strip, as well as Papamoa and the greenfield areas. So those areas obviously capture, 4/5 of the change. In terms of horizontally attached dwellings, again, you see that very big increase, but it's important to note that it's actually it's off a low base. And currently under the city plan, most of that plan enabled capacity is really in Papamoa Greenfields, Paispa West and Wairaki. So about 90% of that typology is enabled in those locations. But under Plan Change 33, that really reshuffles the arrangement. So those the locations then only have about 28% of the plan-enabled capacity. And so you see a big shift of that capacity across the entire city. And you see similar sort of patterns for detached dwellings. At the moment, it's around the city, but you see lifts in that plan-enabled capacity around the entire city. So the main points in terms of the spatial distribution and the quantum, that's really the scale of the additional plan-enabled capacity is significant. It's really enabling change across all typologies, and it's also throughout the entire Tauranga. But if we look at the spatial concentration, we're actually, favouring and enabling a whole range of additional capacity in Tauranga North, Tauranga Central, and locations like Bethlehem. The analysis also captured qualifying matters. So the numbers I've already spoken to, we've already taken out those or considered the effects. So if you have a qualifying matter that reduces or influences, the development potential, so we factored that in and, already reported that. But just for information, if we look at all QMs together, that's the existing and the new ones, it reduces plan-enabled capacity by around 11,000 dwellings if we look at detached typology, but up to about 50,000 if we use the attached, the vertically attached typologies. But that has to be seen in terms of the quantum of what is still enabled. So if we look at Plan Change 33, it will obviously deliver a range of costs and benefits. I think everybody, most of the economists in the room will agree that, look, there's a whole range of positives that are associated with the intensification. But I think it's important to also step back from that and say, look, it's not just about intensification. We also want to make sure that we deliver outcomes, and that's consistent with the NPS UD, and that's around the well-functioning urban environments. So we have to reflect that. It's not just about intensification, but we also need to reflect, the objective 2, which is about planning decisions, improving housing affordability by supporting competitive land and development markets. So we have to hold those further objectives in mind as well. So if we think about what Plan Change 33 is actually delivering, it's enabling a range and a shift in the spatial patterns, and it's those shifts and the accompanying developments that have the new range of interaction patterns, and it's those interactions that actually drive a whole range of the effects. So plan-enabled capacity is, of course, one of the building blocks, but we have to tie that back to the potential demand. It's not just the scale of the plan-enabled capacity, it's also how much of that is taken up by the market that influences the urban form outcomes. So we have to consider that. By taking a step back and looking at across the different locations, Plan Change 33 really enables intensification in high accessibility areas, which is really about the centres. And I won't go into too much detail around that, but it really enables, the centres-based structures, enabling and unlocking a whole range of those urban form effects and benefits that are associated with intensification around those centres and delivering the high amenities. But I think it's important to also acknowledge and reflect that the spatial extent of the different provisions. It's not just about locations, the where, it's also within those centres and around the centres, where the plan-enabled capacity is important. And that's because the benefits of intensification rely on actually getting increased concentration in and around those centres. And it's making sure that we actually capture and enable the growth close to those centres to make sure that we capture those benefits. There are some risks that if we enable entirely homogeneous type uplifts and zones, we don't actually get the diversity of choice. We don't get that differentiation in the marketplace. We do need that differentiation across different locations, across typologies, to make sure that we actually capture some of those benefits. In terms of the scale of the market, I think again, we have to acknowledge that the size of the demand influences the market response, and it's that response that captures location and typologies. So again, we have those trade-offs and those relationships that we have to factor in. And of course, those market segments, or the demand as functions of goes to and influence the level of concentration, where we actually achieve that concentration and intensification. And that then also goes to the typologies within different locations and how much of that is actually achieved, because that then grows through to the different, how much of the potential development is actually enabled and captured, and how much of the potential benefits manifest. So I think that the key point there is that the size of demand is important, and it needs to be considered, because otherwise there's a risk of enabling activities in locations that would not actually gain from increasing concentration. And if that happens, of course, then we're diluting the potential upside benefits of intensification. So I think all up, if we look across the Plan Change 33, it is expected to deliver a range of positive outcomes and benefits. And those include, again, talking about the centres, it's the residential diversity and the choice and housing affordability, supporting centre functions and vitality, improved use of land and so forth. But of course, intensification is not without cost, and it's not without risks. So we have to, consider those as well. Costing, relate to aspects such as increased congestion, and additional movements on networks, potential land use conflicts, and potential impacts on social cohesion and sense of belonging. But all of those really go to the some of the underlying risks that are associated with how do we actually manage the spatial extent and the location of intensification. And I think those risks are already highlighted in the MPS. If we look at policy 3D, when it starts talking about commensurate, the building heights and densities of urban form must be commensurate. So that is, related to with the level of activity in those commercial areas. And in the context of Plan Change 33 with the intensification, in my view, this really goes to making sure that the type of developments that are enabled reflect the type of nature and the role of individual centres and the size of those centres, but it's also then considering how that growth in those centres can actually influence the performance and relative, how the different centres actually interact with one another. And of course, all of that is associated with looking at the anticipated growth and reflecting the demand patterns. That, in a nutshell, summarises my evidence.
Thank you. The question I have is in terms of the demand that the annual demand is around 1,000 dwellings a year, and what the plan-enabled capacity is significantly larger than that. How confident are you that some of the benefits that you've just touched on will be achieved, given that development cannot be focused in any one particular area or a small group of areas?
Yes, and that's part of the challenge we have, because it really comes down to if we look at the size of the potential demand that we have, how do we make sure that we actually accommodate that in appropriate and in the best locations? So we are a little bit hamstrung because of the specific directions that we have to follow. So there are risks that we actually, that some of those potential benefits are actually diluted.
So is a follow-up, and maybe the other experts may be able to respond, is there anything that the council can do to actually encourage concentrations of these rather than those potentials being spread right across?
Well, I suppose if you take a very wide approach, looking beyond just planning, can council take an entrepreneurship type role? Can they actually participate in the market? But I think looking past planning, you start entering into those sort of almost philosophical positions and roles about what is it that council should do in terms of property development. And people it can be quite controversial. I'm sure the planners might actually comment on some of those.
So through the spatial planning process and perhaps coming a little bit back to your earlier question, particularly having those in the development field involved, what has been identified is that the council needs to be investing across the board in terms of movement, social infrastructure and so forth to also assist in attracting investment into areas. So our long-term plan does need to make prioritisation decisions. Certainly, if we were to look at it, the Te Papa city centre, Te Papa has high priority. Areas such as, I guess, the Mount Coastal Strip will have higher priority in terms of that investment, and probably to a slightly lesser extent, the Otamaitai spatial plan area as well. So what we see is investment is planned over the next 10 years in those areas, putting priority around the city centre and those other areas where we want to see growth, and also that investment in transport, and probably acknowledging also to the discussion just then the need for the integrated land use transport requires that growth numbers to support public transport and vice versa. So that's where our investment is going on in those key routes and so forth.
And for my 5 cents worth on that question, the real tool we've got from a planning point of view is height, and the differential in heights. And heights creates and enables a competitive advantage in those locations where you want that intensity to occur. So that's why you have a layering of height CBD down. So those height differentials sort of send the signal to the market and affect feasibilities of development. So having those heights in the most efficient and the appropriate locations where you want that density to occur is a really important part of the framework that can be set up to encourage and facilitate development to occur in those efficient locations, or in the locations you want it to occur.
Thank you.
So a supplementary question to that then, which may be slightly tongue-in-cheek. Would it be easier without MDRS?
Well, just to answer that just quickly, if you're after an answer, we would have had an intensification plan change operative probably, I don't know, 18 months, 2 years ago. So from that perspective, yes. And that previous direction of plan change 26 was much more targeted around where intensification would occur, or to the scale of intensification that was appropriate in different locations, so that we could achieve these benefits better. So I'll leave it there.
Yeah, I suppose the other way of asking that is am I correct in thinking that the area that you really want to achieve intensification is the centres, rather than where you've got the added benefits of facilities, buses, and whatever, all those things that we know about?
Short answer is yes.
Yeah, and yes, but the MDRS has changed the baseline from ground level up to 12 metres, whatever it is, and that's why the heights is quite an important factor.
Well, it's actually done more than that, hasn't it? I mean, on the numbers that you've provided here, we've got in excess of 500,000 dwellings enabled to try and capture 30,000. I mean, that's the boldness of this exercise, isn't it?
Just on that, the number shouldn't be added across the different typologies, because if you have a lot, you can do either development, you can't do all three.
Mr. Keemus, I think, is going to tell us that 54% of those are in vertical structures. So, yeah, we're heading towards lunch. Do you want to bring forward one more witness for 15 minutes, or would you want to take a lunch break now?
Yeah, I'm anticipating that Mr. Kemi's will probably be a 15-20 minute discussion. So I'm happy.
Would you like a 15-minute discussion now?
I'm anticipating that we should do that now before lunch.
Right.
Thank you. Yeah, Michael Kemi's Director of Veros, and Council asked me to provide expertise in relation to Plan Change 33, really focusing on the feasible development capacity and the reasonably expected to be realised development capacity, and obviously the real capacity of what can be expected from Plan Change 33. To try and keep things succinct, there's sort of three main areas I want to sort of focus on that sort of come out of the conferencing and other expert evidence. Those being touch on the population growth rate and some of the impacts that may or may not have on development, and then touch on the distribution of how we've landed at our RER numbers, which Mr. Lambert has raised as an issue, and then just touch on the viability of 4-storey buildings, which comes out of the Collingwood Ore application. And then I've got a couple of notes of clarification that I picked out through comments earlier today that I'll just have a reread and I'll touch on them. So the first one being the population growth rate and the impact that has on, I guess, feasible development, is at a point where there's 140,000 feasible dwellings that we've sort of, as we've gone through the process, that's the number that we've ended up from what is plan enabled, based on looking at some of the raw metrics of developments that we're actually currently involved in, be it townhouse, duplex, subdivisions and apartments. So we've looked at all those dynamics, and that 140,000 dwellings is, to give you some numbers around that, is we've currently got 60,000 dwellings in, just over 60,000 dwellings in Tauranga, so it's still a massive number. And as we've touched on earlier, we only need 30,000 dwellings based on the population growth numbers. And so if we take the 30,000, 11,000, which Ms. Speedy spoke on earlier, does come from future growth areas. So that portion of the population is also excluded from the 140,000. So we're really delivering 19,000 out of that 140,000 within what's currently available. And in order, while the bulk of that is planned to be townhouse and apartments, that still accommodates the attached dwellings in growth areas that haven't been realised currently. And that's how we end up with that 50% of it being standalone housing versus the 38 and the 12% in vertical and horizontal delivery. And so just to touch on that, the number of current properties that we need to deliver the 9,500, say, which is half of the 19, that's going to be more in the vertical space. We only need in the order of 1,350 properties to achieve that sort of number, which is actually only around 2.5% of our total housing stock to deliver those numbers. And so the key thing there is that the plan enables a lot of development capacity, and the feasible development capacity is also extremely high. So we don't actually need a lot of our stock. So if the population growth projection is slightly out or out, there's still plenty of capacity within what's been enabled through Plan Change 33 to meet that demand. So then the second part of it is sort of touching on Mr. Lambert's view that the majority of apartments are going to be delivered at the Mount, and that comes from a historical sense in that the Mount, I think from the early 1980s, has had the only high density zoning. It's had the height limit, it's allowed it, so there's justification for why it has occurred there. And when we actually got involved in this process, there's a lot of other factors that start to come in and dictate where we would see realised development. And a lot of that is actually built up from being fairly active within the development community. And I know you've touched on that in terms of the spatial planning. Our company does get involved in those, and we've been involved with council and a lot of the other aspects that go into the back engine of these processes. So we're well in touch. We understand what makes them work, and therefore when we came to look at how we distributed the deliverable outcomes, it wasn't just solely based on where all the numbers and the data was pointing to us. It was, what does the zoning look like? How big in terms of the Te Papa corridor, it's a large zone, and it's 27-metre height limit. So it has a fairly big part to play in the scheme of things. So it wasn't just in isolation that we looked at how that distribution occurred. And so, look, as Mr. Heath said, that their forecast, we will get them wrong, but at this stage, to the best of our knowledge, these are the numbers that we came up with, and it was understanding that wider, broader aspect of where the Tauranga market's at. And then thirdly, was the Tauranga Water raised questions on around the viability and feasibility of particularly 4-storey buildings. And this is a fairly well known within the development community that there's a big jump from 3 to 4 stories in terms of construction cost. And look, my analysis came to the same conclusions currently. There are examples of 4-storey buildings being delivered in the Tauranga market, one recently, different model, build to rent type model, and things like that. So there is examples where 4 stories provide benefits because it's about yield long term rather than short term delivering. So we see the build to rent and I guess the growth or the involvement of public water in this space is being quite significant over the short to medium term. The market's currently almost building no apartments other than ones that have been pre-approved. The construction costs have gone through the roof, and the sales and the rentals achievable have not kept pace. So, the short term, it's going to be dominated by those players that do have a much longer term view on it. So, in terms of 4 stories, yes, it's currently unviable to the traditional developer-led sales-driven model. There's other models that have made it work in the market, and we see those models as being quite highly favourable in the short term, medium term. And also what we know is the construction market changes readily. every year there's different legislation that comes out that they have to adapt to and adopt to. So there's a lot of R&D that goes into that sector. And those things are all designed around how do we construct and make things more efficient or more economic to deliver. So, you know, we can get around and say that 4 stories is unviable at the moment. I probably disagree that it is, but I also disagree. I disagree with the statement or the sentiment behind it that it should be excluded, or we should go to 6 stories so that it is viable, because there's other benefits of a 4 story, as Ms Peters and Mr Heath have commentated on, around ensuring where that development does occur. And just finally, I just sort of picked up some comments around the 24.5 metre point that's raised in the Tauranga order evidence. It effectively looks at trying to ensure that the commercial is available on the ground floor of the commercial centres where they're sort of trying to approach it. The effect of that is that it will allow a 7th story to a residential building at that same height. So there's a balancing act between keeping it at 22, where everyone can go residential, get to 6. If you've got an element of commercial or retail component to it, you might only get to 5. But that's the balancing act between those.
But that last comment was, if you stay at 22, you can achieve those size.
Yes. So if you stay at 22, you can get the 6 stories of residential. But if you've got an element of commercial in there at the ground floor or the likes, you may only get a total of 5 stories. But if you go to the 24.5, which they want, you'll get 7 stories of residential and 6 stories of a mix.
I'm just interested in your table 6, which is your apartment yield and financial modelling results table, and just I might conclude that later on, but I won't conclude that now. Yeah, I mean, I'm just interested in how you put your total development costs together on this particular line, because that's obviously a major driver of the columns that spit out of that. I mean, is that based on some sort of contemporary pricing and that, or it is? Huh?
Yeah, look, we're obviously very active in this part of the market, and while there's not a lot of apartment pricing going on, I had, we have built, or our company was involved in the building of Latitude Apartments up on top end of town here. But I'm also, I've got other developments that are going on with Foster's, who built Vantage up on 4th Ave. So I had a pretty heavy debrief with them and really understood their costings inside of it, and had a good robust discussion around what would that mean in the current market. And similarly, there's a developer active at Mount North, who's currently got a building in early design phase, had pre-application meetings, and so I have spoken with him as well around what his anticipated costs were, and align those 2 or 3 processes. And yes, so they're based on historical, a little bit of working through it, but also validating with someone that's very active in that market. You know, the developer in the north is an big construction company owner, so you know, I heavily rely on him.
What struck me out of that table quite straight away, of course, was the profitability of 3-story walk-ups as opposed to higher rises. And I'm not sure I saw that sort of. I mean, assuming that. I mean, that's attractive across time. I assume that's not a peculiarity of the current circumstance.
No, there's obviously a couple of elements there. You get the slightly lower cost model, because you don't have the necessary required lifts. And cost of structure as you go higher gets bigger, therefore foundations get larger. 3-story building can't quite compete with 2-story building because based on in New Zealand you can get away with timber framing at 2 stories. It gets a little bit trickier at 3 stories without it having a cost implication. But essentially the 3-story walk up, it's a speed to market process as well. It's pretty well known. It's easier. It's a smaller model. The time taken or required to take it to market to sell it and do all those other elements that get running behind the scenes that not many people see make it a lot easier development, and therefore the time scale has a bearing on the cost of development as well.
So have you done the crystal ball gazing of thinking of how these different typologies are likely to play out over the next 10, 15 years in terms of the distribution and within that particular market?
Yes.
And?
In my opinion, I see the 3-story walk up as being quite a significant player. There's roles to play in all the typologies, but if we want to hit the numbers of these vertical builds at the requirements that are sort of set out here, we will be reliant on the 3-story walk up. It's a market that more people can be involved in, so you can have more constantly on the go in terms of that delivery model. You'll see here the equity required is at a scale that, while it's still a big number, it's not that big for most development people, and that's where the benefit of it is in that you get into a 6 or an 8-story building. It's a highly specialised building. I've been involved in 20-story apartments in Sydney, and the teams that we would pull together for that's all they do is apartment building. So once you get into that scale of building, you need experts who are real experts in that field, and that's what they do. 3-story walk-ups, you'll get most construction companies wanting to be part of that, and therefore it's all a part of that bigger picture, is that scale and repeatability that comes into that scale of development. And therefore, that's why I see that as being one of the key typologies over the next 15, 20 years.
And what height are you needing for that? What's your,
the 3-story
typical?
And that's part of the issue, is the 3-story walk up. If you're good at what your job is, you'll get that under the 11 metres of the MDRS.
Only if you have people shorter than me living in it.
Yeah.
But the benefit you didn't mention of those, I wanted to check whether it was a benefit or not. Is it that issue of risk in terms of simplicity, finance, and also being able to stage your development over time? Because you could have a number of buildings rather than have all your eggs in the one basket, one large apartment.
Yep, that's exactly it. It comes down to risk.
I guess just wanted to probably note that, and brands have some good reports on their website that track development since the unitary plan was put into place. And And I think what they show is a maturing of the development market in Auckland that has taken place as that zoning has been enabled, and there's been a response to that zoning being enabled. So there is an element of making sure that we are zoning and attracting that type of development and enabling it to move forward, which will hopefully lead to a maturing of our development market as well, and expertise within this city and other smaller cities.
And I appreciate that. I mean, what's going through my mind at the moment is if you actually want to encourage the higher rise rather than the lower rise and concentrate in those corridors, whether in actual fact the structure that we're currently talking about is the one that's going to get you there because it's so liberal. And I don't know what the answer is, but that's certainly playing around in the back of my mind at the moment. Got us to lunch, so thank you very much for that. We'll now take a break. We'll resume. What does it say on the? Well, apparently we're going to resume at 12:45, but that's probably another. I think. What should we do? 1:45. Let's come back at 1:45. Thank you very much. All right, everybody, let's resume this afternoon, and we appear to be heading to Smith's Farm.
Tēnā koutou katoa, ko Brad Bellamy tōku ingoa, he kaimahi ahau o te kaunihira o Tauranga. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Good afternoon, panel. Thank you for the opportunity to speak with you this afternoon regarding Smith's Farm. I do have a short presentation with plenty of pictures that we can move through, I'm hoping. So just to give you a quick overview of where I wanted to take this opening statement, there were just some key points I wanted to spend some time on. Firstly was to provide an overview of the site context and some of the background consenting history. I would just provide a brief overview of some of the submissions that we received. The key issue for Smith's Farm as we've moved through this process has been working through some stormwater related matters and responding to submissions that have sought relief in that respect. And finally, I just wanted to touch on the evidence, what was presented through evidence, and where we're at in terms of resolving those issues. Thank you. So Smith's Farm is located approximately 6 kilometres southwest of Tauranga's central business district. So up on the screen, I've just tried to indicate in blue down the bottom left-hand corner where Smith's Farm is. I haven't indicated where the CBD is, but I'm pretty sure we've got a fair idea. The property is currently owned by Tauranga, by the council, and has a total area of 47.5 hectares. The property is split by Takatimu Drive, and with the land on the southern side of the road, which is approximately 20 hectares, forming part of the Kopu Rerorua Valley Reserve. This portion of the site is open space under the operative city plan. So on the screen at the moment, that's the area indicated in green. The focus of this proposal or this discussion is on the red area on the northern side. The northern portion of the property is generally rectangular in shape and comprises a large flat-topped plateau with ground levels of 28 to 30 metres above sea level. This level grassed area of the site is currently in pastoral use. The portion of the site is zoned rural residential under the operative city plan. The elevated plateau areas slope down to the north to a valley, excuse me, which is under modification to the Takatimu North Link project. To the south, the property slopes down to Takatimu Drive. A mixture of vegetation covers the slopes on both the northern and southern parts of the site. Areas along the southern slope of the site are identified in the operative city plan as being part of a significant ecological area.
Help me a little bit. And what is the Takatimu North Link project? You come to that, do you?
I've got an image that I can bring up shortly, but just to touch on it very quickly, it is a Wakakatahi-led project linking Takatimu Drive through to the Minden or through to Tapuna, and then also it's effectively a bypass of the Bethlehem area. And so
there's that area to the north where there's current earthworks, and so that's a really up-to-date area.
What you see on the screen in front of us here is, I'll drive if that's okay. So I'm going to move the arrow, hopefully, if it doesn't, no, I'm not doing a very good job. So just at this point here, yeah, this is where there's a roundabout at this point proposed, and the start of the Northern Link will be there heading north. What you see on the screen here is an aerial from this year, 2023, and you can see the works that are underway by the agency to start that. Existing walking and cycling pathways do run along the southern edge of the site, connecting to existing pedestrian overbridge located near the southwestern corner of the site. You can see that on that image as well. Again, I'm not going to try and move this mouse because I'm not quick enough. The walking and cycling links along this edge of the property are currently closed due to the construction works that are underway. But interestingly enough, this project does introduce the opportunity for and does propose new cycle links as part of that as well. The site has legal frontage to Cambridge Road, as you can see on the top there. via a shared access way, which has been referred to as Richard's Way in the past. This access way is currently impacted, obviously, as you can see, by construction works. The site has also a legal frontage to Westridge Drive, which is a no-exit local road where the head of a cul-de-sac is located up against the site's western boundary. So just to point that out, exactly where the mouse has been strategically located, that is Westridge Drive. Smiths Farm was declared a special housing area under the provisions of the Housing Accords and Special Housing Areas Act in 2016. This allowed applications or resource consents to be sought to establish residential land use across the site. Applications were then lodged with the Bay of Plenty Regional Council and Tauranga City Council in December of that year. The resource consents were granted in 2019 that allowed for residential land use and subdivision over the land. The subdivision included the creation of 216 residential lots, along with vesting of land and council for internal road networks, open space, and supporting 3 waters infrastructure. Subdivision activities were to be controlled through conditions that prescribed a set of development standards that generally at the time replicated the existing provisions of the suburban residential zone. Both land use and subdivision consents included a condition prescribing a 10-year lapse period, so that would take it through to January 2029.
Just a question in relation to the consent. So did the consent apply to the whole area, so both the red and the green, or just to the red?
The consent related only to the area in red, and I've got an image coming up that shows where effectively the boundary of the residential land use was proposed. However, I just want to point out, just for clarity, that the special housing area, when it was declared the land by legal boundary, a legal title boundary. So it did actually include the red and green area, but obviously no consent was pursued for the green area. It was only inside the red area. In 2020, an application to change the conditions of the subdivision consent was made to allow for a change in both the configuration and the number of approved residential allotments. The proposal specifically sought to increase the number of residential lots from the 216 that was originally approved up to 255. However, these were to be located within the same area, so there was no expansion of the area in which the consent related to. It was simply just a reconfiguration internally within that area.
I suppose I should probably note that I made the decision back in 2019.
And was that change accepted?
Correct. It was approved in the same year, 2020, but there was no change sought or even entertained to the lapse period, so that was still 2029. Yeah. So on the screen is the same image you saw just before, but what I've done here is in black showing the area that was approved for subdivision consent, and within that bounds there was the land use component inside that. So I haven't gone to the detail of showing each individual lot proposed layout, but that was the extent of the boundary. So that was a starting point, at least in terms of the next section, which has been the approach to the proposed Smiths Farm rezoning. So the proposal is to create a medium density residential zone over approximately 12 hectares of the Smiths Farm site to enable residential development capacity. The extent of the proposed residential zone would correspond to the area previously approved for residential land use and is subject to the existing resource consent. So that's the point that I've made here, is that by showing the black outlined edge, that is also the area which you would see in the annotated maps in terms of the extent of the medium density residential zone. In addition, and in support of this new residential zone, a new open space zone was proposed and is proposed that includes the land that extends along the site's southern boundary adjacent to Takutimu Drive. This proposed zone would include the steep escarpments and existing ecological areas located along this part of the site. This proposed zone would also connect to adjacent land that is currently zoned for this purpose. The remainder of the site to the north of these proposed zones would retain the existing rural residential zoning. So I thought I'd just pause there and flip through to another plan, which is not that one, but I'll come back to it, is this one here. So what I have just mentioned is to the south is a new green area that would connect to, or just off the screen, sorry, at the bottom is an existing small rectangular looking thing at the bottom there, which is existing open space. And to the north is already zoned open space, and this would connect through that. step actually. I'll just leave it on that screen for a second as I'll come to the context of the linkages with the northern link. The proposal takes into consideration the activities allowed for on-site through the existing resource consents and the works being completed as part of the TNL roading project that also support the delivery of housing for the site. This work includes the construction of a new access road to the site from Cambridge Road and a combined stormwater attenuation and treatment facility. So the reason for showing this picture on the screen was to give you at least an illustrative version of the proposed Smiths Farm access road instead of the Richards Way connection, which was slightly to the east of where this road's been shown. What is proposed is a brand new road that would connect to the roundabout at the of Cambridge Road and St Andrews. The other purpose of showing this drawing or this illustration was to point out, I'm going to try and navigate with the mouse. This is the area of the combined stormwater attenuation and treatment area that is part of the delivery of the TNL process or project. And as I touch on in a second, has been designed to include the capacity for dealing with stormwater from the Smiths Farm site. This diagram also shows, and the reason it was shown is because it was part of the outline plan approval for the active mode pathway that was proposed along with the TNL project. So you'll see a lot of little pathways, etc., running off the access road, and they are connecting on to existing networks around the area.
I think I've lost where we are, what we're looking at now in terms of what part of the site that is.
Okay, sorry, so just off the screen to the south. So I've got the mouse right down the bottom of the, yeah, sorry, it's white, not helpful. That leads directly onto the Smiths Farm site. So if I go back a couple of slides and I try and do the same thing, that, oh my goodness. This is where that access road effectively comes in and connects, where the mouse has just disappeared. Sorry, there's a bit of a lag between me moving the mouse and the actual mouse moving, so as part of the preparation of this work, consideration was given to a range of technical assessments. These included those previously completed for the site as part of both the identification of the land as a special housing area, the resource consents that were approved, and some additional technical work that we completed as part of this proposal. This additional work was completed to better understand any potential constraints on enabling further residential development capacity for the site. These assessments have demonstrated that use of the site for residential land purposes remain appropriate, and there has been no significant issues or capacity constraints identified as a part of this rezoning proposal. So I just wanted to ensure the panel were clear on the location of those technical reports. So at the moment, they all sit within the section 32 appendices. The appendices for Smiths Farm start at 18 and move their way through A, B, C, D, and E, and D as the relevant infrastructure capacity assessment, which includes some of the modelling that was done for that, including 18C, which is the transportation one. Turning specifically to submissions, submissions received in the proposal did not raise specific concerns with the proposed new zoning. However, 2 submissions did seek changes to matters relating to the design of future development proposals, including building heights and access arrangements. These matters are outlined and have been considered and responded to in detail within the Section 42 report at sections 4.72 and 4.73. The submission of the Bay of Plenty Regional Council in respect to the proposal sought the inclusion of a specific stormwater provision or provisions to manage stormwater hydrology and water quality issues. And those have been the what's been concentrated on in terms of trying to resolve through those issues. And as outlined within the Section 42 report, this matter was considered further, and as a result, the inclusion of site-specific provisions relating to stormwater management for the development within the proposed medium-density residential zone have been recommended. So just moving on to Section 6, I'll just cover quickly the stormwater management element. The proposal, as notified, did not include specific provisions for controlling stormwater runoff effects associated with urban development within this proposed zone. It was considered that through a combination of existing operative city plan provisions and those provisions proposed through Plan Change 27 and through Plan Change 33, that these would be adequate to address stormwater-related effects. In addition, had been identified that along with the requirement to comply with the requirements of the National Environmental Standard for Freshwater and any future stormwater system proposed, and that any future stormwater system proposed on the site would still be required to obtain a discharge consent from the Bay of Plenty Regional Council. So I'll just pause on that for a second, because I've just spoken previously about resource consents being issued by the Regional Council and by Tauranga City Council. Those were initially, when the applications were lodged for the SHA consent I'm referring to, they included a permanent discharge consent. However, at the same time that consent was being processed, the TNL works were going through their consent process, and there was a move to try and bring the approach to stormwater together. It made sense from an effective and cost-effective point of view. So ultimately, the discharge consents that were issued by the Regional Council were for the temporary discharges only, and not the permanent one. The permanent one was actually withdrawn from the SHA consents. So I sought some clarity from the Regional Council on this, because it was a little bit unclear as to what had happened, but they did confirm that permanent discharge consents from Smith's Farm to the stormwater facility that's been has been consented and designed for the TNL and Smith's Farm doesn't have a discharge consent at this point in time, and one would need to be sought. So a key element, excuse me, to managing stormwater effects associated with future development within the proposed medium-density residential zone is the stormwater system that is being delivered as part of the TNL project. This system has been designed to not only address stormwater from the TNL, but also attenuate and treat stormwater runoff from the area proposed as medium-density residential zone. This combined stormwater system is subject to resource consents issued by the Bay of Plenty Regional Council. The TNL stormwater system has been designed to provide full attenuation for the future development within the zone. However, the system has only been designed to provide water quality for up to 1/3 of this development area. Water quality for the remainder of the development area would need to be designed and provided as part of future development proposals, in addition to what has been designed as part of the TNL consent. So this would also be the case, I note that this would also be the case in the circumstances that additional attenuation volume was required, or if stormwater runoff from the future development was not to be directed to the TNL stormwater system, which frankly wouldn't make a lot of sense because it's sitting there ready to go. Ensuring that the requirements of the MPS for fresh water have been satisfied remains a key outcome for this proposal, that this proposal seeks to achieve. It is appropriate that stormwater management for future development on the site adhere to these national policy expectations. I'm of the view that this can be achieved through implementation of a stormwater system that responds to both the scale of development proposed through use of low impact stormwater design practices that can assist in promoting positive effects while addressing any adverse effects on stormwater runoff. So this has been a change from what, as a result of the submission, frankly, and a further review of some of the design intricacies of the TNL system that I've arrived at this point to try and better align, excuse me, the delivery of urban form or development on the site with an appropriate stormwater response. So as a result, the inclusion of a new policy and stormwater-related provisions have been recommended to implement the outcome sought under a new objective, which is 12B 1.2. This new policy and supporting provisions seek to ensure stormwater management is comprehensively addressed or assessed, and considered within a what I've termed a stormwater management plan, and that is required to be provided as part of subdivision or land use development within this proposed zone. The policies and provisions proposed are intended to deliver on the outcomes set out within the new objective and to also support existing policy framework within the operative city plan, that have been set out within section 3.3 of the section 32 AA report that was prepared. Discussions with staff of the Bay of Plenty Regional Council have taken place during the preparation of these provisions. These discussions have been ongoing to satisfying the relief sought in their submission. I understand that these are I understand that these recommended provisions are largely agreed now, with only minor matters now outstanding. Just finally, I want to turn to the evidence submitted. I've read the evidence of Mr. Tapaire of the Bay of Plenty Regional Council and that of Mr. Collier on behalf of the Urban Task Force, and note that neither have raised concerns in relation to the inclusion of these provisions. I note the recommended changes made by Mr. Tapaire and confirm these discussions have been ongoing, or that discussions are ongoing on addressing some of these matters. Further, I understand from the evidence of Mr. Collier that concern is raised over there being a lack of certainty and clarity with one of the clauses that comprise the controlled activity standard and term that's been proposed. The concern being how the protection or enhancement of wetlands and open space as set out in that provision relate to managing stormwater effects for the development. I look forward to hearing evidence and presentations from all these submitters. Finally, this proposal seeks to rezone this site to provide for a medium density residential zone in conjunction with a package of provisions proposed to support the proposed outcomes sought under sections 14A and 14G medium density residential zone of the city plan. An open space zone has also been proposed to complement this new residential zone. This proposal now recommends the inclusion of provisions to support stormwater management associated with residential development and being land use and subdivision within this proposed zone. These provisions are intended to complement existing and proposed subdivision and land use provisions and other existing provisions of the operative city plan. These recommended provisions, in my view, are considered to better provide alignment with the expectations set out under the NPSFM. So other than the issues I've outlined above, I'm of the view that there is support for this rezoning proposal and that it will, in conjunction with the provisions as recommended, enable greater housing capacity and choice as required by the Resource Management Act and NPSUD, and I look forward to assisting the panel further when necessary in their consideration of this proposal.
Ms. Bellamy, anything on that? Good. Right.
So now we'll move on to subdivision provisions. So Miss Karen Steer will address these.
Good afternoon. Oops, that's loud. My name is Karen Steer. I'm a policy planner with the city planning team. As Ms. Beaters has said, I'm presenting on subdivision. The opening statement provides an overview of the approach to subdivision adopted through the plan change. The majority of changes that were notified through Plan Change 33 to operative provisions were to amend wording which refers to zones which are to be replaced by the medium density and high density residential zones, or to rehouse provisions in the subdivision chapter. To give effect to the MDRS, the plan change restructured residential subdivision provisions to accommodate three scenarios, being subdivision to create vacant lots, subdivision creating new boundaries around existing lawfully established dwelling units, and subdivision implementing or following a concurrently considered land use resource consent. Those are covered in a little bit more detail in paragraph 4 of the opening statement. In addition, Plan Change 33 also inserted non-notification requirements and made other minor changes to support the amendments required through the MDRS. No submissions or only submissions and support received for a number of the amended provisions. Key submissions seeking amendment to the notified provisions which remain unresolved as areas are, if you'd like to just advance forward, please, in relation to yields and consent notices. And if we could advance again, thanks. There was actually very little change that were made to the existing yields provisions notified through Plan Change 33. I added the words "at least" to clarify that net yield is a minimum, and the yield rules were amended to reflect new zone names, as in those examples on the screen. Next slide, please. Submissions received in relation to yields were to delete all yield requirements. This was on the basis that proposed Plan Change 6 to the Regional Policy Statement proposes to remove yields. A further key submission was to amend the yields to better reflect the MPSUD and the Amendment Act. Through evidence provided, expert evidence provided, the preference was indicated for outright deletion of those yield provisions, and the alternative that 25 dwellings per hectare or 50 dwellings per hectare were to be provided in the medium density and high density residential zones respectively. Thanks.
Sure. Go back to that previous slide. No, the one before that. Yeah. So by ensuring that the target average net yield of at least 15 is achieved, etc. So that's not a requirement. That's okay.
It's essentially forming a baseline, or at least a sort of a backstop position.
So why do we have the words ensuring if it's not a target? If it's not a requirement.
Unfortunately, this was an operative provision that we inserted the words at least there, more to give it at least to advertise an expectation that 15 dwellings would be a bottom line.
I'm a little bit confused as to whether it's ensuring or whether it's a target or quite how it works. I understand the difficulty you have. I'm not trying to be difficult about it, but I'm just trying to understand what we've ended up with.
So in terms of the, excuse me, the existing provisions, these just relate to our urban growth areas. And if you just go to the rules of, in terms of those yield requirements for our urban growth areas, how they are set up is that as agreed through that plan change process, is they started off at 12 dwellings per hectare and they cascade over time. They increase up to 15 dwellings per hectare. So off the top of my head, I want to say 2030 is when that 15 dwellings per hectare. And so that was to recognise market conditions change over time and you'll have those increased densities. So that was agreed between the parties. And I think at the moment it's, so at the moment that minimum requirement is 12 dwellings per hectare in terms of 12.5 in terms of the rule requirements for the identified urban growth areas. So as you can see in subpart A, it's talking about progressively increasing that over time. So we're not actually, in terms of that rule framework, at the point now where 15 dwellings is a minimum requirement for those growth areas, noting that most of those growth areas are almost at completion. Does that clarify the question around why it's worded that way in the policy?
Yeah, it's just confusing when it talk about a target and then talk about a requirement. They're two different.
Yeah, so the target average, it relates really to links into clause A, where it's talking about that baseline requirement of 12 dwellings and then it's progressively increasing over time to get to that 15 dwellings. But it also in that policy takes into account and acknowledges that you may have, for example, geotechnical or land constraints where you can't provide that minimum yield requirement. Because if I'm right, Ms. Steer, this is only part of that policy. That's not the complete B, clause B, which goes on to, if you go into the rest of the policy, it recognises geotechnical constraints or other values that need to be protected where you wouldn't reach that minimum yield requirement.
But as I read that, and I can't recall the rest of it, the yield requirement is on the zone, not on the individual subdivision, isn't it?
It relates to the urban growth area. So yes, it is the zone, as you can see below, but it is in relation to the listed urban growth areas. So there's Pies Pa, West Bethlehem. So within our city plan, we have an urban growth plan, which identifies the boundary of that urban growth plan. And each urban growth plan may have specific subdivision requirements or land use requirements that relate to that urban growth area.
Right. The position that was taken in the 42A was that proposed plan change 6 to the RPS doesn't preclude the setting or retaining of density targets. The explanation for the new policy introduced as part of that plan change talks about density targets and provisions are best set in district or city plans relative to local opportunities and constraints. So the yields were considered necessary to retain those to avoid the creation of lifestyle lots, which would represent poor utilisation of the land resource, and in consideration that higher targets may stifle development, acknowledging that the land is highly fragmented with little remaining urban growth area to be developed, as Ms. Speedy mentioned. It was considered that the existing requirement of 15 dwellings per hectare provides a reasonable baseline. In summary, I consider that the yield provisions continue to serve a useful purpose and can remain in the plan without further modification. Is there any further questions on yields? The other key unresolved issue was in relation to consent notices. There's a provision under the Controlled Activity Matters of Control and Conditions where we added an additional clause talking about consistency of subdivision with any approved land use resource consent. Just advance forward, please. The key submission sought to delete the requirement for consent notice. In the expert evidence, the submitter considered that it was not an appropriate process to manage land uses, and if subdivision proceeds, land use vacant lot subdivision requirements would apply. Additionally, the development would have to meet design assessment requirements. I consider that the notified approach avoids the creation of vacant lots unsuitable for development. Once the subdivision is finalised, the vacant lot provision will no longer be applicable. Instead, land use provisions will apply. The wording of the consent notice provision talks about only applied where appropriate, so it will not be required for every combined land use and subdivision consent. And I believe it helps avoid poor built form outcomes. The following situation, it may be appropriate to tie land use and subdivision together. This one, the subdivision implements the land use consent. If we could just, thanks. In the following situation, however, poor built form outcomes could arise. In this case, subdivision proceeds before part implemented land use consent and then a permitted land use is established on a vacant lot. I consider that it may be necessary in some instances to ensure land use is fully implemented and that subdivision is completed in conjunction with the land use. In summary, having the ability to control the implementation of concurrent land use and subdivision through consent notice is appropriate and provides a mechanism to avoid poor built form outcomes. I'm looking forward to discussing this with submitters and with the panel members.
Can you just go back to the actual consent notice provision again, just to reread that now I've seen the rest of that? One more further back, I think. Oh, is that's all we got?
Oh, I may not have, yeah. I didn't actually put the full, there's a list of other, very good.
To go back.
One more there, yeah. Any further questions? Okay, thanks.
So next we're moving on to Council's approach to retirement villages. So again, Ms. Steer will be addressing those.
Lucky you get to listen to me again. Right, for the recording, my name is Karen Steer, I'm a policy planner with the City Planning team. Obviously, the subject of this presentation is retirement villages, and the detailed position has been set out in my opening statement, which has been tabled. I propose to go over some key aspects. If you'd like to advance, please. It's just to look at the operative versus the plan change notified approach, the rule framework, including activity pathway and residential zones, submissions and expert conferencing, key changes in response, key unresolved areas, and then just touch on the framework for the commercial and city centre zones. Under the operative city plan, retirement village activities are a permitted activity and subject to density requirements, including a minimum site area. Where the density is not met, it falls to be a restricted discretionary activity and has specific standards and terms and matters of discretion that are applicable. Where standards and terms are not met, and in this case it's development intensity on a bed or room basis, urban design and engineering assessment requirements, any proposal would fall to be a discretionary activity. Next. The approach through Plan Change 33 was to include the MDRS as retirement villages include buildings and residential units. So city plan amendments were required to incorporate the MDRS within the medium and high density residential zones. Retirement villages continue to have a permitted activity status and subject to 1 to 3 independent dwelling units being permitted and 4 or more independent dwelling units being restricted discretionary. The provisions largely replicated the operative restricted discretionary standards and terms and matters of discretion. There's broad alignment to the treatment of 4 or more independent dwelling units generally, but the standards and terms specific to retirement villages focus more on external interface aspects. There were no other substantive changes as this would involve associated services and facilities by virtue of the inclusion within the definition of retirement village. Where standards and terms are not met, once again, bed and room density, urban design engineering assessment, a discretionary activity results.
Before you move off that slide, can you just, yeah. So in terms of what's currently in the plan, you said that there was permitted activity residential. Can you just go back to the previous one? Yeah. So
that's gone forward. If you could just back up, please. That's the operative city plan in front of you.
Right. So in terms of to compare what's permitted under the operative plan and compare what's permitted under the PC 33, you mentioned PC 33 talks about 1 to 3 being permitted, and then beyond that is a restricted discretionary. So how does that compare with what's currently in the operative plan?
The requirement was under the MDRS that we had to replace out the likes of independent dwelling units and replace those for the equivalency of 1 to 3 on a permitted basis for residential units under the MDRS. And then 4 or more would be a restricted discretionary activity. So that approach was taken in respect of independent dwelling units generally, but because the density provision for retirement villages actually included independent dwelling units within it, we then had to sort of, I guess, assign or allot a permitted activity status to 1 to 3, and then apply that 4 or more as a restricted discretionary activity.
Fine. Now, and so how does the current plan provide for, and because I understand what's proposed, but what does the current plan provide for?
That's providing for 1 independent dwelling unit per 325 square metres. Yeah.
And just noting that's with a minimum site that's got site area requirements as well. And whereas in Plan Change 33, we proposed to delete those minimum site area requirements, so it's more enabling in that respect.
So it's sort of, there's a bit of give and take.
Exactly.
So we've looked at the activity pathway. Just moving on to looking at a little bit more in depth at standards and terms through Plan Change 33. As I've discussed, they're more focused on interface aspects. So 4 or more independent dwelling units are required to comply with some standards that were translated from the operative provisions, being building height, setbacks, height in relation to boundary. And we're subject to a new standards for site coverage and fences and walls. Importantly, under Plan Change 33, we did not require retirement villages to comply with outdoor living, outlook space, windows to street and landscaped area, and waste management. The other requirements, which were maximum intensity for bed or room basis, urban design assessment, engineering assessment, and other chapters of the plan, were all operative provisions which were directly translated into Plan Change 33. Next one, please. When it came to the matters of discretion, once again, those were just all operative provisions. Character and coherence, scale of built form integration, capacity of infrastructure, public road entry and exit, and financial contributions. So those were just basically translated directly into Plan Change 33. So the key submission areas from retirement village submitters were requests for definitions, one being to replace out the retirement village definition with that of the national planning standards and to insert a new definition for retirement unit. There was a request for new policies. Permitted activity standards, there was a request for no density provisions and to tailor provisions for retirement villages. The standards in terms and matters of discretion were requested to have a bespoke approach and for non-notification to apply to retirement villages as they do for 4 or more independent dwelling units generally. The Tauranga City Council submission sought to align the standards in terms and matters of discretion more closely to those applicable to 4 or more independent dwelling units generally. Next slide, please. Through expert conferencing, the activity pathway was discussed and there was broad agreement reached on retirement villages with 4 or more independent dwelling units having a restricted discretionary activity status. The standards and terms and matters of discretion were to closely aligned to 4 or more independent dwelling units generally as well, but those were to focus on external and interface aspects. And there was also an agreement that non-notification requirements for retirement villages should apply the same as the 4 or more independent dwelling units generally. Accordingly, as part of the Section 42 amendments were made, the summary of amendments are outlined at paragraph 6.2 of the opening statement. The standards and terms, we made greater alignment with the standards of terms for 4 or more. The matters of discretion, once again, greater alignments with matters of discretion for 4 or more. There was also a move to align the approach to standalone rest homes to the treatment of rest homes within a retirement village. Importantly, the discretionary activity pathway was deleted. Non-compliance is now assessed on a restricted discretionary activity basis. And there was also non-notification added for retirement villages as well. Through expert evidence, for the request was made for 4 more independent dwelling units to additionally have to comply with outdoor living, outlook space, windows to street, landscaped area and urban growth area requirements. As part of that requested addition, there was also related amendments sought to outdoor living to be able to provide outdoor living cumulatively in 1 or more communally accessible location and for indoor living to be able to be used in part satisfaction of outdoor living. Both of those amendments I recommended to approve. The amendment, however, to outlook space, which was reducing the outlook from the principal living room to a 1-by-1 metre, I was not comfortable in recommending approval. In my opinion, the outlook space for retirement village residents should not be less than for other developments. Finally, other amendments were made to the urban design assessment criteria to remove some duplication which has been created when we're considering the policy framework.
A question there in terms of the 4x4 outlook. Is that combined with the adjacent dwelling so that you end up with an 8 metre?
That's a direct MDRS statement, straight out of the density standards of the MDRS. I think the idea is you're not meant to overlap the outlook spaces. Yes.
So it's a combined, so it's 8 metres.
If you've got 2 dwellings next door to each other. Yeah. So just moving on to the matters of discretion. Thank you. Once going through the expert evidence, there was a request to add the corresponding matters of discretion for non-compliance with the permitted activity standards for outdoor living, outlook space, landscaped area, etc. I recommended these matters of discretion are added as they provides greater alignment with the treatment of 4 or more independent dwelling units which are not in a retirement village. There was also a request through expert evidence to broadly reword the matters of discretion. I was not recommending these amendments in response as the notified approach, in my opinion, is clearer as it directly aligns to the matter of discretions for 4 or more independent dwelling units and other developments. And the majority of amendments sought are already covered within the matters of discretion for 4 or more generally, including the consideration of positive effects. As part of the rebuttal, I put in a table there which on page 28, which had a comparison with the matters of discretion that were notified in the substitute wording recommended by the expert evidence. Any questions arising from that? Further amendments which were requested through submissions were for retirement village to definition to be swapped out for the National Planning Standards definition. The definition is replicated at paragraph 3.3 of the opening statement. The submitters also sought a new definition for retirement unit. I wasn't recommending changes to the definitions as I think retirement villages are within a spectrum of residential uses and this needs to be assessed comprehensively. The operative definition of retirement village covers the full range of accommodation types, associated services and facilities of retirement villages. Additionally, the submission seeks that retirement unit is not an independent unit, dwelling unit. The definition of independent dwelling unit is included in other definitions and provisions throughout the plan, which may result in unintended outcomes and change the operation of provisions in a way not contemplated. Submitters also requested new objective and policies for ageing population and housing for ageing population. This was to recognise and enable housing and care needs, provide a diverse range of housing and care, which the policy was refocused through expert evidence to enabling retirement villages. And a further reason was recognise that greater density of development than anticipated for independent dwelling units and other forms of residential development is appropriate for retirement villages. I didn't support this objective and policy as I believe that Plan Change 33 framework provides for greater density for all forms of residential development. That recognition is provided for retirement villages as other accommodation type in section 14A purpose statement and policy for residential diversity and densities. And the city plan does not provide recognition of other groups with specific accommodation needs. When it came to the ability to provide greater density than any other forms of development, I believe there's no limitations on density through Plan Change 33, and that if it relates to greater height, this can be considered through a restricted discretionary resource consent process. As part of the raft of policies that were requested by submitters, one was called Changing Communities, to provide for the diverse and changing residential needs of communities and to recognise existing character and amenity will change over time. I believe once again that the framework through Plan Change 33 has already signalled in objectives and policies that there will be a range of dwelling types, that there will be a variety of housing types, and the planned urban built character will change over time. In particular, there's still the provision for specialised accommodation which responds to the planned urban form of the zone. A further policy requested was that of larger sites, which was to recognise intensification opportunities of larger sites and to provide for more efficient use of those sites. The policy was refocused during expert evidence to consider the site's ability to internalise potential effects of intensification. I'm not recommending the addition of this requested policy as it's not clear what constitutes large. If large equates to extra height, that's contrary to the centres-based approach that we've taken through Plan Change 33. A restricted discretionary resource consent process gives the ability to consider additional height and characteristics and the ability of the site to internalise effects. The next policy requested was that of density standards, to utilise density standards as a baseline for assessment of effects. I see through expert evidence this is no longer being pursued as a separate policy and instead has been added to the policy on residential diversity and densities. I believe a policy is unnecessary as the RMA already provides a permitted baseline test through section 95. Just moving to the commercial and city centre zones. There's actually no specific objective policy or otherwise in the operative or the Plan Change 33 in relation to retirement villages. Instead, they're encompassed within the definition of residential activity, and residential activity notified through the Section 42 is now permitted activity. Accordingly, there's no specific activity status for retirement villages, both operative and in the plan change, and no specific standards and terms, matters of discretion or non-notification provisions. Within the commercial and city centre zones, the submitter requested, once again, the policy for housing for an ageing population, which was to enable retirement villages. And as with the discussions in the residential zones, I believe that the framework already provides for greater density for all forms of residential development. Therefore, I consider that policy recognition is not required. Again, the city plan does not provide recognition of other groups with specific accommodation needs within the city, commercial and city centre zones. There was also a request through expert evidence to amend permitted activity standards for outdoor living and outdoor space. In the case of the outdoor living, I thought it would be appropriate for retirement villages to be able to provide outdoor living cumulatively in one or more communally accessible location or through indoor space, much like with the residential zones. Once again, though, the reduction in outlook space was not supported for the same reason. I don't believe that a resident in a retirement village should have less opportunity for outlook space than in other developments.
Just a question. When the request for a reduced outlook space, I can't remember, did they give a reason why they thought it was appropriate to reduce the outlook space?
Really, many of the discussions, I guess, are in relation to the very comprehensive nature of retirement villages, how they're designed, how they have very rigorous urban design standards that they adhere to provide amenity for their residents. The concern is, for me personally, is that not all retirement villages are comprehensively designed. There are smaller scale retirement villages, and I think that without minimum standards, that, and particularly with regard to outlook space and therefore access to daylight, that there could be very poor design outcomes for those residents. So in general summary, I believe that the policy framework through the plan change supports and enables the creation of diverse housing for all sectors of the economy. It recognises. You can take that, that's fine. It's going to be more interesting what you're listening to now. It better not be your wife you just said that about. Anyway, sorry, I digress. The policy framework recognises specialised accommodation needs. The definitions encompass the spectrum of residential uses. The definition of retirement village recognises the very types of accommodation, facilities and services that they provide. The plan change aligns independent dwelling units within a retirement village with the MDRS approach to residential units and appropriately provides for small-scale retirement villages through to large-scale developments. The specific standards in terms of matters discretion manage retirement villages as a subset of the 4 or more category, and there is non-notification for independent dwelling units within retirement villages and other developments which has been aligned. In my opinion, the plan change and recommended amendments provide an appropriately nuanced approach to retirement villages. And I look forward to a robust discussion as part of this hearing process.
I'm not sure it's going to be a discussion. Yes. I have to ask the question. I mean, the evidence that we've been given is that there are something like 30 or more than 30 retirement villages in Tauranga. So it's hardly a one-off exercise, and therefore one might reasonably expect from their point of view anyway, for some sort of bespoke consideration to be given to an industry that is relatively prevalent and is going to get more prevalent from all the predictions that we've got. The council's position seems to be to, rather than to actually accept nuanced approaches, to actually want to put things into a more global consideration, i.e. more than 4 or more IDUs. Is there any sort of thought that maybe not perhaps in this process, but in a subsequent process that you might sort of move differently, just so that we're sort of forearmed for that discussion that we're going to have?
If nothing else, when we actually have to apply the national planning standards definitions, that will mean sort of a comprehensive review of the full spectrum of residential uses, which obviously retirement villages are part of that. And I think that naturally then translates into looking at the provisions and seeing what is needing of a refresh. I mean, the specific standards in terms of matters of discretion for retirement villages, which were operative and we've refreshed, I guess, as part of plan change, did provide for a nuanced approach and actually provided greater benefits to the retirement villages by focusing on these external interface aspects. The inclusion by request of expert evidence to include the likes of outdoor living and outlook space and things and those sorts of standards obviously brings in closer alignment to the 4 or more. But I think at least by giving those reductions or reconfigurations of outdoor living, that it allows some degree of flexibility for their internal design. We did notify sort of more interface type aspects instead, but with those inclusions, I think the idea is to make it a little bit more prescriptive. Obviously, that's something you can speak to the submitter's expert on, but perhaps to make it a little bit more prescriptive to remove some of subjectivity. I think there's a genuine concern from the retirement villages of the length the process takes, and that planners will come in and try to redesign the interior of retirement villages. I think that we are trying to strike a balance, that we've got to have provisions that are suitable for not only comprehensively designed, but also the smaller scale. If nothing else, the non-notification provisions that have been put forward have actually, I guess, reduced the complexity, the length potentially of consenting process, which should help or facilitate the retirement villages establishment.
I just had a bit of a follow-on question. You mentioned there about when the national planning standards will have to be incorporated, you'll need to do a fuller review. And I think maybe Mr. Luca might have mentioned earlier today about that you're not on target to meet the timeframe currently set. I was just wondering, what is the timeframe for when you're looking at rolling out those standard definitions?
We're currently in discussions with Ministry for the Environment in terms of meeting those standards. A number of councils are in discussions, given the complexities of what's sitting in front of councils, giving effect to national policy statements and the Amendment Act. So we will be reviewing those timeframes with them, and I know that there's at least 2 other councils are in the same discussions.
And so when were you due to have or required to currently?
In terms of national planning standards, we're required to notify those changes by it's May 2024, and we were on track with that in terms of our city plan review. However, that's on hold. So it's as we discussed this morning, it's on our work program, but we're working with Ministry for the Environment in terms of what's practical for our council to be able to implement those changes, because especially when it comes to matters such as definitions, it does require a very broad, when you look at the whole plan, as many of those definitions cut across multiple zones, and whereas we're through this plan change, while it's a large plan change, we're still confined to those residential zones and commercial zones that were notified.
Thank you.
Just going back to the earlier question in terms of the I guess the lack of specific treatment of retirement villages as opposed to residential development as a whole. I was just trying to get a comparison between the operative plan and what's proposed in terms of this plan change, in terms of changes to objectives and policies. The impression I was getting was that, and correct me if I'm wrong, a lot of the objectives and policies are being removed. Is that correct? In that focus on retirement villages.
There was policies or and also in purpose statement and policies that talk to retirement villages. The policies, though, were premised on the fact that you had a very low density suburban environment, one house, one site. And the idea was, the context that was given with those is that it may be appropriate to allow for larger scale, comprehensively designed retirement villages in the suburban residential zone, which had a receiving environment of very, very low density. So the removal of those, I consider was appropriate, because the scale of development that the MDRS is now providing means that we have a more urban type environment moving forward to be created. So therefore it removed that specific need to accommodate retirement villages and comprehensive use of also larger sites, which was also provided for under the operative plan.
I can understand your thinking. Could that to some extent be moderated by the large extent of the medium density zoning, basically right across your residential area, and the indications we had this morning of the likelihood of a lot of that land never being in a medium density zone, whereas in terms of the likelihood of further retirement villages, as we heard, is quite high, and whether that contrast that you were saying there's no longer going to be there is in fact will be there because of the extensive zoning that's proposed over Plan Change 33. I didn't explain that particularly well, but what I was just trying to think is whether some of the intent of what's in the current plan might be lost because of you're not going to necessarily get that intensive, 3 dwellings per lot over an extensive area of your district.
I'm thinking that the very clear signalling that we've put forward as part of the policy framework in Plan Change 33 is talking about the changes to the environment, the planned urban character. The narrative has changed a lot, and I feel that through that narrative that the larger scale retirement villages are enveloped or encompassed within that.
So what I'm hearing then is that there's no need for these bespoke policies and objectives, because the plan is far more enabling to allow these things to happen anyway.
And of course, on top of that is that the activity itself is permitted. So it's really development controls that we're talking about.
That's correct.
Yeah. All right. All right, as you say, we will engage more on this as the week progresses. Thank you.
I just note in terms of the schedule, we've got a afternoon tea break about now, if anyone's considering that. Otherwise, I'm happy to move on to speaking about the residential provisions. No. If I just direct you back to my written opening statement from this morning, I think it starts on page 8, para 4.1, section 4, about there onwards. So I don't propose to go into a significant amount of detail in terms of provisions, obviously because there's a lot to consider throughout the hearing and consider kind of the alternative positions that some submitters seek. But I do propose to kind of give you a bit of an overview and a context to the different sections and how those provisions kind of relate in the plan. So obviously Plan Change 33 is introducing 2 new residential zones, the medium density and the high density, and to accompany those zones is section 14A. So it's an existing section in the plan, and considering the city plan's current structure, it functions like a strategic chapter or provides a bit of overarching direction to a broader range of zones. And so when we notified Plan Change 33, we thought this was the appropriate place to include those higher level directives of the NPSUD. So particularly the well-functioning urban environment directive, changing amenity values over time, and that focus on integrated decision making. So section 14A also provides that high level direction around urban growth areas. It identifies kind of the process or the reasoning behind the spatial application of, say, the high density zone. And it also provides some specific policy direction for other supporting land uses, such as retirement villages, visitor accommodation, schools, health centres and the like. And so how Section 14A functions is that it should be read alongside the other zone provisions. In terms of submissions on Section 14A, the bulk of these were generally supportive. Some minor amendments or additions to additions seeking kind of specific policies, most of which Ms. Steer has touched on. And I've recommended a range of amendments to address some of those points. But at this stage, I'm open to kind of considering what's coming through in the hearing, and my intention is that the Section 14A remains a responsive kind of framework to align with the MPSU directives. So if there's no questions, I'll move on to Section 14G. So Section 14G is where the medium density residential zone sits in the city plan. So the purpose of this section and zone is to implement the MDRS as prescribed by the Act. So all of those standards as listed in Schedule 3A of the RMA are included in there as permitted standards. And I note there's 2 additional supporting standards, and they have a urban design function. Firstly, a minimum standard for waste management areas, so prescribing a minimum area to accommodate council's rubbish and recycling bins. And then secondly, a maximum standard for fences and walls adjoining public spaces, so streets primarily, or reserves. So these standards do not impact the ability to achieve any of the MDRS requirements, built form, density, anything like that. Their purpose is to assist and support good urban design outcomes as that intensification and built form is naturally going to increase on some of these smaller sites that are being enabled. I note that when we notified Plan Change 33, we included a minimum dwelling unit size, and in response to submissions and some of the viewpoints that have come through there, I've recommended that has been deleted, primarily on the fact that it duplicates some of the Building Act requirements and is difficult to actually to manage kind of functional design of dwellings. So that matter of discretion in terms of the functionality of dwellings and the overall amenity assessment is more important when you're in that 4 or more dwellings assessment as a restricted discretionary activity. So overall, in terms of the provisions, I've recommended a range of amendments. A lot of them are around improving interpretation, reducing repetition, providing more clarity, and a joint witness statement focused on the matters of discretion when you're in a 4 or more dwelling situation. So really looking closer at the expectations for urban design assessments there, because there was some risk that could potentially be quite onerous with the notified provisions. So in terms of the objectives and policy framework of the MDRZ, or the medium density zone, it's still enabling of height because of what the Amendment Act is asking us to introduce. But it's reinforcing the fact that if we are considering applications for greater height in the zone, it should be in locations that are supporting walkable neighbourhoods, greater access to public transport, day-to-day amenities, services, social infrastructure, parks and the like. So that's integrated throughout. And so the primary way that the plan will be giving effect to or enabling greater height is through the high density zone. That's located in section 14H. So the high density zone includes the MDRS because it must, and also gives effect to policy 3 through greater height enabled in spatial areas that we discussed earlier this morning. So one of the differences between the high density zone and the medium density zone is that we have omitted the maximum site coverage rule that is prescribed in the Act. So I propose that the acceptable level of building coverage is instead managed by a maximum impervious surface rule. So that's 70%, and also works in conjunction with the 20% landscaping area requirement of the MDRS. This recognises that within the high density zone itself, we are anticipating, and in my opinion, it's acceptable that a greater concentration of built form could be supported within those areas. And like the medium density, it has the same two additional supporting standards, considering provision for waste management areas and your public facing fences and walls. Another key difference with the high density zone is the introduction of 3 area specific precincts. So these are unique to the high density zone, and the purpose of them is primarily to manage the scope of the IPI and the way that it limits our ability to make changes to non-residential activities. So because we've taken a consolidated approach to a number of existing residential zones, they have some nuances for some non-residential activities with different activity statuses across the city. So we've proposed precincts to carry over those existing development rights for those non-residential activities, and also the precincts will then they reflect the spatial application of where they're currently enabled or have some other supporting standards. So there's 2 city living precincts, and these are around immediately adjacent the city centre zone, and they primarily allow some specific frameworks for offices at ground floor and a few other little nuances there. So we're not proposing to change any of that other than some minor clarification to make sure that the terms and references are all correct. Again, the Mount Maunganui precinct is another example, well, the third example, I should say, and the primary purpose of this is that from Moau, so Adams Avenue at the base of Moau to Banks Avenue, an operative plan visitor accommodation is a permitted activity, and that's not permitted in any of the other residential zones across the city. So we've used that precinct to carry that over. And also unique to that precinct is the operative high-rise plan area. So if you're familiar with Mount Maunganui, there's the existing towers that are established within that area, and they have a kind of supporting objective and policy framework that sits alongside. So the general direction is that that framework is retained as much as possible. Obviously, yeah, some wording is proposed to be amended to ensure consistency throughout. And again, we can probably touch on it on Thursday as well. There are some consequential amendments to those provisions in the Mount Maunganui precinct, recognising the introduction of some specific qualifying matters and specific sections or specific framework that is addressing those kind of natural landscape cultural values. So instead of replicating them in the precinct, they're being pulled out and kind of created their own unique framework that gives them a bit more strength. But overall, the bulk of the submissions for Section 14H, in terms of the provisions themselves, were around ensuring like a permissive land use framework is proposed, and also a focus on the extent of urban design control. So making sure they're not too onerous, but they're also achieving their purpose. Considering the matters that were raised in submissions, I've generally at this stage retained the planned outcomes for the zone that were notified. So enabling between 4 and 8 story buildings throughout, greater building bulk on the site. And again, I've recommended a range of amendments for improving clarity, avoiding duplication and the like. A key change since notification was how Plan Change 33 proposed to enable the height required by the MPSUD. So at notification, this additional height to up to 8 stories in some locations was enabled only for a resource consent that was for 4 or more dwelling units. And a number of submitters sought that this built form should be enabled as a permitted activity regardless of, say, the activity or the number of dwellings on a site. So I've accepted that recommendation, and also in relation to the equally enabling height in relation to boundary. In my opinion, they're appropriate to have as permitted standards within the zone rather than being attached to the 4 or more pathway. A key submitter to the provisions in the high density zone was Kaingaora's opposition or alternative height in relation to boundary that was sought. Obviously, to achieve the planned built form for the zone of up to 8 stories, we do need to have a quite enabling height in relation to boundary. Otherwise, you need a huge piece of land to make any sort of apartment development feasible, because you'd be breaching your height in relation to boundary quite easily. So at this stage, we've recommended retaining the parameters that we've notified, although recognising moving them from that restricted discretionary pathway into a permitted standard. And I think Mr. Luca will address some of the merits of that, but we are interested to hear more from other experts. As far as I'm aware, no other alternatives have been proposed in that regard. And again, what was discussed or presented yesterday in terms of the enabling framework for 4 or more dwelling units, a number of submitters sought that there should be more enabling in the high density zones, so having, say, up to 6 dwellings or more permitted. In addition to the infrastructure matters that were discussed, I think it's appropriate to retain discretion over 4 or more dwelling units as a resource consent, particularly for that urban design focus. And similar to the medium density zone, joint witness statement agreed to the revised matters of discretion when you're looking at an application for 4 or more dwelling units. So again, primarily clarifying that urban design role, making sure that wasn't too onerous. And just overall, the key issues that I see remaining are a range of amendments to the objective and policy framework to recognise, in some submitters' opinion, that the high density zone should provide for at least 6 stories, rather than what we've currently recommended as a range up to kind of 8 stories. So again, they're taking that position that 6 stories should be enabled everywhere, regardless of commensurate centres, accessibility and the like. Again, the alternative height in relation to boundary sought, deletion of the waste management areas, some specific matters of discretion around access for firefighting or potential constraints to that access, some more enabling pathways for Papakainga, which was put to Mr. Fisher this morning as well, and also for shared accommodation. So overall, I look forward to hearing from submitters and their viewpoints on some of these recommended changes. I know I haven't elected to provide any rebuttal to some of the further amendments that have been sought, because I wish to do that comprehensively at the conclusion of the hearing.
With that shared accommodation, is that the issue in relation to whether it's 8 or 10?
That's correct. I can continue on to the urban design section. So I'll just provide a brief kind of overview of this, and then Mr. Luca will provide some supporting information around his role in urban design. So with Plan Change 33, and obviously the changing kind of environment that is anticipated. I see urban design principles as an important component that we should incorporate throughout the provisions. A key way or key mechanism that we do that is requiring an urban design assessment for applications of 4 or more dwelling units on a site in both the medium density and the high density zone. And the scale of that assessment will be commensurate to the scale of development. So obviously, if you're looking at, say, 4 dwellings compared to, say, a 6-story apartment building, there's the ability to have a commensurate assessment there. So Mr. Luca will discuss the value of urban design and the role of council's non-statutory design guide. It's called the Residential Outcomes Framework. So that was released in a draft form initially as part of Plan Change 26, and then also as part of the notification of Plan Change 33. So this is a supporting design guide. It's not a mandatory requirement, and we've proposed to remove. We had some guidance notes that link to it. We've proposed to remove them for clarity. And again, where relevant, the principles within that design guide have been reflected or incorporated where appropriate into the zone provisions, and that gives some weight to those outcomes. But I'll pass on to Mr. Luca to provide some further detail in this regard.
All right. Yeah, so Carl Luca, I am a qualified urban designer by background, and just, I guess, yeah, by way of background, have worked, I guess, within both policy and assessing the urban design components of resource consent applications for councils. So have a good understanding of, I guess, both the policy and the delivery context. So look, good quality urban design, it's not just about the aesthetics, it is very much around the functionality as well. And, you know, if we don't get it right, it can result in social, environmental and economic costs. And those costs often play out over the long term. This becomes more important as our cities continue to expand, but become more intensive as well. People living closer to one another, buildings close to one another and so forth. And it's really important that we have the teeth within our city plan to be able to have this discussion with people, with applicants and developers as they are moving forward, so that we can move towards positive outcomes as opposed to having to clean up the negative ones over time. Next slide. So in this vein, Tauranga City Council has been working hard to put together, I guess, what we're calling an urban design framework. And within that framework, we have now established an urban design panel, which has been up and running as of this year. That has 15 professionals on that urban design panel. And the focus is assisting to assess and provide feedback and guidance on both public and private development projects. So in terms of private development, the type of medium density that we might see, we're encouraging people to come to the panel to take advantage of that free service, and that through that panel they will provide advice as to what changes might be necessary to, I guess, to respond to the appropriate, the matters that have been identified within the city plan, or otherwise provide advice more generally that, that the design is in the right direction. So by way of example, we've had about 10 different applications go through our panel this year, and a number of those have gone back, or one of them has gone back at least twice, where it's helped to shape up their proposal. They now have a development proposal that has been supported by the urban design panel, and that will probably, should all going well, find a clearer pathway through the consenting process from an urban design perspective. So that's the purpose.
Is there any guarantee that a proposal going through the urban design panel will actually be supported by council?
So as part of the setup, we have an urban designer who works within council, and the planner. So that urban designer and planner will sit alongside the panel on that journey, so that they're well informed, and certainly the outcome and the advice note that comes out, if it's supporting that that development from an urban design perspective, that will hold weight through that consenting process. So as part of the process, going through the panel, we develop a cover sheet which outlines the relevant city plan matters that would be considered and so forth. So it is very much about, I mean, we can't provide absolute certainty, because there might be other things that come up through the process, but from an urban design perspective, it will help clear the pathway, and it's a free service, and one we're taking a proactive approach to provide that guidance on. So alongside that, so that's the urban design panel. Another aspect of that urban design framework is the I guess the urban design guidance. So we have the residential outcomes framework, which focuses on residential, particularly around that medium density residential, and we're likely to see also development of guidelines for commercial centres. And we're also talking about, you know, some other areas where there might be specific issues or matters we want to cover. Recently raised by the Urban Design Panel, for example, was, you know, in the future looking at Cameron Road corridor and potentially having specific guidelines along there. And overall, we're also supporting, you know, I guess the panel moving through that and the awareness of the guidance and so forth through, I guess, proactive comms, promotions and engagement with our developer community and representatives. Just on the next slide, thanks. So I guess looking at the provisions themselves, it's important to retain objectives and supporting policies to provide a statutory framework for urban design matters to be given sufficient assessment and weighting. The urban design assessment for 4 or more independent dwelling units will assist in maintaining a level of consistency, both for developers, so they know what to expect, and also for our council staff reviewing development applications. The process of urban design assessment will be supported by the design panel, as well as internal urban designer. Last slide. So just honing in on a few particular standards. So the 4 metre outlook space has been discussed. You know, my opinion is it is really important to retain that daylight access, privacy, noise mitigation, and overall well-being of residents and neighbours. There is some very good analysis that's been done by Christchurch City Council, for example, that does look at the comparisons of a 2 metre separation versus a 8 metre versus a 16 metre and so forth. And it's very telling in terms of that proximity. You know, you can imagine even within this context, you know, being next to the person next to you versus this sort of distance and the type of privacy and the outcome that can, or better outcome that can enable. In terms of smaller outdoor living areas, certainly through my experience, I've seen both good and not such good examples of communal space. So really do see the need to set a baseline standard there. And if applicants are looking at shared space, then it's appropriate that that be considered on a case-by-case basis. In relation to height in relation to boundary, I agree that the TCC proposed approach is appropriate, as well as taking into account, I guess, dominance and so forth. The front setback also provides for a human scale, which starts to respond to some of those broader, I guess, submissions that relate to character and so forth. So the height in relation to boundary approach, you know, both protects or seeks to retain good amenity between neighbours, good amenity in relation to street, and it also acknowledges that, as we've discussed today, you know, change in some of these areas will take time. and providing appropriate setbacks in relation to existing development is appropriate. Last but not least, streetscape and fencing. I mean, I remember talking with some police in terms of engagement on SIPTED, and quite simply, eyes on the street will make the street safer, but equally, eyes on people's houses keep the people off the property and the burglars away. So, it's quite a simple measure of crime reduction there by keeping those fences lower. Happy to take any questions.
Yeah, I've got a couple. In terms of the residential outcome guide and the other guides that you mentioned that were being prepared or will be prepared, and clearly they're outside of the plan. What process are they going through to give them some status, though, as another matter to consider in, with a resource consent, consideration of a resource consent? Because, for instance, in Auckland, where you've got the Auckland Design Manual, which is, a huge amount of work, but actually has very little status because it's been through no LGA process and just has internal sign-off within the council. So what sort of process are you going through to make sure that these things have some weight?
So this is where the policy team and the team working on the guidelines work closely together. So in the instance of this current framework that you're looking at for residential, the teams have worked quite hard to make sure that the matters of discretion link up well with those matters of design guidance that are outlined in the residential outcomes framework, for example, so that there is that ability to provide a line of sight back to the matters of discretion. Looking forward to other guidelines, for example, if we're looking at commercial areas, and that's part of the subsequent work program of plan changes, we would look to take the same approach where those would be documents, or the policy and the guidance would be developed in parallel and working closely together to make sure that it enables that line of sight and that there's consistency between the two documents.
I mean, I accept that, and I accept that's good practice to do that, and that's a sensible thing to do. But it's actually also about the process you go through in terms of consultation with the public and giving it some status like that. Because otherwise, they may talk really well together, but actually, as another matter in a resource consent decision, someone could just push it to one side.
So the residential outcomes framework has been notified with the community. So it was notified through Plan Change 26. And then it was again highlighted that it was still in draft through Plan Change 33. And we did receive some submissions on the content that was from developers rather than residents. So it has been a very public document where feedback has been sought. And we and Ms. Luca might want to add to this, but we kind of see it as a living document that we will continue to improve and reflect as we use that outcomes framework to support residential development across the city. So that's where making it non-statutory gives us ability to easily update it and improve on it as things change over time.
I mean, all I'm just trying to do is head off the situation that you might find yourself in a resource consent hearing with a lawyer saying, this has no weight. And it was just really making sure that I appreciate the significance of it and the importance of it, but just to sort of highlight that issue more than anything.
Yeah, and it's something that we are aware of. And while Mr. Luca has alluded to spending a lot of time on the provisions, the assessment criteria, and in the information requirements through that urban design assessment. And that's really where we see the teeth are, or the ability to really consider those important urban design aspects. And that guide, the residential outcomes framework, is really that guidance document of what are some ways in which you can achieve those outcomes that we're seeking through that assessment criteria.
And then sort of links to that a bit, Ms. Peters, you mentioned that some changes have been suggested to make the urban design assessment for MDRZ less onerous, and I just wondered what that meant in practice.
Yeah, so we had a joint witness statement for both the medium density zone and the high density zone. And we looked at the number, I guess, the extensive list of matters of discretion that were urban design related at notification. And we worked through a process of actually consolidating what is the key issue. So the issues or the principles remain. It's just we've kind of consolidated them so the interpretation is clearer for people. And they should be able to step through and understand the intention of those matters of discretion a lot better.
Thank you, that's helpful. And just in terms of the use of the urban design panel, again, which is sort of beyond the plan change as such, but in terms of the threshold of who goes to the urban design panel, is it anything that requires consent, i.e. more than 4 or more? Is it open to all those people?
It's totally open, and we're to be encouraging, particularly at this point, in the early days, to get as many applications or upcoming applications through that process.
Thank you.
One question relating to the 4 metre outlook space. Can you just explain to me how that works in conjunction with the side boundary setbacks? In terms of side boundary setback, I understand it's 1 metre is the minimum.
Revert.
Yeah, I can talk to that a little bit. So we've got the side boundary setback, which is controlling your building bulk, and then you've got a separate standard, which is controlling your outlook space. So from a primary window of a living area, so they work kind of in conjunction with each other. So in some areas you could have, say, the building up to the setback, if it's not that primary living area, but in other situations, if you're that primary living area, you may have to be set back at 4 metres to meet that the outlook standard.
So I'm just sort of thinking along the lines of having these outlook spaces being on the sunny side of the property, for a simple way of describing it. So in those senses, you could end up having the actual side boundary could be 4 metres or thereabouts.
Yes, depending on how that dwelling was designed. And I just note that in terms of the MDRS, because we can't be less enabling than the MDRS, we can't introduce or we shouldn't introduce controls around, say, the location of those outlook spaces in terms of sun orientation and those sorts of things. If people wish to do that, that is a good outcome, but we cannot require it.
No, I understand. Okay, thank you.
Just pick up the urban design panel thing again. Have you given any thought to requiring or incentivizing through the plan the use of such a panel? And there's an allied question too, in terms of, I don't see in here except by implication, a requirement for an urban design assessment as such, I don't think. Whereas the plan specifically involves requirements for qualified landscape and so on. You're thinking about that? It's just not something that you particularly want to do, or you just haven't gone there? Maybe you're the wrong person to ask, because there might be a bit of self-interest in this.
Mr. Speedy might jump in a moment, but no, look, at this time, we're definitely working on a carrot rather than a stick approach. We are providing, I guess, a free service and encouraging people to come through. The panel works best when it's utilised prior to the application being submitted. So it gives that ability to provide feedback and so forth.
I'm well aware of it. Yeah. I've had lots of issues where have come before me. And just to elaborate on one question that you asked from Commissioner Knott there. I've had situations where, in actual fact, I haven't actually been able to give much weight to those things because the panel's not before me, and I have some questions which I wanted to ask but couldn't ask. So there is an issue for decision makers when you use a voluntary process like that.
Yes, and even within the period that the panel's been running, we've had different experiences, and certainly those using it would argue they've had different experiences. Certainly, as I say, the incentive is that the service is there, or to be provided, that we would hope that by going through it, it will streamline that process. If people choose not to use it, or potentially don't receive a favourable review, they are still able to apply for consent and submit their own urban design assessment and seek a review through that process. So through the process, either the council's urban designer or an independent urban designer would be called in to make that assessment. I guess what we've found to date is that where that has happened, both the panel and the independent assessment have come to the same conclusion. But I understand, I guess, some of the challenges that do sit alongside this process that we will continue to need to iron out.
Okay, up next we have the commercial provisions and the city centre provisions. So Ms. Carolyn Ratt will be joining us.
Just wondering if the panel wish to have afternoon break now.
We'll just do some desk shuffle. Did you have a preference about which one we do first? Okay, noted. Good afternoon, Commissioners. My name is Carolyn Ratt, and my role has been to support Tauranga City Council in terms of the commercial zone and the city centre zone. I was not the author of the commercial zone provisions, but I did pick that up and respond to the submissions through Section 42A and obviously rebuttal as well. In terms of the city centre zone, I did draft those provisions, took that through Section 42 and rebuttal also. If I will start with the commercial zone, I'll take first paragraph as read and move to paragraph 2.1 of the opening statement. So really the purpose of this is to provide an overview of the provisions relating to the commercial zone, and that's chapter 17A, commercial zone, as well as 17C, which is commercial zones and development. So the commercial zone is, as you've heard today, numerous times, it's located in various parts of the city, including on the edge of the city centre zone, as well as applying to all of the commercial centres. So moving on to paragraph 2.2, my opening statement will focus on providing an overview of proposed Plan Change 33 as it relates to the commercial zone, and more specifically just setting out an overview of the operative commercial zone provisions. And I don't want to labour that, but I think it is quite important to understand where we've come from as to where we're going. A summary of the amendments notified,
key issues that are raised in submissions and evidence, as well as outstanding areas of contention as I see them. Moving to paragraph 3.1, in order to better understand Plan Change 33 changes, as I've said, I'll set those what's in the operative zone and just in summary. So the purpose of the commercial zone is to provide for the development of a broad spectrum of uses in consolidated locations, and it is intended to be a true mixed use zone. The commercial zone provisions were embedded in Chapter 17, Commercial Zones, which contained everything relating to the commercial zone, the city centre zone, and set the broad policy direction for commercial activities. So Chapter 17 also contains provisions specific to Tauranga Commercial Zone, the Wairaki Town Centre Zone, the Wairaki Neighbourhood Centre Zone, and various commercial plan areas. So those commercial plan areas are specific locations where they've got different or additional standards such as Bethlehem, Bayfair, Gravett Road, etc. So in terms of what the commercial zone did, it enabled a wide range of uses as permitted activity, with the exception of residential activities within the 17th Avenue commercial plan area, which was a controlled activity. Tauranga Commercial Zone was similarly permissive, except for residential activities, homestay and visitor accommodation, which were all non-complying activities. The two commercial Wairaki zones were more restrictive, with all activities being permitted activity, provided that the proposed development had been designed and constructed in accordance with a comprehensive development consent that was granted, and anything outside of that was a restricted discretionary activity. So the standards that applied to the permitted activities included maximum height, pedestrian environment, streetscape, which controlled the interface between the building and public space. Boundaries of the commercial zone were sensitive zones, residential and visitor accommodation density, and residential activities on the ground floor. So there wasn't a huge number of standards, to be honest. But there were additional standards which applied to those areas that I've outlined in paragraph 3.5. I won't labour 4.1, I'm sure it's embedded on your brain and you never want to see it again after this process. But basically the upshot of it is that the key policy here is, in terms of the MPSUD, is 3D. Moving to paragraph 4.2, although I've recommended modifications in response to submissions, the spatial extent of the commercial zone has not changed, and the focus of Plan Change 33, as you've heard, was the provisions. So turning to what the changes were that were in Plan Change 33, firstly, the provisions for the commercial zone remained as Chapter 17A. So if we took Chapter 17 and blew it into 3, that's basically what happened. So instead of having everything commercial in one zone, it's now split across 3 different chapters. You've got A, which is the commercial zones, and some of those site-specific zones as well that are commercial, and then Chapter 17B is your city centre zone, and then your Chapter 17C is the ones that are more general, like they're about more generally commercial activities, which are not necessarily in a commercial zone. They could actually be in another zone. So the most significant change for the commercial zone in Plan Change 33 was the proposed change in activity status of residential activities from permitted to restricted discretionary. And because of the definition of residential activities, this applied to both the physical structure as well as the land use activity. And the reason for this was to ensure that residential activities are located above the ground floor level, provide quality on-site amenity for occupants, and manage the interface with surrounding non-residential activities. So this increase in activity status was considered to be necessary to support the removal of density limits and provide a pathway to ensuring that the design positively contributed to well-functioning urban environments. And kind of in that respect, it was to mirror what was happening for the higher densities in the residential zones, to mirror that approach. And to support quality residential development, Plan Change 33 proposed inserting a new objective and a number of new policies focused on residential activities. So that was new. Residential activities really got a spotlight as part of Plan Change 33 in terms of that commercial zone. As a consequence of the more stringent activity status for residential activities and the fact that it would go through a resource consent process, there were further changes, and these won't come as any surprise to you. It's things like deletion of the density standards, deletion of the standards controlling residential on the ground floor, because all of a sudden when you go through consent, you don't need these standards because they're matters that you can look at through that design that Mr. Luke was talking about and through that resource consent process. Additions of standards applying to residential activities, so they very much mirrored the MDRS standards. Addition of a non-notification rule, because again, suddenly you're going through a consent, but there's no need for it to be notified. Addition of matters of discretion, again, if you're going through a consent, suddenly you need matters of discretion. And addition of a rule saying if you don't meet those standards, where does that cascade to in terms of activity status? And as Ms. Peters has pointed out earlier, in response to policy 3D, the heights were increased in many locations of the commercial zone from 12 metres, where residential intensifications proposed through the high density residential zone, and the height for each area is set out in the new Appendix 14Q. So the provisions for the Tauranga commercial zone, the two Wairakei zones, and the commercial plan areas were largely unchanged. And I've really set out at paragraph 4.8 what the genesis or what the reason for chapter 17C is, so I won't repeat that. So going down to paragraph 5.1, there were 89 primary submission points received on chapters 17A and 7 on 17C. And I've summarised below what I see really is the key issues. And these ones really I've focused on where I've had a response to them, where I've recommended a change, and then further down I've got the ones where I think they're still matters of contention. So paragraph 5.2, the most common concern, and this is no real surprise, raised in submissions was the activity status for residential activities, and a number of submissions opposed that more stringent activity status from permitted through to restricted discretionary. So in my opinion, there was sound planning and urban design reasons for doing that. However, the Waikanae decision kind of put kibosh on that. Basically, it's because Plan Change 33 imposed a more restrictive regime than the operative city plan, and therefore the Waikanae decision means that retaining what was notified is not an option open to council, in my opinion. So in light of the Waikanae decision and to give effect to policy 3D, I've recommended that the activity status for residential activity reverts back to permitted as it is in the operative city plan. And again, not surprisingly, the evidence filed on behalf of the submitters supports that recommendation. That does necessitate a number of consequential amendments, and this is where it gets a little bit messy because you're kind of winding back the clock a little bit. So I recommended things such as reintroducing the residential activities, so that's the density standard. I recommended changes to the introduction to explain what's happening with residential activities. So taking those standards that had been applied to residential as a restricted discretionary activity, bring them back into permitted in terms of the location in the chapter. Amending the provisions so that non-compliance with those standards became a restricted discretionary activity, adding new methods of discretion, things like relocating information requirements, and also refining the matters of discretion so that they relate rather than, because as it went through, if it was going to go through a restricted discretionary process, you know, we could have some really great matters of discretion around urban design, but as a permitted activity, I had to tie in the matters of discretion more tightly with the effect of non-compliance with those standards. So they went through a refining process. And obviously there's a number of rule references that needed to change as well.
Good. Right. Just a question in terms of, so is the activity was permitted in the operative plan. Are there now more controls on that permitted activity than there were in the, or there are in the operative plan now?
Yes, there are. So that's where those additional standards for the MDRS have come in.
Okay. And you're quite satisfied that that doesn't breach Waikanae?
I don't believe so, because I don't think it makes it more restrictive.
That's obviously one of the matters that we're going to have to run the rule across the entire plan once we decide what we what we think Waikanae means. So thank you.
So going to paragraph 5.5, just set out some of the changes that I've recommended to policies, and they're not extensive. The first one there is to the policy which is around movement networks, and that's to focus on people rather than all transport modes. And that was, and then I've recommended further amendments in response to Ms. Tate's evidence to avoid the perception that public can access through private developments. Made a change to the policy 17A742, which is around residential amenity, to refer to good quality rather than high quality. And that is to match what Ms. Peters has done with the equivalent policy in the residential chapters. I've also had a look at Ms. Tate's evidence, and I think she's got a good point about the compatibility with adjacent land uses, because of course as a commercial zone it's intending to create a wide range or enable a wide range of uses. Not all of them are going to be compatible, and our hands are a little tied as to how much we can achieve. Policy 17A744, which is around site and context, that's evolved out of expert conferencing, and also change to 17A745, which is housing design. That's really to avoid repeating the relevant objective, because as it notified, there was a lot of duplication, if you like, between one of the objectives and that particular policy. So going to paragraph 5.6, when I was drafting the Section 42 report, I noticed an overlap between two provisions which manage residential activities on the ground floor, and recommended deleting two clauses out of Rule 17A11(2). Mr. Batchelor, in his evidence on behalf of Blue Haven, addressed this issue and expressed concern that deletion of these clauses will result in domination of the streetscape with parking at ground level, and I agree. And he very helpfully provided an example too. While I was focused on the overlap with the management of residential activities on the ground floor, I overlooked the management of parking, because of course I had in my mind that we cannot have rules in the district plan about requiring parking, but I forgot that some developers may actually choose to do that. And I think without this standard, there is the risk of car parking dominating the frontage of the site and the public interface. And for that reason, I've recommended reinstating clauses, but keeping them focused on car parking activities at ground level to avoid that duplication of trying to manage residential on the ground floor with two different standards. Mr. Batchelor and Ms. Tate both seek refinement of that of 17A1161 residential activities in the commercial zone, and I mostly agree with their points. Retirement villages, this has already been canvassed by Ms. Steer, but in essence, the only changes recommended that are specific to retirement villages are to the outdoor living area standards, and that's in response to the evidence of Ms. Williams. So turning to building heights at paragraph 5.9, plan change 33 proposed increasing the maximum height in certain areas while retaining the current height in others. So the Tauranga commercial zone was one of the zones where the maximum height was proposed to remain at 16 metres. So the submission from Tauranga Crossing and the evidence from Mr. Arbuthnot seeks increased height to 21 metres. And although Mr. Heath didn't really talk about it too much today, Mr. Heath did provide expert economic evidence on behalf of council. And he recommended allowing increased height at Tauranga Crossing on the basis that the local community is projected to increase its population base significantly over the next 20 years, and growth of Tauranga Crossing is important to sustaining the growing retail provision. So I have no reason to depart from Mr. Heath's assessment, and I consider it will give effect to policy 3D of the MPSUD. The gross floor area is another issue, but you'll see that further down where I cover that as a matter still in contention. In her evidence on behalf of Kāinga Ora, Ms Tate seeks an increase in the maximum height of commercial zones, and I know this has been canvassed earlier today, to 24.5 metres. And the reason that she provides for this is to ensure centres have a competitive advantage and to support good urban form. So notwithstanding the fact that this issue was not raised in the primary submission of Kāinga Ora, Ms Tate's evidence does not include any technical evidence to support the increase in height. And I just note there that Council did undertake extensive architectural modelling to support the notified heights, but the evidence has not provided any equivalent testing for that increased height. So without that evidence, I feel unable to recommend amendments at the moment. And we just did get a couple of other submissions seeking additional height that I've set out in paragraph 5.11, but we haven't received evidence on that. The minimum floor area, this is an interesting one because Ms Peters recommend deleting the standards for the internal floor area of an independent unit from the residential zones, and that was in response to a submission from Kāinga Ora. So for consistency, I recommended the same, notwithstanding that their original submission didn't seek to delete it for the commercial zone, it just sought to reduce the metres squared. However, in the evidence for Kāinga Ora, Ms Tate does not support deleting the minimum unit size from the commercial zone, and she considers that for more than 4 residential units in the high density res zone requires a resource consent, whereas a different framework applies in the commercial zone. So in her view, she thinks that it makes the standard appropriate. The awkwardness is that given that I recommended that standard requiring a minimum floor level, floor area for residential units be deleted in response to the Kāinga Ora submission, I'm comfortable reinstating it as sought by Ms Tate. Turning to paragraph 5.13, we haven't received any evidence on this, but I noticed that Classic Group are intending to appear. They sought to delete the rule applying to 17th Avenue commercial plan area. I've recommended rejecting this submission as the background for this, the backstory if you like, is that it's a very complex rule that does all sorts of things for different uses and different heights and different gross floor areas, but that came out of an appeal process. And I feel that the future of that site's more appropriately addressed as part of a commercial land strategy on this matter. Matters of discretion. Blue Haven seeks to simplify the matters of discretion with residential activities. And as I've outlined already, they required substantial amendments as a result of bringing that back to a permitted activity. I've recommended further amendments to really focus those. So moving to section 6, that's the outstanding areas of contention as I see them. And I've alluded to this earlier about the Tauranga crossing and their wish to delete the gross floor area. Originally, their submission sought to delete it in its entirety. However, that position's been modified through the evidence of Mr. Arbuthnot and Mr. Akehurst, and their suggested approach would allow an increase of up to 1,000 square metres as a permitted activity, and greater than 1,000 square metres would be restricted discretionary activity. Mr. Arbuthnot felt that the restricted discretionary activity would just have a single matter of discretion focused on effects on the transport network. And as you'll see in my rebuttal evidence, I've looked at a range of different approaches that we could consider. But in essence, I recommend retaining that maximum gross floor area, but making the activity status for gross floor area above that to a restricted discretionary, because at the moment it is discretionary. And I feel that it's fair if it was to increase in size, we kind of do know what the matters of, what the effects will be, and therefore can tailor the matters of discretion. However, I don't think that just one is going to cut it. And I'm also mindful that Mr. Heath considers it's important, and he alluded to this this morning, about the city centre retaining that focus. And so I've therefore recommended including a matter of discretion around the role and function of the city centre and effect of basically increasing the gross floor area of Tauranga crossing, as well as some other matters of discretion, which I consider relate to the effect of any increase in gross floor area. Reverse sensitivity, I haven't been able to do a heck of a lot with. So a number of submitters, such as Mr. Tuck and the fuel companies, seek amendments to minimise reverse sensitivity. And I agree with the point made in Ms. Tate's evidence that by its very nature, the commercial zone will result in a wide variety of land uses, and not all of them are going to be compatible. And so that was really one of the big advantages of residential activities going through a restricted discretionary consent, because you make sure the compatibility of land uses, or if there's extra reverse sensitivity or extra insulation or things like that. As a permitted activity, we don't have that same ability. So what I've done really is consider that the potential for reverse sensitivity effects can be addressed through that policy. And also as a matter of discretion, where that's for residential activities, and also noise limits and lighting standards that are already contained in Chapter 4. There are reverse sensitivity standards in the commercial zone, but these only apply where the activity is adjacent to a residential zone or another sensitive zone. It happens, that occurs at the zone interface rather than within the commercial zone. Ms. Williams, on behalf of the retirement villages, seeks amendments to that policy that I've outlined there, which is around safety and security, to encourage residential activities to provide for passive surveillance rather than ensure. And she sought similar amendments to that policy around residential amenity as well. But I consider that the use of the word encourage weakens the policy, and therefore do not support such a change. And the other change that she sought around the deletion of the amenity, that was the whole purpose of the policy, is to address amenities. So I think without the word amenity in the policy, you've kind of lost the purpose of it. In terms of residential standards, at paragraph 6.7, the evidence from Ms. Tate seeks to reduce the outdoor living areas and delete the space requirement for an outlook space from a principal living room, but I do not agree. The standards provide the minimum requirement, as I see it, and I think they're, to my mind, they're important for amenity as well as the health of occupants. So I think the increased density that is enabled in the commercial zone, especially with that greater height, makes the size of the outlook space even more important than in residential zones. And Mr. Tuck alternatively sought a tiered outdoor living area that increased depending on the size of the residential unit, but I recommend rejecting that so that there's consistency across the commercial zone with what the residential zone is doing. Density control was also an issue raised. Ms. Tate supported reverting the activity status for residential to be permitted, but she didn't support the reintroduction of the density standards. So just as a recap, that's an existing rule in the operative city plan, and that limits an independent dwelling unit to 1 per 50 square metres of gross site area. I think it's important to retain, if we're going to be permitted for residential, then I think it's important to keep that in to make sure that we actually do get true mix of uses rather than being dominated by residential. Matters of discretion, both Ms. Tate and Mr. Batchelor address the matters of discretion in Rule 17A 1424, which is around residential activities on the ground floor. So these matters of discretion apply, as I've said, when residential is proposed for the ground floor. Mr. Batchelor expresses concern with Clause B, which relates to the economic effect of loss of business floor space, but Ms. Tate had more wide-ranging concerns about those. As I've said here, the purpose of the commercial zone is for mixed use, but there is a risk that the zone is dominated by residential development. And to my mind, that Clause B addresses the effect, even though the wording could be changed, but that was the intent. Turning to diagram 15, and some of the discussions today have caused me to think about this. So diagram 15 is a commercial centre network, and that was deleted by Plan Change 33, as well as references to the diagram in the policy. So Mr. Batchelor opposes the deletion of it as he considers it to be useful. And I've said, while there is undoubtedly value in having a commercial hierarchy included in the city plan, I consider this is most appropriately developed through the upcoming commercial hierarchy strategy work, rather than this IPI process. And the reason I say that is because if we did, so the thing is that through this process, we've looked at the hierarchy of the centres only insofar as they inform two things: what we do for the height of those of the commercial centres, but what we do in terms of the residential surrounding them. And at the moment, with the city plan the way it is, that commercial zone does so many things. Like, we don't have, we've just got a very flat structure. We don't have that depth of using different zones, neighbourhood zones, town centre zones, city centre zones, that are in the national planning standards. So I think, to my mind, this is not the right time to do it. I think there is value in it, but I think because there's so little difference in the actual rules that apply to those very different commercial centres, I don't see that this is the right time to do it. And in conclusion, thank you for the opportunity to provide an overview. I think it's going to be really interesting to see what comes out of the evidence from submitters.
The next one then, shall we? Yeah.
Sure. Okay, moving on to city centre zone. So I've replicated some of the diagrams in the PowerPoint. They're exactly the same, but I just thought you might appreciate it being a little bit bigger. So the purpose really of the opening statement, same as before, is to go through the city centre zone provisions. So the diagram that you see up there, that just shows the extent of the city centre zone, and I know you're probably all aware of this already. That's the dark pink. The lighter pink is the commercial zone, especially down that southwestern edge. Now, what's interesting too is on the right there, I've got the spatial extent of the city. It's called the city centre waterfront zone. The interesting thing about that from a very geeky planning perspective is it doesn't actually function as a zone. It's more, even though it's called a zone, it's actually an overlay. And it did some interesting things in the operative city plan, which I will get to. So if I go down to paragraph 3.2, so as you've heard again today, it's refreshing to hear everybody restating this, but the city centre zone is a principal retail, commercial, civic, entertainment and cultural centre of the city and the Western Bay of Plenty sub-region. I think it is quite important to recognise that it's not just important to Tauranga, it's got a much wider catchment. So the city centre zones provisions, as before, were embedded in Chapter 17. So going down to paragraph 3.3, so a wide range of land uses similar to the commercial zone were permitted in the city centre zone in the operative city plan, with the exception of residential activities, homestay and visitor accommodation. And this is where that waterfront zone kicks in, because the residential, anything residential basically were non-complying in that area. With the exception of visitor accommodation was a discretionary activity in subzone B. So the reasons for that were primarily reverse sensitivity from the railway line and the commercial operations on the harbour edge, and the open space purpose of the land between the Strand and the harbour, despite it actually being a city centre zone, which is quite interesting. So the land down there that's used for public open space actually has an underlying city centre zone. So the standards that applied to the permitted activities included maximum height, very similar to commercial zones, a lot of similarities here. Pedestrian, environment, streets and streetscape. Residential activities on the ground floor. This one is different. Sunlight admission to public spaces. And also E, which is buildings, activities and structures in the city centre waterfront zip zone. So really the key policy for this one in terms of the NPSUD is 3A. Going down to paragraph 4.2, similar to commercial zone, the spatial extent of the city centre zone has not changed. The focus was really the provisions. So same as the commercial zone, those provisions were extracted out of chapter 17 and made their own chapter, which is 17B. Many of their objectives and policies were unchanged, but with some refinement where the subject matter was already covered by another more specific objective or policy. So in terms of the activity table, because I think this is really key, there were 3 key changes. So the first one is separation of the built form from the land use activity. And the reason for this has been alluded to by Mr. Luca. The design of the city centre is critically important to the council and to the community. And so by separating out the built form, there was less concern over what the activity was, more about the physical structures that it was housed in. So that was why that approach was taken. So the physical structure of the building became a restricted discretionary activity, and the activity status for residential activities, visitor accommodation and homestay was amended to be permitted across the whole zone. So I've set out the reasons why in paragraph 4.5, but I guess central to that, and again, this was touched on by Mr. Luca, was the ability to effectively engage Council's urban design panel, and really to do that requires a resource consent process. So going to paragraph 4.6, turning to the management of height, the maximum height in the city centre zone is established through a combination of a map contained in Appendix 7A, as well as a rule. So basically, the map sets out almost these little areas where they've got different heights, and then the actual heights are established in the rule, which is in the chapter. But basically what it did, the maximum height in the operative city plan, the first one was the height on Trinity Wharf and Dive Crescent, and that was to maintain cultural views from Monmouth Redoubt. The height on the Strand is to preserve amenity and sunlight on the waterfront, which, as I've said, is a public space. Preserve sunlight access to key public spaces, and these are actually identified and described. And then you've got the airport's height, slope and surface, and you've got shading and dominance on the adjoining residential areas. So Plan Change 33, as notified, rationalised the number of areas, with former areas 1 to 4, which had 4 different height limits, being amalgamated into a single Area A. So that diagram, really the blue bits are the changes. So as what was in the operative city plan versus what was notified. So the blue areas are where that's become theoretically unlimited, although in reality the qualifying matters will actually limit it. And those qualifying matters are the airport's heights, slope and surface, and the view shafts to the mount. So I've just got there in paragraph 4.7, the purpose of that Area A and making it unlimited height is to give effect to NPSUD Policy 3A and its requirement to enable building heights and density of urban form to realise as much development capacity as possible. Area A is basically less sensitive than the eastern edge of the peninsula and can accommodate more development. Additional height in Area A will also enable views to the water, as the buildings can look over those closest to the harbour edge, where the height is more limited. So the height limits for areas B through to I have remained the same as the operative city plan. And that's for the same reasons as set out above in that paragraph 4.6, with the exception of that last one, shading and dominance on the adjoining residential areas, because that was the reason why the height was limited in that sort of southern portion. But the the environment, if you like, has changed obviously with the higher commercial zone and also the high density res. So a number of additional standards were introduced, many of which were derived from the MDRS. So there's those match. So going down to section 5, key issues raised in submissions and evidence. There were 47 primary submission points, not many really, which is quite surprising because I would have thought that the city centre, being the focal point would have attracted a little bit more attention, but it didn't. The most common concern raised in submissions was, not surprisingly, again, the activity status for building structures, and those submissions felt that it should be permitted. And for the Waikanae reasons, again, I'm recommending that we revert back to permitted as it was in the operative city plan. And again, not surprisingly, the evidence filed supported that position. But similar to the commercial zone, this amendment does necessitate a number of consequential amendments, not so many, you'll be pleased to note. Basically, they're set out in 5.5, but they include moving the residential standards from applying to restricted discretionary activities to permitted, deleting the more general design matters of discretion, because obviously as a permitted activity, they become a bit useless, and deleting the non-notification requirements. Again, if you were going to put the buildings for resource consent, then I felt that it didn't need to go through a notification process, but obviously that environment has now changed. Paragraph 5.6, similar for retirement villages, there's nothing unusual or different from the commercial zones in that respect. Going down to paragraph 5.7, objectives 17B2 and B02, and 03, they relate to bulk and scale of buildings and site layout and building design respectively. But as you can see, even from the headings, there's an awful lot of overlap between those objectives. So in response to the submission from Kāinga Ora, I recommend rationalising that into a single, more focused, more crunchy objective. In terms of historic heritage, we received a submission from Heritage New Zealand, and I've recommended an additional clause to the policy 17B P7 to ensure compatibility with the scale and values of built historic heritage. And given that the height of buildings in close proximity to a scheduled historic heritage building is recommended to be included as a QM, I consider it's appropriate that this is recognised. In terms of access, a number of submitters seek amendments to policy in regards to access, such as Fire and Emergency New Zealand, Waka Kotahi, Kāinga Ora, and the retirement villages. And so I've recommended a couple of amendments there. One, to enable improved multimodal accessibility, and secondly, to enable access for emergency vehicles and to enable quality cycling infrastructure and facilities. But I've not recommended accepting all the submissions received on this matter, and recommended rejecting one part of the one from Waka Kotahi, because that sought quality public transport infrastructure and networks. But the thing is that this is applicable to the city centre zone, and the public transport infrastructure doesn't sit in the city centre zone, it sits in the road zone. So such a change would be ineffective. Minimum floor area, same issue as the commercial zone. Turning to flood hazards in the waterfront precinct, we received a submission from Mr. Tuck, I believe. And at the moment, there's quite a complex standard that just applies to that city centre waterfront precinct. around buildings and structures must be designed so they'll not be damaged by or impede floodwaters and inundation. So I can see some problems with that standard, the measurability of it, and whether it's black and white. It seems to me that it's shades of grey. But in any event, it's been overtaken by Plan Change 27 and the standards are no longer relevant. In any event, the council owns that land anyway in the city centre waterfront precinct, so it's pretty low risk. Turning to matters of discretion, I've recommended amendments to the remaining matters of discretion to make them consistent with Ms Peters, which she's been recommending in the residential zones, and also to make them more focused on the effect of non-compliance with the standard. And I have accepted or recommended accepting, the inclusion of positive effects in response to Ms Williams' evidence as a matter of discretion for overhyped buildings. I think it enables a more balanced consideration of the effects. So turning to the outstanding areas of contention, Area F. So evidence from Mr Whittle and Mr Collier on behalf of JWL Investment Trust oppose the height limit of 16 metres for Area F. So you can see that. So you can see it on the diagram here. So it's those 4 blocks that are shaded blue. So that's Area F. So there's been no change in terms of that height limit. So going to paragraph 6.3, in response to the submission from JWL, Council undertook modelling of the shading effect of 16 metres in height in their area, as well as 2 other height scenarios. Mr Collier, this is a little bit of a technicality, but Mr Collier considers that we haven't used the right QM assessment. He erroneously thought that we used criteria F, which relates to open space, but we did not. Because the thing is that it's used as open space, but it's actually not zoned as open space. And so the QM clause that we used was the other matters. So it's existing and it's another matter. He makes the point that 2 consents have been granted for the JWL site. So that's a JWL site. So that was the second one down in terms of those 4 blocks. And the site is at 62 Willow Street. And 2 consents have been granted for height greater than 16 metres. In terms of this, I noticed A, it's only actually a portion of that block, and B, that site's only an even smaller portion of Area F in its entirety. And I think that the 2 granted resource consents have proven that with a good design, overhyped buildings may be successfully consented. In addition, I noticed that those consents were granted as a discretionary activity, whereas non-compliance with the maximum height in Plan Change 33 would be a restricted discretionary activity. So in essence, it hasn't caused me to change my recommendation there. I'm going to recommend, recognition of QMs. Ms McKelly's evidence on behalf of Heritage New Zealand considers that the purpose section of Chapter 17B should acknowledge QMs. I accept that that is included in other chapters, but it's in a slightly different context. And I think the thing is that QMs don't need to be singled out. They apply throughout the plan. They have before. I just don't see any need to shine a spotlight on them. And they don't apply across the board either. They apply to different sites. So going to paragraph 6.8 and policy 17B-P3, Ms Tate sought amendments to focus on acoustic insulation. I'm aware there's other ways to minimise the potential for reverse sensitivity, such as orientating habitable rooms away from noise and light generating activities. And I just don't think there's any point in narrowing it to just acoustic insulation. In terms of Rule 17B641, that's a matter of discretion for height. Ms. Williams, and this is similar to what Ms. Steer was talking about earlier about that larger site issue. She wanted to include an extra matter of discretion, which the extent to which effects have been internalised on larger sites. I don't see there's any need. There's sufficient matters of discretion which already would cover that without, again, alluding to what is actually in a larger site. In terms of residential standards, and this is the same for the commercial zone, Kainga Ora sought to reduce the outdoor living areas, but I don't see the need to do that. And the submission for Fire and Emergency New Zealand sought inclusion of an advice note drawing attention to site layout requirements being further controlled by the building code, but I don't consider that to be necessary either. So that's where we're at with the city centre zone.
I think we've been bedeviled by the detail, I think. Yes, thank you.
That's the problem when you don't have many submissions to address. You can get lost in the detail.
Oh, well, you're not lost, we are. So don't worry about that. All right, well, thank you. Anything? Just looking around, or are we into site visit territory now, I think? Have we still got time? Yep, I think so. I think yeah, we're definitely up for that. Okay. And you'll send a schedule through tonight for us, will you? Because we don't have that. Oh, all right. Well, thank you for what you've done so far. Right. All right, everybody. Well, we're adjourned then until 11 o'clock tomorrow morning, and we'll be site visiting now and first thing in the morning. Yeah. So, thank you.
Apologies, just sorry, one matter that I forgot to mention. We have received a late submission, late legal submission, so I'll email that through to you tonight. They're appearing on Friday morning. That was the request from Miss Barry Bacino.
I was going to say, yes, I said that was okay.
Yes, and so we'll be uploading that as soon as possible to our website as well.
And for those of you who don't know what that was, she's appearing for a number of appearing pro bono for a number of parties, but she also had numbers of parties who had formally engaged her, and she was having trouble actually getting around to doing everything. So I granted her a few more days. Yeah.